the appellate side matters, we'll take up that.
So, Your Lordship directed the matter to be appeared, granted leave to appear 2 dates, if it is not in the list.
When the appellate side list is taken up, we'll check.
Lordship.
Number 1.
Yes, 1.
Item number 1, I am appearing, Lordship.
Yes. নোট করছিল কি কিছু? আচ্ছা আচ্ছা, হ্যাঁ, শুধু হিয়ারিং শুরু করছি, রাইট। Yes, please.
Yes. So before the single bench, our primary defense was that it is the family mark. Second defense was delay and third defense was that. Now kindly come to their case, plain case.
And also barred by delay or acquiescence, whatever. These are the 3.
Yes, these are the bench. Now kindly come to page number 35 of the stay application.
Of the stay application.
What was their case?
Yes.
The single bench.
Right. This is the petition.
This is the suit.
Oh, sorry, this is the
Suit. This is the injunction application.
Oh, this is injunction. Right. Yes.
Page number 35, Lordship. The petitioner number 1 is a registered partnership firm carrying on profession as solicitors and advocates, inter alia from its principal office at 12, Post Office Street, Kolkata 1, who has the jurisdiction of this honorable court. The petitioner number 1 was established.
Just remind us, please. This is against an order of injunction.
Injunction order.
Please continue.
The petitioner number 1 was established in or at the year 1896 with 2 partners, namely Fox and G.C. Mondal. G.C. Mondal is, Lordship, the great grandfather of the appellant.
All right.
Copies of a few bills of telephones installed at its office for the month of August 2022 and received dated 28 September 2022. Payment of lease rent office, etc., etc. Now kindly come to the paragraph number 2. The firm is inter alia engaged in providing legal arbitration, mediation, conciliation, and other dispute resolution services, consultancy, advisory, and legal information services. The petitioner number 1, since its incorporation or around the year 1896, has been using the trademark Fox and Mondal openly, continuously, uninterruptedly, and extensively to distinguish its service from those of others.
This is the case of passing off.
Passing off. The word Fox and Mondal also forms a part of the business name of the in view of the expertise and high quality of services rendered by
You
the
got
firm.
to read the entire thing and read the salient portions, because these are the usual.
Kindly come to paragraph number 4, Lordship.
Please.
After the John K. Fox, the partnership was reconstituted in the year 1992 with induction of other solicitors, and since then the firm has undergone several reconstitutions. This paragraph is important, Lordship. That's what I'm reading out.
Absolutely.
G.C. Mondal died on 28 November 1930. Sudhir Kumar Mondal, who was also a solicitor of great repute, after having qualified in the year 1904, also became a partner of the firm. Thereafter, in course of time, Dinobandhu Mondal and 1973, and then in 1984. 1984, the firm Fox Mondal was incorporated by the partners of the plaintiff.
Not incorporated, reconstituted.
Not reconstituted, established for expanding the business. The Fox and Mondal was only in Kolkata, so the partners of the firm decided to expand the business. So in Delhi, they opened their business in 1984. And one of those partners is at present also a partner of this firm.
So from Fox and Mondal, you constituted this
Fox Mondal
and company. Very good.
The petitioner number 3, Arun Kumar Mondal. Arun Kumar Mondal was also a plaintiff in the suit, but after his demise, it's substituted. And along with the pro forma respondent number 3, Ashok Kumar Dhar, amongst others, Ashok Kumar Dhar is presently a partner in the plaintiff firm. They opened a firm in Delhi in 1984. was a permissive user.
Foxmondale and Company, Delhi one.
Delhi one. Fox Mandal is Delhi one.
Fox and Mondal is based
Fox
here.
Mandal, Fox and Mandal is Kolkata based.
Yes. You can take your seats, both. Yes. No, not you. No, your reliever has not come. So you
His
continue.
Lordship, he's on the way.
You're very yes.
The profile respondent number 4, Debanjan Mondal, become a partner of the firm in 2004. Dinobandhu Mondal expired 30 June 2020, and the present partners of the firm are Arun Kumar Mondal, Ashok Kumar Dhar, and Debanjan Mondal. After the demise of the Dinobandhu Mondal, the father of the appellant, he was the sole decision maker in the firm. The dispute arose between the parties.
The firm means which firm? And company or
Between the brothers Fox and Mondal,
they were common partners in both.
Dinobandhu Mondal was the common partner in all of the firms, and others were permitted users. The appellant was managed Delhi and Mumbai.
There are no common partners between the two.
At present, there are no common partners. The petitioner number was set up by the firm through his partners. Introducing, I'm not reading out this.
So their case is that you are, as Foxmondale and Company, you are usurping their trademark, which they have been using for.
Not their trademark. The question is, they were
We are talking about their case.
yes.
Their case is that you are passing.
Yes, I'm
your
passing off their trademark and the goodwill, and they are also,
associated everything.
yes, and they are also restraining us from claiming that his great grandfather from the farm with J.K. Fox in 1896. Here
That
in
is a
Kolkata.
fact. They are also
Yes.
admitting that.
They-
Why can't you claim that?
They are restraining us, and the learned single judge has also restrained us from claiming that from 1896.
You would be arguing for that is beyond. Yes, you want to
Just
add
for
something.
clarification purposes, what the
Yes.
learned single judge has restrained my learned is they cannot claim associate from 1896,
Kind
being a distinct entity.
Association with Fox and Mondal.
Yes, yeah, association with the year establishment 1896, because the firm is a distinct entity.
Very. But you have admitted as a fact that they broke up and they formed this.
Lordship, two of the founding partners of the petitioner before this honorable court were actually the founding partners of the petitioner, but subsequently they left. The only common partner was Dinobandhu Mondal. Till his demise, he was the only common partner of both the firms, Your Lordship.
Yes, we can come to the prayers or something like that.
yes, Lordship. I'll go through the impugned order once.
No, let us
Your
first see
Lordship,
the
permit
prayer.
me to go
Let
through
us first see the prayers at page 74 once. In prayer, their prayers. Restraining from
Yes.
passing of their firm by you.
Prayer is an order of injunction.
So where is that other prayer that you cannot claim? They cannot claim and such and such. They. That's not the prayer.
No. So that's not in the
Then we can come to the order. Yes.
yes. Order, Lordship.
Acha, we will be following from memo. So you can please just refer to the internal pages of the order.
Page number, Lordship. Page number 2.
All right.
This is the order, impugned order.
Yes.
This is a suit inter alia for passing off. The petitioner number 1 is a registrarship firm engaged in providing similar services. The petitioner number 1 was incorporated in 1896 and has since been using the mark Fox and Mondal. The petitioner number 2 is a limited liability partnership. The words Fox and Mondal also from the business name of the firm. The petitioner number 2 enjoy immense goodwill both in the legal and business fraternity. Originally, the firm began as a partnership between Fox, an English attorney, and Gokul Chandra, an Indian attorney. There is evidence to demonstrate that the firm carrying on business since 1896. Due to passage of time, date of the partners reconstituted on several occasions. The firm is also the owner of the trademark Fox, which had been registered on 7th March 2000 in class 2, with the date of the mark recorded as since 1st January 1896. That is also the proprietor of a number of other registered marks. The respondent number 2 is ownership which was registered in the year 1984 by the partners of the petition number 1 have its principal place business at Delhi. 2003 one had also trademark to be registered in his name. Registration certificate in favor of the respondent number 1 records the user details of the respondent number 31st December 1986. Respondent number 1 is the eldest son of the late Dinobandhu Mondal, who was one of the common partners of the petitioner number 1 and the admittedly the respondent number 1 had never been a partner of the wife, have always associated with respondent number 2. Paragraph 7. The disputes between the parties in the filing of this suit have arisen after the date of Dinobandhu Mondal on 30 June 2022. The petitioner number 3 and the performer number 3 had on 2nd of 2001 resigned from the respondent number 2. Since the date of the late Dinobandhu Mondal, the petitioner number 1 and the respondent number 2 have had no partners at all. It is submitted that the respondent number 1 and 2 are seeking to pass off their business as that of the petitioner number 1 and claim to have a legacy of 125 years. Significantly, the respondent number 1 had only become a partner of the respondent number 2 in the year 1996. Farm was incorporated in the year of 1984 and the appellant became the partner of the farm in 1996. Since then, it was managed by the partners of plaintiff firm. In such circumstances, any representation that the respondent number 1 and 2 had been incorporated in the year 1896 aims to be India's oldest and largest law firm and thereby associated with the petitioner number 1 is false. Attempt to encash on the goodwill or reputation of the petitioner number 1.
Half a second. You say that it was incorporated in 94, understood, but the learned single judge holds that the registration certificate was issued in on 30 December 1986. So the registration was of the paragraph 5.
Paragraph 5.
Last sentence of paragraph starting at page 2 and ending at page 3. The registration of the respondent number 1 records the details of the respondent since 31st December 1986.
Yes.
So the registration was of 31st December 1986. Incorporated in 1986. Very good.
I am coming to paragraph number 9. There
Right.
The petitioners are also aggrieved with a number of publications in various newspapers and other online portals published on 15th October 2022, whereby the respondent number 1 and 2 have been described as being India's oldest since 1896. The petitioners contended that on a reading of the reconstituted partnership deed, the respondent number 1, as one of the legal heirs of the late Dinobandhu Mondal, is only entitled to a monetary claim respect of the goodwill of the petition number 1 in support of their contention. Reliance is placed on Bhagavan Das Khanna Jewellers. There are the judgments and in your lordship. Now, paragraph number 10. From here, our section starts. On behalf of the respondent number 1 and 2, it is contended that the petitioner number 1 does not have right of exclusive ownership in the marks Fox and Mondal, or FNM. The marks Fox and Mondal, or FNM are family marks and belong to the Mondal family, at least since the demise of Mr. J.K. Fox. The share of late Dinobandhu Mondal in the group of the petitioner number 1 firm has also devolved on the respondent number 1. The goodwill in the mark of the petitioner number 1 firm is just shared.
Please continue.
Is a shared or common goodwill, and the respondent number 1 contributed to the same. There has also been acquiescence by the petitioners, and they are now stopped from otherwise. In support of their contentions, the respondents rely on the judgments, lordship. These are the judgments which were relied upon the learned single page. The petition 1 was incorporated in the year 1850 and has since been continuously, uninterruptedly, and using the mark Fox and Mondal. The respondent number 1 has never been a partner of the petitioner number 1. The father of the respondent number 1, 30 June 2022, and on his date, he ceased to be a partner of the petitioner number 1. There are intersect between the sons of the late Dinobandhu Mondal parting to the estate. The youngest son, late Dinobandhu Mondal, who was the sole surviving partner in the petitioner number 1, has amicably resolved all disputes between himself and the petitioner number 1. Hereafter, the number 1 had been reconstituted on 30th March 2022. A suit filed by the petitioner number 1, being CS 178 of 2020, is also pending before this court in respect of the share of late Dinobandhu Mondal in the petitioner number 1 partnership business. It is also an incontrovertible fact that the petitioner number 1, the prior user and first in the mark, Fox and Mondal. This significance in an action for passing off, which is for protection of the right of the prior user, has created the goodwill in the market. The petitioner number 1 firm is the only source and origin of any goodwill. The marks Fox and Mondal and FNM. The case of registration of an associated mark in an action for passing off. Thereafter, in paragraph number 12, you should set out the Partnership Act. Now, paragraph number, I'm reading paragraph number 7, the clause 7 of the reconstituted partnership deed dated 7th October 2040 is set out below. The date determinant of a partner shall not dissolve the partnership, but the partnership shall be carried on by the surviving partners. The partnership accounts shall be made up after 2 years from the date of date determinant of a partner, but in 3 years from the said date. The share of the deceased or retiring partner in the outstanding bills up to the date of his date retirement lays the cost of realization assessed at 30% of the amount realized on these bills shall be paid to the retiring partner or the legal representative of the deceased partner or share of the profit and goodwill of the firm. The amount payable for the share of profit and goodwill of the deceased retiring partner to be calculated in the manner aforesaid shall be determined and paid in the manner decided by the Dinobandhu Mondal in his absolute discretion, and heirs of the deceased partner and of the retiring partner shall not be entitled to raise any question or objection thereto. In absence of Dinobandhu Mondal, Lordship, there is no one to decide of the firm, and he has died on 2020-22. Paragraph number 13. Any goodwill generated by a partnership is a partnership asset. All the partners have an interest in the assets of the partnership, but does not mean that they own the assets themselves. There is also no question of claiming any legacy in a partnership asset which exclusively belongs to the firm. The disputes in respect of the surviving estate of the late Dinobandhu Mondal, subject matter of a pending suit, being CS 178 of 2000 filed before this court. In prima facie, the only entitled of the respondent number 1 as heir of late Dinobandhu Mondal is in monetary compensation and nothing. This cannot by of any imagination entitle the respondent number 1 and 2 to any right over the use of the business or marks of the petitioner number, or to be permitted to represent the public of having any association or connection with the services being rendered by the petitioner number 1. The respondent number 1 is not entitled to use any mark belonging to the petitioner number 1, either as grandson of late Sudhir Kumar Mondal or as the son of late Dinobandhu Mondal. Any such third party right in favor of the respondent number 1 would amount to an entitlement which is neither justified or nor warranted. The petitioner's primary pertain to the impugned articles and publication describing the respondent number 1 to be associated with the petitioner number 1. In so the articles and publication describe the respondent number 1 to be synonymous with the petitioner number 1 firm. The conspiracy false and misleading. In suggestion that there exists any connection or association between the petitioner number 1 and the respondent number 1 and 2 is confusing. Misrepresentation lies in the heart of a passing of any confusion found to be damaging and have undesirable ramifications in diluting the goodwill of the petitioner number 1. The respondent number or 2 cannot claim to have a legacy of 125 years and thereby trade or encash on the goodwill and reputation of the petitioner number 1. The impugned articles and publication cannot be described as sheer coincidence. Undoubtedly, the impugned publications create an association of thoughts in the public mind between the respondent number 1 and 2 and the respondent number 1, and therein lies the confusion and misrepresentation this is crucial, is an action passing off. There is also no merit in the contention that the marks Fox and Mundell or FNM are family marks. This argument is unsubstantiated. Name of the petitioner number 1 expressly demonstrates that the petitioner or partners of the petitioner number 1 were not exclusively members of the Mondal family. The original partner of the firm, John K. Fox, was not a member of the Mondal family. In any event, there is no reason why the sons bearing the surname Mondal should only be entitled to any right in the alleged family mark. If this argument succeeds, then all the heirs of the Gokul Chandra Mondal would be entitled to a right in such marks. Actions of the respondent number 1 exclusively associated with the respondent number 2 not being a partner of the petitioner number 1 and causing an independent mark to be registered in his name also negates against the argument of family mark or shared reputation. There is also no right which the respondent number 2 can claim either common lineage or family mark or shared goodwill in respect of the marks belonging to the firm. Any prior association of the respondent number 1 with the petitioner number 1 firm cannot extend it to a right to use the marks of the business name of the petitioner number 1. Paragraph number 16, there is no quarrel with the proposition laid down in the cases cited by the respondents in Anderson and Lemke versus Anderson and Lemke, 1998 RPC 120. It was held that there was no misrepresentation. In Kushal Khemgasha, the concept and consequences of the dissolution have been laid down. It is true that the goodwill of a firm cannot be ignored upon the date of partner. However, in view of 17 of the partnership deed, the only entitlement of respondent number 1 is in monetary consideration. In any event, this issue is the subject matter of a pending suit. The facts of the Sriram Education Trust versus SRS and another are also distinguishable. In the same decision, the parties were claiming a right to a common family shared between the parties. The plaintiffs were also found not to be prior users of Sriram Professional Institution. Moreover, not only were other members of the family using the impunity, but third party also adopted the trademark educational institutions prior to the plaintiffs. In conclusions, the defendants inter alia are directed to show that they have no connection or relation with the school. Similarly, in the decision of HFC Bank PLC versus Midland Bank PLC, the plaintiff was unable to establish any goodwill. In Lancer Trademark, there was no likelihood of confusion between the two marks. The decisions in Rajni Dua versus Bhushan Kumar in August 1990, online 8620, and Krishna Sweets Limited versus M. Mura are also distinguishable and inappropriate. There is no dispute insofar as interpretation of family settlements or arrangements are concerned. However, in view of clause 17 and the legal rights of the parties, both the said decisions are inapplicable. There is also no substance in the defense of acquiescence. Prima facie, there is no petitioner inconsistent with the claim or in the marks of the petitioner number 1. In order for such defense, there must be a positive act of petitioners, not mere silence or inaction. MS Power. The decision in Habib Bank Limited versus Habib Bank AG Zurich is inapposite. In this case, it was found that both the entities had been set up by the same company and their staff were also freely interchanged. Upon the filing of the suit by an order dated 4th November 2022, it was directed there would be no further publications similar to those published in page 574, 592 of the petition. Thereafter, by a further order dated 15th November 2022, the respondent number 1 and 2 were directed to not use the marks Fox and Mondal or FNM till the final hearing of this application. The orders at the ad interim stage were assailed in an appeal by an order dated 16th December 2022. The Honorable Division Bench refused to of the ad interim orders. Thereafter, by an order dated 10th February 2023, the special leave petition filed against the order dated 16 December 2022 was also dismissed as withdrawn. Diverse orders have also been passed in an attempt to settle the disputes between the parties. However, both parties were unable to arrive at that also failed. Paragraph 19. For the above mentioned reasons, the petitioners have been able to demonstrate a strong prima facie case on merits. The balance of inconvenience and irreparable injury is also in favor of the protective orders being passed. Accordingly, the ad interim orders dated 4th November 2022 and 15 November 2022 stand confirmed. The respondent number 1 and 2, their men, servants, agents, and assigns, and other partners are restrained from holding themselves any manner whatsoever of being affiliated with the petitioner number 1 or the petitioner number 2 or claiming a legacy in the year of the establishment of the petitioner number 1, that is 1896, or pass their farm or their legal services as that of the petitioner number 1 or the petitioner number 2, and also from using the marks Fox and Mondal or FNM. Issues, including the question of restraint on the use of marks Fox Mondal and Co. or FM, or any other deceptively similar mark, and the question of disclaimer on either of the marks are left to be adjudicated upon at the time of trial.
You are Mr. Munshi.
Yes.
Mr. Munshi, please come to paragraph 18 at page 11, internal page order.
Number 11.
11. Paragraph 18, page 11.
Paragraph 18, page 11.
Last paragraph of page 11. Now, there further publications from page 574 to 592 have been referred to. Can you show us those?
Yes.
Please show us those first, and then we'll proceed.
Right.
Yes, absolutely. Please.
Right.
We'll just start. We have just finished the order.
I followed.
Yes.
Great.
Because that is a part of the injunction, so we have to.
Yes, your lordship wants to see those publications once.
Yes,
May I
exactly.
just show your lordship those publications?
Apparently, three types of injunction has been passed. Those two orders have been made absolute. One is using the marks.
Yes.
Second is publications,
Yes.
and third is general for holding yourself out in any
Grateful.
manner.
My lord, as far as, may I just digressing for a minute,
Yeah.
say that I am not using the marks Fox and Mondal or FNM. I have no difficulty with this injunction continuing because there is nothing has ever been shown that I have
Totally.
ever used these marks. I have no difficulty with this.
Right.
Now, my lord, I also have no difficulty with the injunction which restrains me from passing off my firm or my legal services as that of the petitioner number 1 or the petitioner number 2. This also.
Yes. So
Now-
now we are restricted to this only, that legacy part and
Yes,
publications.
grateful. My lord.
Publications, if you just show us. Please.
Yes, I'll show your lordship the publications once. Kindly have page. The newspaper publications are at pages 617 onwards, volume 5. And why is it not written over here? You set over there.
Number 2. Which number 2? 17.
My endeavor would be to show your lordship that these publications, in fact, make it very clear that I have nothing to do with the firm in Calcutta, and I claim to be a distinct entity. And in fact, there has been a breakup. Kindly have, my lord. Page actually starts at, to be fair, starts at 610. Why is it not written here? Why is it? I asked you whether it's been annexed or not. So, why is it not written? So you will. So 0.
Yes. With the legacy with you.
Yes. India's oldest. This is a newspaper article. This is
Your publication.
it's not my newspaper article. A. B. Legacy remaining with me, not remaining with me.
All right.
This is a puff. And kindly, we do not read just the headline. Kindly permit me to read further. India's oldest law firm split. Now, this is an article which has been relied upon and which the learned judge has been persuaded to say that this is holding out to the kind. India's oldest law firm, Fox Mondal, not Fox and Mondal. There's a difference here. Because I will show your lordship that Fox Mondal has in fact established a bigger identity than Fox and Mondal. Here this is Fox Mandal, not Fox and Mandal. Fox and Mandal is the plaintiff, your lordship bears in mind. And your lordship will bear in mind that we are as legal professionals in Calcutta, exposed only to the Calcutta scenario. We do not
Taking a risk.
we do,
That's practical. Yes.
that is what I'll show your lordship, the learned judges. We are not considering the national as well as the international scenario. Now, India's oldest law firm, it's not Fox and Mandal, it's only Fox Mandal.
There was a firm called Fox and Mandal. Fox Mandal.
It is the appellant number 2. Fox Mandal and Company, Delhi, is the partnership firm which 3 partners
But
of
that was registered in 86.
correct.
Oldest law firm Fox.
No, there wasn't.
So there was only Fox and Mandal.
There was only Fox and Mandal. The
Why
article
should
doesn't
this
say.
obviously referred to Fox and Mandal. I mean,
No,
everybody
it doesn't refer to Fox and Mandal. That's all that I'm trying to say. Today, your lordship is dealing with a
No,
firm.
we are trying to distinguish, Mr. Thakkar, on the
Please.
line that there is no Fox Mandal.
Correct.
There was no firm called Fox Mandal, oldest firm.
Correct.
There was only Fox and Mandal.
Yes.
So this will not be taken as anybody having some know-how that this is Fox and Mandal. Directly,
Very well, my lord. Even if I give it
we are taking the worst case against
Worst
it, because
case
you are arguing.
yes, worst case scenario, your lordship takes it as a worst case scenario. This refers to Fox and Mandal. It talks of Fox and Mandal being split. So there are 2
But you
identities now.
legacy remaining with
Legacy remaining with me is my claim that the legacy remains with me. But the fact is that there is no passing off. The test here is, am I passing myself off as a plaintiff?
yes, if the legacy of Fox and Mandal remains with you, we are saying Fox and Mandal for the time, or Fox Mandal
Yes.
remains with you.
Yes.
So you are carrying the banner of Fox and Mandal also. So
I
even
am
today
grateful, my lord.
remains
Correct.
present
Grateful,
tense.
grateful. So it has to be tested. 2 things.
Hmm.
One, the article incontrovertibly establishes that there is a split.
Yes.
There are 2 law firms.
But the legacy remains with you.
Grateful, my lord. Now, what is the legacy which remains with me is a Fox Mandal, not Fox and Mandal. Third, my claim that the legacy remains with me is a mere puff. This is my claim. Because we are not dealing with fast-moving consumer goods or medicines.
But this puff, how to distinguish between a puff and a...
Yes, the distinguish between a puff and an action passing off. That is the test.
So you'll be coming to that.
I will be coming. And second, my lord, most importantly, kindly bear in mind the target audience of this. The class of people who are being said to be possibility of being misled.
Absolutely.
This has the lordships are dealing with the plaintiff who claims to be a tier 1 law firm.
Yes.
Catering to large scale litigation and my lord, to a specific with some personal knowledge, if I may say, they deal with only the biggest of the biggest cases.
Absolutely.
Absolutely. So now the question is, after seeing that this article, will their category of consumers be misled? Will their category of persons be misled who avail of their services? Because a law firm, yes, a law firm has an identity of its own, but the partners of the law firm.
Here there is a link.
Yes.
If you please come to the first
Yes.
paragraph of page.
May I read further?
Right.
India's oldest law firm, Fox Mandal, has split. And there's some logic. I'll show your lordship what the learned, the greatest of respect, has not considered. The fact that plaintiff number 1 used the marks which he is now complaining against. And that is why Fox, if I may just give a little bit of history, Fox and Mandal, the plaintiff started in, there is no dispute about that. As time went by and as the family grew, that is the Mandal family grew, they decided to branch out into various parts of the country. So the partner of Fox and Mandal Kolkata, who's the plaintiff firm, 3 partners, was to be set up the appellant number 2, Fox Mandal and Company in Delhi. They were the founding partners. They set up Fox Mandal and Associates Bangalore. Now Fox Mandal and Company Delhi set up offices all over the world, including in Bombay. They collaborated with a law firm in Bombay. Now, the literature which the plaintiff himself shows all these Fox Mandals or Fox and Mandals were one cohesive unit that is available from the documents annexed to the petition with the great judge has not gone through. And that is the explanation behind these. It is not India's oldest law firm, Fox and Mandal, because the brand became Fox Mandal with all these smaller law firms under that one umbrella.
Mr. Thakkar, just give us half a minute. We'll disturb you for that half a minute. Please, page 610. We'll just jump from the first sentence of the first paragraph, third and fourth paragraphs. First, I'm just telling
Yes.
India's oldest law firm, Fox Mandal, is in the first paragraph.
Yes.
So, India's oldest law firm, there was only Fox and Mandal. It can only refer to Fox and Mandal.
Grateful.
For the timing, let us.
Yes.
Now, the third paragraph, Mr. Som Mandal, managing partner of Fox Mandal.
Yes.
And next paragraph, Fox Mandal is a well-reputed full-service law firm.
Yes.
Obviously referring to Mr.
Mandal's
firm.
Yes.
So therefore, this link between
Yes.
Fox of Lore
Yes.
and the current Fox Mandal, which is run by managing partner Som Mandal.
Yes.
Now, this is a direct link. I mean, you are saying the oldest law firm, Fox, but that split is very vital.
Kindly see paragraph 2.
Yes, we'll come. We are taking the worst against you first.
Yes.
Let us come to para 2. Yes.
The firm split was primarily because of the political alliances of so-and-so, the younger cousin of so-and-so operating from Kolkata. So that is appellant before your lordship in initial years
You
of...
also referred to it also refers to Fox and Mandal, right?
Yes,
That
used to work
used
at
to.
Fox and Mandal Kolkata office and had left Kolkata.
Right.
Clear split. When so-and-so was in school to set up Delhi practice of Fox and Mandal as Fox Mandal.
Now this is also something that you set up a Delhi practice of Fox and Mandal as Fox Mandal. You did not. You formed a new firm and you started your practice there.
No, Malad. So that is why the documents will show that the Delhi, Bangalore, Dhaka, Bangladesh, London, everything traded under the brand name of Fox Mandal.
All right.
But
But it is not the Delhi practice of Fox and Mandal which is being run by Fox Mandal.
It is not the Delhi, Malad. This has been used loosely because the partners were the same. The constituent partners of Fox Mandal Delhi were the three senior most partners of Fox and Mandal Kolkata.
Have they shown anything? The plaintiffs shown prima facie anything to indicate that this is a sponsored news item?
They say it's sponsored because it's at the top. It's there at the
Yes,
top.
you are
611,
At
your
the top.
lordship, it's there
Sponsored
sponsored
Yes,
content.
it's there at the
And
top.
all the
You cannot
articles.
dissociate from that.
No,
So-
Malad, it is a
Yes, we were guessing that.
it is a newspaper publication.
Sponsored publication.
It's, Malad, how much it detracts with a normal publication in a newspaper is an issue.
Is it? Sponsored content is advertisement. Sponsored, if you sponsor a content,
Yes.
it does not remain news. News has to be unbiased. That is the cardinal principle of news, Mr. Thakkar. It has to be objective, unbiased. Where is that objectivity and unbiased in a sponsored content?
Very well, Malad. Let me take to be absolutely correct. I said sponsored content. It is attributable to me. It's in a newspaper. A, that cannot be taken away. B, it talks clearly of the split. So my rest of passing off is I claim I am him. I claim.
You say oldest firm is Fox Mandal,
Yes.
which has split.
Yes.
Delhi practice of Fox and Mandal has been taken up,
Taken over by me,
taken over by Fox Mandal.
which is
And
correct.
then you are the current managing partner and well reputed is.
Yes.
Now, this is you are bringing the past into the present seamlessly, saying that it was there, Fox Mandal was there,
Yes.
reputed old firm, Delhi practice carried Delhi practice of Fox and Mandal. Then you link the Fox and Mandal was carried to Delhi by your client.
Yes.
And then it's continuing there.
So, Malad, I will try to satisfy your lordship that this is absolutely factually correct. If this is absolutely factually correct, matter ends.
No passing.
No passing. And Malad, the passing off, again, I come back with
Yes,
passing off.
times you can, but
Passing off, the point is that A passes himself off as B.
yes.
Here, the minute I say I've split, the minute I say I am in Delhi, The I say Fox and Mandal is in Calcutta. There's no passing off. We are two distinct entities now. It is for the public at large to choose whether he continues. I'm not sorry, the public at large, the litigating public to which this category of law firms deal with or service, for them to choose whether they go with Mr. Som Mandal in Delhi, who claims to have the legacy. It's a puff.
All right.
Or whether they continue with Fox and Calcutta, who's named in the advertisement. So this is an advertisement. This is a sponsored content. Now, if it is factually correct that the practice of Fox and Mandal, Calcutta was set up in the name of Fox Mandal. This is the only link and says that we have split. If this in fact goes to show the split.
Split, but goodwill is carried over.
That is the claim.
That is the claim.
That is the claim. Now, the goodwill is carried over by somebody who claims that I am in Delhi, I am carrying forward the goodwill. What is goodwill then? Goodwill is in the perception of the public at large. If the public at large associate the firm at Calcutta having the goodwill, it still remains in Calcutta. I am disassociating myself from Calcutta. I am disassociating. If after the split, if I had said the goodwill of the Calcutta firm, I am disassociating with Calcutta. The goodwill, I am not claiming goodwill of Calcutta. If I had suppressed paragraph 2 of the split, then yes, there could have been a point. But once I say there is a split, then the goodwill is the impression of the public at large, not my claim or his claim, or for that matter, anybody. It is the goodwill is the impression of the public at large.
All right.
This is a public perception. Now, the public associates or the class of, I'm using the term public loosely, my lord, but if the class of clients.
Informed litigant.
Informed litigants.
All right.
If the informed litigant, the test is of a, I'll just give 3 exact words I use. A very litigant with limited information and limited recollection. I'll give the exact language. It's then one of the Supreme Court judgments. So with that test,
please repeat that one.
I'll give you a lordship the exact terminology. Once the judgment is there, I'll give the exact terminology.
That was cited in other cases.
Yes. That is the test. So when we apply the test to this article, one must bear in mind the kind of services these law firms provide and clientele. And law firm is not a product. It is the sum total of the partners who constitute the law firm.
Yes.
People don't deal, litigants don't, yes, some go to the law, but they know, yes, this has so much, this has, for these big cases, it can win my case also. But then after that is there, the next is the partner who comes into the picture. They deal with a partner. It's not a product which you go to the shelf and buy off the shelf. You see a RIN and a super RIN, and you get between RIN and super RIN, and you buy super RIN and go. It doesn't end there. So paragraph 2 makes it very clear that the disassociation and my claiming that I have the goodwill doesn't make it a case of passing off. This is a claim which I make. But it is for the public perception that whether Mr. Fox carries the goodwill or Calcutta carries the goodwill. The public perception. My claiming will does not, my lord, give me, make out a case of.
All right.
Now, my lord, kindly come to page 576. This is the next advertisement.
4. We had started from 600.
I'm sorry, 612, the next page.
Yes.
576 is the franking number. Fox Mandal has split. Original identity of Fox Mandal law firm Som Mandal. So, my lord, I'm saying the original is Fox Mandal, not Fox and Mandal. When it is said to be sponsored content, I would have said Fox and Mandal.
This is apparently by a business correspondent.
This is apparently by a business
First sentence says has split with Mr. Sommondol's firm in Delhi.
Yes. So I'm stressing on, had it, I take all of this, their case, and what the learned judge has been impressing once, these are our publications, these are coincidences, that all of them is sponsored. Let us give it, I will argue to the absurd. Then I would have said the original identity of Fox and Mandal. To claim goodwill, what is the plaintiff harping about? He's saying the goodwill is of Fox and Mandal. And I'm not saying Fox and Mandal once in all my sponsored content. That is the distinction. It is not his case that Fox Mandal has any goodwill. He says Fox and Mandal is trash. It was born day before yesterday. It has nothing of its own. It's piggyback riding on my entity. No, then it would have been Fox and Mandal. I've paid for this. I would have got Fox and printed. And the split is of Fox Mandal. That is the point, Malad, which I'm trying to make. Fox Mandal has split. Your Lordship will not find anywhere that Fox and Mandal has split. Because I will show your Lordship from the documents in the petition that they were trading under one umbrella. And the plaintiff himself was using the marks Fox Mandal, which he complains of, which the learned judge has not even adverted to, although it formed the main ground of my written note. The plaintiff himself was using the marks Fox Mandal, which he now seeks me to restrain me from doing. Your Lordship understands a law firm attracts business by showing its presence all over the world and India. That is how they attract business. It's a symbiotic relationship between Fox Mandal Delhi, Fox and Mandal Calcutta, Fox Mandal Bangalore. I get a client in Delhi who has work in Calcutta. I send him to Calcutta. He wants to go to New York and Singapore, where I have contacts. As in Fox and Mandal, Calcutta wants to go to New York and Singapore, where I have contacts. He asks me for my contacts. That is the reality, practical reality, which we cannot close our eyes to, and we cannot close our eyes to the fact these are all brothers and cousins. So, learned judge treats it as a purely partnership action with the greatest of respect. Mala, that is where he goes wrong.
And there is no prayer. We don't know about the prayer, but there is no restraint order on you using Fox Mandal and company.
Till now. Till this.
Kept open for the suit.
Yes. Now the summary judgment application is also being heard. Because we need to file a written statement.
Habitual defaulter in non-matters.
Looks like me.
The other matter also.
It's
content.
I not off the record.
No, we understand. We understand.
And I fear for the clients.
We feel for the council actually.
I fear for their clients also.
Yes, that's a very important consideration. Very important.
That's she will not.
No, we are not. We are not.
That is as counsel I'm saying.
No, just forget it.
Yes. So, the sponsored content doesn't say Fox and Mandal has split. Sponsored content says Fox Mandal has split. That is the baby which I have created has split. To the contrary, Fox Mandal, they have nothing to do with Fox. They say we are not Fox.
Up to now, if you can sum up, one is you are using Fox Mandal, not Fox. Second, split is very from all these articles.
Yes.
Third is not a passing off.
Correct.
You have not that goodwill, the goodwill of Fox and Mandal.
Yes, because I'm saying there's a split. Claiming that it will come to me because I have three Fox Mandals.
Yes, and also that perception of the clientele who are informed litigants is a matter of consideration.
Yes.
Very good. This repeated use of this law firm Fox Mandal and then being spearheaded by you, that creates a problem, Mr. Thakur.
That can be
in the private perception. Not
I follow that, Malad, because I am not the oldest law firm. Fox Mandal is not the oldest, consideredly. So, Malad, this is at the highest a puff.
Has been spearheaded by you, and then you connect the two.
Yes, so I say that Fox Mandal has been spearheaded by me.
Very good.
Of which also there is few.
But that's preceded by split.
Yes.
Fox Mandal has split.
Split.
Yes.
I am saying that my firm has split.
Yes.
If your lordship takes this to be the gospel truth, what is written? Let us take it from my perspective. I say that I spearheaded India's oldest law firm, and that law firm has split.
Hmm.
So it's Fox Mandal which is split, not Fox and Mandal.
You don't say that. If that was it ended at that, Mr. Thakur, yes. Fox Mandal has split. Your side of the firm has gone to Delhi.
Correct.
And then you say India's oldest law firm, Fox Mandal, has been spearheaded by you.
Yes.
So the sum total is oldest firm, Fox Mandal, spearheaded by you or your dynamic leadership. You have taken your side now to Delhi.
Delhi. That is all that it says. Now, can that amount to my passing off the services of
You are Fox and Mandal.
I am Fox and Mandal?
That
or
identity is missing.
That identity.
That I am Fox and Mandal.
I am Fox and Mandal is missing. What is even more stark is that we have split. There is a complete separation of Mandal Delhi and Fox. I'm sorry, Fox Mandal Delhi and Fox and Mandal. All these publications, in fact, reiterate that. And if it is sponsored content, I'm trying to save my goodwill. I'm saying I have nothing to do with Fox and Mandal Calcutta, which is spearheaded by one gentleman whose name is there. It cannot be more specific. So with the greatest of respect, Mala, that is where the learned judge says that you are trying to encash on Fox and Mandal. With the greatest of respect may not be correct. And that is the common thread in all the articles. Common thread in all the articles is that there is a split. Now, if there is a split, then there can be passing off. Passing off is when all the judgments which they showed, I pass off my goods and services as those made by somebody else.
Yes.
I pass off my goods and services as actually his goods and services.
So for coming under the umbrella of that passing of action, you had to claim that you are Fox and Mandal.
Fox and Mandal. Great.
You are Fox and
I am Fox.
Identity is missing.
That identity.
Claim of identity.
Yes. Just by saying
you are saying I am Fox Mandal and company. They are Fox and Mandal.
They are Fox and Mandal.
Started from the same genesis. I am carrying the legacy.
That is all. I couldn't have put it. Now, if I am claiming the same legacy or not, whether that will amount to
legacy is past,
legacy.
not present.
Not present. No. That is, my lord, and that is, my lord, what is really, my lord, trouble the learned judge. These articles really trouble the learned single judge.
Yes.
That this is not
very evident. Yes.
It's very evident, and that the learned judge was
else apart from this.
No, I'll show you. No other proof. No other proof. Zero. Apart from these articles, no prima facie evidence of passing off. In passing off matters, your lordships will find bills.
I was just going to say.
Yes.
Any bill produced?
Nothing.
That you bill in the name of?
Nothing. Not one. I will show he has issued bills in the marks which he is trying to stop. A. So there is no prima facie evidence of passing off except these articles which are construed as evidence. One. B. There is an averment in the petition that my clients have been approached by the rival firm claiming to be that of the Kolkata firm.
My firm is there or your?
The plaintiff firm.
Their firm,
So
yes.
the plaintiff in his petition pleads
says
that
his firm is?
His clients have been approached by the rival firm of Delhi claiming to be the original firm of Kolkata.
No proof on that.
No proof on that. Now, I would have thought that such a serious allegation
No
would
communication, nothing, no email.
Nothing. All that was required is, and your lordships, since your lordships have so much experience, are aware of the relation between the litigant and his solicitor. The litigant, at the beck and call of the solicitor, the litigant will issue an email, whether correct or incorrect.
Yes.
Whether correct or incorrect, he will issue an email.
Yes.
Because he's not concerned with the firm in Delhi.
Tenant, anybody in a subservient position.
He will do it.
Dependent position.
Yes.
Very well.
But there's nothing. And there's just a bare averment. And that is not something which has persuaded the learned single judge also. He has only gone on these articles. The articles, in fact, show the split. Now, what the learned single has not considered with the greatest of respect, because the written notes of argument are also on record, the fact that what is dressed up as a passing of action is actually an action, in his case, of revocation of license. That is his pleaded case. That is his cause of action. Kindly see, that is what the learned single judge has not considered the plaintiff's pleadings, who has tried the color of a passing of action, whereas actually his cause of action is a revocation of license. Because he cannot run away from the fact that Foxmundle Delhi was set up. And one of them is the co-plaintiff here. I'm sorry, the pro forma respondent. And that is the admitted position. The petitioner say that till 2020, when there was a common partner, Mr. Dinobandhu Mondal, in both the firms, there was no problem. It is after his death that everything has started. So passing off since 1984, there was no passing off.
No, there was no separate identity. But
There
it's
was-
in 1984.
Yes. 1984, Delhi was set up.
Yes. When has the suit been filed?
This suit is 2022. So 1984 to 2022, there's no passing off. There is no chance of misrepresentation. There's no chance of deception. The public are not misled. His goodwill is not hampered. Now, after 18 years, he says,
So that is your acquiescence point.
delay and acquiescence both.
Delay and acquiescence.
And your lordship has just read the order. Your lordship will see. He just says that there is no
Action was required.
positive action.
I just said positive action.
Yes. So the positive action is his using my marks, number one. Number two, his knowledge. Inaction is also knowledge.
Probably you may have a point there, Mr. Thakur. We are not trying to supply points, but you don't need that.
In this-
Waiver and acquiescence are on different footing.
Yes.
Waiver is positive.
Positive.
Positive relinquishment of a right. Conscious positive relinquishment of a right.
Yes.
It has been defined in
Merely keeping quiet is not
being quiet is acquiescence.
acquiescence. Yes. You are
You have to just show his knowledge.
Yes.
For acquiescence, you have to show he was conscious of this use.
and he didn't stop
The
it.
scope of not being conscious because
It's pleaded.
everybody knew about this.
He's plead. And the most interesting part, which the learned single judge also deals with in one sentence, the marks my mark was registered prior in point of time. Well, prior registration is not a defense to passing off. I'm not saying that. But my mark is registered prior in the mark which he now seeks to stop.
You are putting that into the acquiescence bracket.
No, my lord. I go even a step further.
Like,
My mark is registered.
yes.
His mark, the Calcutta marks are registered as associate users of my mark under the same. They are clubbed with my mark, and under section 24 of the Trademark Act, they are joint ownership.
Was it argued in the trial?
Yes, everything was argued. The written notes of arguments are there. That is suppressed in the petition, squarely taken in the opposition. He says registered, I got my mark registered. He says he got his mark registered. But he does not mention this critical fact that his registration is as a joint or associate user.
Just give us half a minute, I'll take a note of that.
Please, please. Notes of argument are there. Stay volume 1. 8 to 8.
Yes, sir.
Yes.
Right.
Now, my lord, kindly come to
Even if registration is not important in the passing of action,
Not at
but it's a piece of evidence which
Yes.
ought to be, you say, looked into. Because
Yes.
to get what they are giving out. In their perception also, it's executive.
in their perception. And acquiescence, my lord, is a complete statutory defense under section 33 of the Trademark Act.
It's not a trade infringement case.
Not in infringement, but in a passing off, it's a complete statutory defense.
Very well.
Now, my lord, kindly have the petition once, please. What is the cause of action? Because
Early when we try to trademark act statute, we take out the passing of action instead of
Yeah.
infringement.
yes, because he knows I am a
Wider
wide.
and in
It's
tort.
common law right.
Common
Common law right, my lord, is an equitable right.
Yes.
Kindly bear that in mind also. It's not a statutory right, it's an equitable right.
Yes.
One who seeks equity must do equity.
Right.
Now kindly see the release which are claimed. You will stop me from running my business which is going on since 1984 completely within your knowledge, from which you have benefited. Would that be equitable or not? Because none of the cases which are cited by the petitioner have remotely deal with any of this. Remotely. The most important being the defendant was to be incorporated by common partners of the plaintiff. Most important distinction. So it's not a third party outsider stranger who suddenly one day comes and starts a manufacturing unit in his backyard and says, I am selling Unilever's RIN. It's not that. You set up. That begs the question, you set up and you set up with a similar trading name. Only distinction being Fox, Mandal and Company. Now,
When the split happened, they became Fox Mandal and Company, but you continued as
they
reconstituted and
remained
continued.
as Fox and Mandal. They remained as Fox and Mandal. Fox, Mandal and Company was mine.
All right.
The split was clearly defined because my lord kindly says, and this was perhaps a good way of doing it to stop in the what happens in the if the entire family continues in the same business, the business ends. That is why
All right.
these people had the foresight to
Yes.
set up these independent centers. The main partners of the Calcutta unit had
Exactly happened, Mr. Thakur, when the split means a new partnership was formed by a deed or whatever.
so no, my lord, what happened?
registered, and there was a reconstitution of this,
No.
of the old one.
So, my lord, what happened was
What is the model?
1980 Fox and Mandal Calcutta has
Continue.
been reconstituted time to time,
Yes, yes.
primarily controlled by the Mandals and the immediate cousins.
Is there any Fox left in Fox and
There's no Fox. He was the only one, Mr. Fox.
Mr.
Mr.
Yes.
John Kerr. After that. After that, it has always been Mandals. So, my lord, the Mandals continued. Now, to expand business and with the growth of the family, they branched out. Very sensible because they constituted different partnerships. This is the wisdom with them
Absolutely.
learning from the oppression mismanagement cases, perhaps that everything will, the pen will also get destroyed.
Yes.
So they use that foresight and they set up these different partnerships, but all constituted by the same founding partners. The main partners here went and set up a partnership there. As and when the young blood came in, they were given charge there. So I was the young blood who was given charge of Delhi. One of my brothers was in Calcutta along with my father. One of my brothers went to Bangalore with his own independent. And the other mandals also came into Calcutta. All this continued. The other two partners in Delhi, other than my father, Dinobandhu Mondal, resigned from there and I came in. Dinobandhu Mondal continued to be partner in Delhi till 2020, till his demise. My
Dinobandhu continued as a partner here also.
Yeah.
Dinobandhu Mondal was a common factor for some time till his death.
Yes.
Between the two.
Yes.
He was a partner in both.
He was a partner in both. Now that is argued by them by saying that is their cause of action. That Dinobandhu Mondal was common partner with no difficulty. But that is not passing off. That is not an action in passing off.
Dinobandhu Mondal was an individual partner.
Grateful. And now kindly see, with the same logic with the learned judges, which they have argued that the goodwill is of the firm. The mark is of the firm. It's not of Dinobandhu Mondal. Then that very argument of theirs, reliance on clause 17 of the partnership deed, cuts their entire argument that we allow to use since Dinobandhu Mondal.
Dinobandhu Mondal expired when?
2020. Now, my lord, if the mark is of the firm, then the partner can be allowed to use. Because he's setting up a rival, if I may say. You've permitted a rival to be set up. So that is why I say, my lord, this is not a classic case of passing off. Which the learned single judge has, with the greatest of respect, not considered.
Dinobandhu's continuation as partner in both may be a great argument of yours. I mean, a great component in.
But I say that they make it a great component, and that is the cause of action. They say till Dinobandhu Mondal was alive, you were allowed to use the mark. after his demise,
Cannot link up the user with Dinobandhu because he was only a partner.
it was only a partner and it is not his mark. I would have understood it is his. It's not his mark.
No, we say the component of your argument of family mark.
Yes.
Since Dinobandhu was there as a
Yes.
common partner, if there was a rift in that sense, I mean, anyway.
And they say it's not a family mark. I say it's a family
No,
mark.
no, that is what we are saying. That can be a component in your family mark argument.
Yes. And they counter it by saying it's not a family mark. It's a mark of the partnership. Please see clause 17. Any partner who dies, his heirs do not get any benefit. The asset is that of the firm. It's a partnership asset. The goodwill and the marks are that of the partnership firm. They cannot be passed down by inheritance. If that is the case, then in no manner could Dinobandhu Mandal have anything about Dinobandhu's association with the plaintiff, with the Delhi firm, justify the use of the marks by the Delhi firm, because it's not Dinobandhu's mark to start with.
Not Dinobandhu Mandal.
It's not Dinobandhu Mandal's mark. It's your pleaded case. Now, the question I ask myself is, how can the demise of Dinobandhu Mandal suddenly give it a passing of action? That is now Malakisi's petition. Can I come to Malad paragraph? I'll show your lordship what these annexures actually are, because they make very interesting reading. They use a brand Fox Mandal, which is mine. The plaintiff himself uses the brand Fox Mandal, which is mine. The plaintiff's bills have the mark Fox Mandal, which I have coined, which I have created, which is devised by me. Prior to that, they are not able to show they had anything to do with FM Fox Mandal. They have used it. And now they say that this is passing off. So this is a case of reverse passing off which no judgment has dealt with till today. Can the plaintiff who has himself used a mark, can he then turn around and say that this mark is being passed off by somebody else? When the mark was not his in the first place. Because his mark, now kindly see what are his marks. Kindly have the petition at page 41. The firm is the owner. The firm is the owner of the trademark Fox and Mandal, which is registered on 7th March 2006. Kindly note the date, my lord, and also the mark. In class 42 with the user date recorded since 1896. At the time of registration of the said mark, the firm had 6 partners, and accordingly all their names were recorded as partners of the firm in the trademark registry, as also the registration certificate. The firm as on the date is a proprietor of the following trademarks. And kindly see the marks which are there. They are all F and M. Fox and Mandal, Fox and Mandal, Fox and Mandal, and F and M. Now kindly see the infringing marks. Paragraph 20 at page 44. In the year 2003, it appears that respondent number 1 got a trademark registered in his name being so-and-so. Copy of the e-register is annexed to and marked with K and K1. The respondents have also subsequently applied and obtained registration of several identical and deceptively similar marks as that of the firm's mark, Fox Mandal.
But you said your registration was prior?
2003. His is 2006. Kindly turn to paragraph 40.
Right. Yes.
And that is why he became an associate of my mark.
Right.
Now kindly see annexures K and K.
K would be in which volume?
K and K are
Which number?
320 volume 3. এটা দেখাও যে ও আমার অ্যাসোসিয়েট আছে
তুমি এটা হাতের এমন জায়গায়
আমার অ্যাসোসিয়েট আছে রিট পিটিশনে ওখান থেকে
Yes.
Now kindly see the mark at 321.
Yes.
offending mark K and K1. K is certificate. The Lordship sees the mark at 321. For Mandal. Now let's see page 131, please, my lord, of 1. And keep that 321 open, please, my lord, side by side. 131 of the volume is annexure D to the petition, which the petitioner relies upon, or the plaintiff relies upon, to show his goodwill and his
131 is
in bold, my lord, in handwritten bold
oh
of volume 1.
yes.
These are, my lord, annexures which the plaintiff relies upon in support of his goodwill and continuing business,
Yes.
which
Whereas-
are referred to at page 39 of the petition. Paragraph
yes.
9 of the petition refers to annexure D.
Yes. These are letters.
Yes. These are all, my lord, to show that this firm, that is the plaintiff firm, is in continuous existence. These are all the supporting facts to show goodwill. This is the documentary evidence he relies upon as part of his case of goodwill continued existence. Now, this starts at page 131, annexure D. Now, kindly see 133. And kindly see the mark at the center of the page. And kindly compare it with the mark at 321. This is my mark. And this continues. And kindly see the addresses at the bottom of that page. Fox and Mandal has only Calcutta at this point in time. It has now opened a shop, which it has written in the petition. None of these outlets were of Fox and Mandal. These are all my brother in Bangalore. New Delhi is mine. Mumbai is mine. Chandigarh is mine. Kindly see the mark at the center of the page. And this is the document in the petition which I will show your lordship from the written notes, specifically argued, but the learned judge has not dealt with it with the greatest of respect. This very important. And also, my lord, since we are at this document, kindly take a note of that email ID over there. Calcutta@foxmandal.com. This is also mine. This domain owned by me, registered by me. Because I have Delhi, somebody has Bangalore. All of these separate entities were trading under my brand name, Fox Mandal. And your lordship has gone through the order. Your lordship will not find any reference to this. The learned judge has only considered the advertisements. And these are the documents annexed to the petition. I'm grateful because I would never have had access to these. That they've disclosed these. I would never.
These are their documents.
These are their documents. They rely upon these documents as proof of goodwill and business.
This 321 is also their document. Your infringing mark.
Yes, their document.
They're saying that this
Yes,
is
this is the infringing mark. This is the mark by which I'm passing off my services as his. This is reverse passing off. And that is why I have a suit to restrain them from using Fox Mandal, which they have been using.
And you split up in
20. We were never. Kindly bear in mind.
so this you were formed in
1984.
1980.
So it's not one partnership firm which has split.
2011.
And these continue, not one. Kindly see the next.
We have seen
134, 135, 136. These are his documents. We can't, the greatest of respect, on this. And there's no explanation for this. Because my case was also of shared goodwill.
yes.
It is not only goodwill of Fox and Mandal. Yes, we in Calcutta know that Fox Mandal has tremendous goodwill. But outside Calcutta also there is a world. And Fox Mandal has some presence there. Otherwise, Calcutta would not be using Fox Mandal. I would have been using Fox and Mandal there, which I have never used. There is nothing to show, not one scrap of paper at the interim stage to show that I have used Fox and Mandal ever. And that is where the pain comes from. Something which I have established, which you have used.
Hmm.
Now you turn around and say, I cannot use. Now, my lord, these letters I've shown your lordship, my lord, all of them have mine. Now kindly see his billing. His money receipts have this. In the next volume. Second volume 2. Kindly come to 172.
Volume 2
167 onwards.
Yes. 67, yes, please, my lord. Now these are cash vouchers. Has my
Yes, yes.
cash vouchers. Now, cash vouchers are internal documents. They can say that, oh, these are internal documents. They don't go out to the world at large. So, there's no problem. Very good. Kindly come to money receipt at page 177. It's a money receipt. Received from Electro Steel Casting Limited. And kindly see the mark at the top left-hand corner.
The and is there.
Yes, and is there.
And is there.
But kindly below that is Fox Mandal.
First one.
Yes. Fox Mandal. Now, coming back to the advertisement, the sponsored content advertisement. What does it say? It says Fox Mandal has split. Because all these entities are under Fox Mandal. One common brand for their own advantage. Because a law firm which shows a pan-India presence and an international presence obviously attracts more clients than a one-shop law firm.
You have not filed a counterclaim, so they are
No.
passing off. Yes, this
My written
shared goodwill argument gets.
and there's only one line in the order which deals with this without taking into consideration any of these documents. I cited Habib Bank, and that your lordship has seen was dealt with by saying cases fact is different. There the founding were the same, and was change of employees were shared off and on. That is how Habib Bank has been dealt with, and Habib Bank was identical. Bank set up in Pakistan, set up an office in Switzerland, set up a branch in Switzerland under the same name. Pakistan got nationalized, came and said, now you have to shut down Switzerland. You cannot continue in my name in Switzerland. Because I have set you up, goodwill is mine. It was disallowed by the House of Lords. So, no, these factual aspect of the matter coming out from the petition has not been averted to in the order. What would be the consequence? That your lordship will decide the first time. Now, as to whether these can be a defense in passing off or not, that is for your lordship to decide for the first time. But kindly bear in mind, your lordships do not have the benefit of the learned single judge dealing with these documents.
Yes.
I have argued in matters before your lordships, my lord. In court appeals, the scope is less.
That's always there.
The scope is less. That is what interim orders. Your lordships do not exercise discretion.
Because it's High Court against High Court.
And your lordships do not.
Taking judgment over High Court.
Yes, and your lordships do not interfere with discretion. Here is a case where discretion has been exercised without, my lord, before the vacation, my lord, it's.
So you'll be faster now. Yes.
But I'll take time, my lord, in this, my lord. May I?
No, take your time. But
Today,
we thought you'll be faster because
no, my lord. Today, my lord,
we won't finish.
no, my lord. I'll have to take your lordships to the judgments because this order has serious consequences. And I'm laboring more because this order of the learned single judge is placed before the learned single judge to say that, of course, he's not influenced by it.
But we'll have to carry another matter then over to the election. Obviously, they'll also not be finishing today.
Because I will not be able to finish it, to be honest. Because this aspect, the factual aspects required to be placed before your lordship because they're not dealt with in the order.
So well, then we'll keep it parted at
Yes, please,
because
parted at the same
called-
position. Grateful, man.
have to be aware of practical reality.
Before the vacation, my lord.
But for further hearing, the matter be
24th, we are reopening, my lord. It's a Friday. If your lordship takes it up on that day, also I have no difficulty.
we don't have any problem. Excellent. Then we'll have some business at least.
Yes, because first day generally, my lord.
It should come.
Yes. 24th, your lordship.
Yes, the poor learned juniors of the other side will have to come. Who is leading you?
Mr. S.N. Mukherjee, Your
He'll
Lordship.
definitely not be there.
But I will take the day.
No, yes, right. Understood. So, date for further hearing, we listed on October 24th, 2025.
Grateful. After the appellate side matters, my lord, because it's an appellate side day.
Top chilo. At the top, we date at the top because we'll lose continuity otherwise.
My lord, this will be after the appellate side or before?
No. Before the appellate side,
Or your lordship keeps it up in the second half at 2 p.m.
in the because we put the appellate side matters because it's generally the bar association calls more 3:30 on Fridays. That's why we we deduct their time.
That matter fixed on that date also. That consideration was also because it's the 24th. Nobody will come. Tucker will be there. We'll do it. That is why I'm humbly praying if it can be 2 p.m. or 12 noon, my lord.
12 minutes different.
PM, please.
Has been fixed already.
Yes, my lord. It's already. I can place the order also. It's been.
If it's at the top, if it's
Yes,
not at the top, then
it's at the. But it's before a learned single bench. But it's been. But it's already been fixed, my lord. Can you keep it at 2 p.m., my lord? We'll do.
Sorry. 24th is a Friday. It's a single. So we are in single.
No, it's a single.
So we'll keep it on 27th, then at the top.
Yes.
Wednesday.
It's a Friday.
29th.
This
29th.
bench will not be assembling.
29th. So 29th.
Yes. Yes, please, man. At the top. At the top.
29th. Thank you.
Grateful.
Great.
I'm grateful. Man.
Thank you. এইটা এটা কি ওদিকে না এটা তো আমারটা নোটটা
Item number 2.
My lord, I am appearing for the Chartered Accountant Institute of India. My lord, I had completed my submissions, my lord.
yes
My lord, today I think Mr. Joydeep Kaur was supposed to submit on behalf of the complainants, my lord.
you should keep it after the vacation.
Keep it after 2 and 3.
He's not there. Not there. I have not seen him around also. Then after
My lord, 2 and 3, both of them, my lord.
2 and 3. It's a college for the institute. No,
The complainant, my lord, I am for the institute, my lord. My lord, I was appearing for the institute. I made my submissions. I finished.
I've been led by Mr. Kaur. Engaging courtroom number
we'll
1.
keep it after the vacation. Then.
Kindly keep it after.
On the prayer of the complainant, let them understand adjourn till after the upcoming annual.
Grateful, Lordship.
Grateful, my lord, very grateful.
Whenever next Wednesday, probably 29th. Probably.
My lord, very grateful, my lord. Very grateful.
Thank you. This is from
2 and
Sir.
3, man.
2 and 3.
2 and 3, my lord.
2 and 3.
Same.
Grateful.
Item number 4 with item number 5.
Or did I appear for the appellant in item 4?
Yes, Mr. Bush. We can't see you without any junior.
Yes, this is the matter. I was about to tell you this matter will not take 5 minutes.
Ah.
But both my junior lord are stuck not because of the increment weather in Calcutta. They had gone to Guwahati, and yesterday there was a Guwahati band because of the death of that famous singer.
Yes, yes.
So they get the
Something
flight
huge.
back. Well, I tell your lordship what the matter is, so that next time when your lordship assembles, well, there was a 397, 398 application.
Mr. Bose, is there anyone at least from the otherwise it will be difficult to record your name.
Then my lord, keep it after the vacation.
I think that will be easier. We are not strict on these, but we are just trying to because
protocol
we respect you
agreement.
too much to recognize without a junior.
Protocol
We have been
has
very
to-
careful.
But this much I can tell your lordship will not be troubled once this matter is taken up.
So we can record all the learned senior.
No. Kindly do not break your
Need not.
lordship's rules. It's not right.
No, we can just record that your name and
Yes, I was here.
senior advocate is here. You are assisting Mr. Bose.
My item number is item number 5.
No, he's
That
not
is the-
assisting me. He's in the
I
next
am
matter.
the
but they're
next matter,
similar
item
matter.
number 5, similar matter. There is a
So we'll say basically that since none appears for the respondent, therefore we are urgent.
It is doubtful whether anybody will appear for the respondent, but we shall open that chapter next day. But may I unofficially tell your lordship what this matter is about?
Yes, yes.
It is not meant for anything else. There was an application under 397, 398. Hungerford Investment Private Limited made this application. Hungerford by one Mr. Hoon, Nirmaljit Singh Hoon. Lords may have heard about it.
Mr. Hun, not only hard. Yes.
Yes, I did say the rest in open court.
Yes.
Now, my lord, that application was dismissed after a prolonged hearing on merits. Appeal preferred, appeal dismissed. Review preferred, review dismissed. There was no SLP. So, my lord, that order 397, 398 attained finality. Much later, Hungerford and Mr. Hoon purported to take out a score of applications, my lord, trying to revive the merits of the old application, and took out applications under section 340 of the Code of Criminal Procedure, alleging that mistakes had been made. Our stand was, it cannot be so, because you cannot open a new chapter on the basis of applications which touch upon the merits of the original case. The learned single judge, my lord, was pleased in the impugned order to say, I will not pass any order in the section 340 application, and I will give a hearing to all those alleged people we are complaining against. Against them, we preferred the appeal. We need not have preferred the appeal. The only clarification which we are seeking from your lordship, subject to your lordship's granting us the clarification, we had taken out an application court below saying no application relating to the 397, 398, whether under 340 or any other section pertaining to the relevant law, should be entertained until our application is heard. So that is the only clarification which we shall ask for. We shall show your lordship the trial judge and say that this application is not.
Is there any reason for apprehension that it will not be taken up first?
There may be, because considering the fact if for a bench like your lordship, this application would be taken up and the 340 matter would be heard without, my lord, the other application being. Same learned judge had passed that order. I shall just show your lordship that order. But kindly do not record anything today. It would not be fair.
Then we'll.
And Hungerford Investment, subject to correction as far as Mr. Hoon has passed away. There was a time somebody else was appearing. Mr.
File tag was
Hoon-
just একটা ইয়েটা দাও মেমো হ্যাঁ ওটুকুন
Because if we are heard,
Ms. Rupitro is still there in the matter. You won't be knowing. He had signed the memo.
Yes. This is on behalf of Khaitan and Company. Now, Mr. Onunoy Bose of Khaitan and Company is present advocate on record.
Mr.
Onunoy Bose.
He is your advocate on record.
Yes.
Heard Mr. Utpal Bose, learned senior advocate. Puts up, however, comma, since none appears for the respondents at the time of call, comma, let the matter stand adjourned till after the upcoming annual vacation. Mr. Utpal Bose, please give your name and Bose's name with Mr. Onunoy Bose's name in his matter. And your matter, your name only.
Lordship, I am also appearing online with Mr. Bose, my lord.
You are appearing
Kindly
online.
Yes, my
But
lord.
You will also suffer the same predicament without Mr. Onunoy.
Yes.
So Mr. Sharma's name, please give all the names. Mr. Bose, Mr. Mr. Onunoy Bose, and in the other matter, you. Thank you.
Grateful.
Thank you. We'll come back after 10 minutes for the next matter.
My lord, I'm led by Mr. Jishnu Chaudhary in the matter. He is on legs, and even the junior is also not there. I was humbly praying if
I had to say something. I have on the period of the appeal, let the matter stand over till after the upcoming annual vacation. Vacation? Puja vacation? After the puja vacation, we don't have any other day.
yes,
But petition in the petition.
Item number 7.
My lord, I appear for the respondent, but I have an application which is somewhat of has somewhat of an urgency, but very short, very short. In the appeal, the defendant was directed to, my lord, put in pursuant to a chapter, I believe, chapter 13A application, my lord, rent. There was a division initially by orders of court that 30 would be paid to me directly, and 30% of the rent occupational charges will be
This arises out of an originating summons.
no.
Regular suit. We are afraid of originating summons. So then, yes, to put in
Rent
they did.
30% to me directly,
Awesome.
and balance to be paid to the registrar side, who will keep it with the in his account,
interest-bearing
in the
account.
Yes. Now, my lord, today, my lord, the
I have
application.
challenged that in the.
No. I have made an application. Very
No,
innocuous.
the appeal is against what?
The appeal is against the order of chapter 13. Now, my lord, all we are saying is two things. My lord, the registrar, my lord, there is a poundage that the registrar tracks. My lord, we are saying we will lose such substantial amount of money at the end of the litigation, because this will run into crores. My lord, we are saying, first of all, let the receiver, my lord, let the defendant deposit in a account to be designated by court in the credit of the suit, and my lord, all the amount of money that is lying with the registrar as of now, around 3 crores and odd, be transferred there. That is the only, my lord, innocuous prayer we are seeking, because we ultimately have to pay, my lord. We will be the loser, because if 10 crores is accumulated, almost 1% of the total and 2.5% of the interest earned upon that has to be paid by me. So I will be the loser, and money will be.
But the appeal is, what is the appeal about?
Appeal is the order of chapter 13.
May I
But,
only
my lord,
indicate this? We are not opposing to this prayer, my lord. We are conceding. The only that we have, my lord, is the name, because, my lord, the account name is in the name of Turner Morrison Limited. We are only objecting to that. But may it be in CS number.
No problem. Nomenclature, there's no
Nomenclature, my lord, because we are otherwise agreeable. I take
শুধু অ্যাপ্লিকেশন কি করে আসবে? অ্যাপিলটা তো been assigned to us.
only the GA, my lord.
Yes.
Oh, yes. So if you don't oppose, you'll direct that.
Well, only prayer is, my lord, the nomenclature of the account, because it is in the nomenclature. What they've prayed for is the nomenclature should be Turner Morrison Limited. My lord, I've taken it. We don't have any other option, but the nomenclature, my lord, I'm only praying.
Page 14, my lord, kindly comes to page 14. Instead of Turner Morrison Limited FD account, they are possibly saying, and rightly so, CS number.
CS number.
CS number.
Cost for that.
Absolutely correct. Absolutely correct. So, well, two things. One, the registrar should transfer whatever is lying from henceforth, yes, that account, to that private limited bank, where an account is to be opened.
No, the main appeal has been disposed of.
No,
No, my lord, it's pending.
Appeal is still pending.
Yes,
Great.
interact, arrangement.
The respondent in the appeal has taken out the present application with a prayer of modification of the order dated December 20, 2019, as subsequently modified by different coordinate benches on December 14, 2020 and February 25, 2020, to the extent that instead of the deposits directed to be made by the defendant stroke appellant in the suit partially with the registrar, original site, the entire deposits to be made by the defendant stroke uh, in consonance with the order of the court, be made in an account in the name of the respondent. For sub next para, during arguments, learned counsel appearing for the appellant comments that the appellant, in principle, has no objection to the.
May I pray for this? It's Milord, a government entity. Kindly don't record my
That's very well.
calculation. Milord.
Learned counsel for the appellant opposes such prayer. For sub next para, upon hearing learned counsel for the parties, it transpires that it would only be appropriate that an account is opened in the name of the suit where the deposits directed to be made by the defendant appellant should be made in their entirety. However, the ends of justice demand that ought not to be in the name of either of these, but of the suit. Next para, we take into consideration the argument of the respondent stroke appellant to the effect that in the event part of the amount is deposited with the registrar original site, unnecessary amounts would be deducted on account of poundage, which to the benefit of neither of the parties. For some next para, accordingly, GA5 of 2025 is allowed, thereby modifying the order passed in the present appeal dated December 2019, as subsequently modified on December 14, 2020, and thereafter on February 25, 2022, to the effect that the deposits directed to be made with the registrar, original site, at the tune of rupees 3016333 to the tune of deposits directed to be made to the registrar original site shall henceforth be made in an account, to be opened in the name of the suit, bearing CS number 45 of 2013. Who will open the account? The registry or them? Probably the registry. You can open.
Yes.
Very well. Full next para.
And intimate them.
Yes, that is particulars.
Yes.
The amount of rupees 3016333 already lying with the registrars, original side registrars.
Malad, may I just, Malad, this amount is on April 2025. So
the amount of number
whatever amount is
the amount which is lying with the PLA account in the name of opened by the registrar at the Reserve Bank of India, Kolkata, in the fixed deposit escrow account. In the PLA account opened by the registrar shall stand transferred to the newly opened account in the name of the suit. Next para, the respondent stroke petitioner shall undertake necessary formalities for opening pursuant to the direction of this court, and for such limited purpose, is empowered to do so. Next, the particulars of such account shall thereafter be intimated by the respondent to the appellant at the earliest in writing.
Also the registrar.
As well, such intimation, similar intimation shall also be made to the registrar original site, who shall take necessary steps for transfer of the amount lying deposited with the by the registrar previous, after deducting the necessary poundage till date. Next para.
From November, if they can transfer that.
Whatever amount is lying. The first such such new account shall be opened positively within, how soon can you open it?
15th of October, my lord, because of I'm taking some.
No, yes, the vacations will be there intervening.
Yes, that's why I'm saying 15th of October, or my lord, let October be.
Yes.
So that by first week of November.
On or before October 31, 2025. Full stop. Next para. The transfers and the fresh deposits to such account shall commence on and from the in and from the month of November 2025. Full stop. No arrest to costs.
Stop. Very deep reflections.
Next.
Item number 8. In the goods of Shishi Kumar Bhattacharya.
Item number 8, Your Lordship, I'm appearing for. There was a direction upon us formal paper books due to the voluminous nature of the papers, and it's a very old record, so we could not.
How soon can you file?
After vacation, we'll file. We'll file and serve.
Will give after the vacation?
Yes, Your Lordship.
On the prayer of learned counsel for the appellant, comma, and keeping in view the voluminous nature of the papers, comma, we extend the time filing paper books till November 7, 2025. Full stop. Let the matter be listed next in the listed next on November 12, 2025.
Much obliged.
Next.
Item number 9.
Your Lordship, I am for the appellants. I am led by Mr. Ratnako Banerjee and Mr. D.N. Sharma. They are not in Calcutta.
The D.N. Sharma appeared online.
Yes, Your Lordship, he is not able to join now. This might be kept.
What are your instructions?
To oppose.
Your Lordship, it's a voluminous matter. It is to be now.
Every matter is voluminous. So
No, I disagree with that. I have not.
it's not voluminous.
It's not at all voluminous. We've been running around in circles with the matter. It is assigned, beloved, before your lordship. And since Mr. Banerjee is not there, beloved, kindly keep it immediately upon reopening, and we shall, beloved, come and do the matter.
On the prayer of the appellant, comma, let the matter stand adjourned till October 29, 2025.
Grateful. Can't object to Mr. Banerjee's request. And Millard, it's I know he's traveling for work, and this is something, Millard, is not voluminous. There are orders which have been. Everything is decided. Just one order is to be request for.
Item number 10. Kolkata Municipal Corporation.
10, my lord, I appear for the app. I'm being led by Mr. Joydeep Kaur.
Not here. Yes, what?
Opposed lordship, this is a short point there. Condonation of delay application affidavits have been called. Why, on the basis of a Supreme Court judgment which state that section 34 appeal, there was a delay of 227 days that was not condoned. The judgment is a long, very longish judgment. And here is a delay of 547 days.
No, the number is not important. That's well said.
It was not condoned on the legal.
That judgment is.
No, but yes, every section 5 is distinguishable from the other.
Yes,
Apart from Justice Pardiola's recent judgment,
yes.
those are on principles. So don't rely on those because that will.
No, I'm not.
boomerang on something.
It's not on the fact, but on the legal aspect, lordship. If you see that.
What legal aspect in section 5?
Yes, lordship will see that judgment once.
My section 5, he is moving it, my lord. My
Section.
And I'm not moving, but they are seeking
But the
time.
section 37 appeal, my lord, is further more interesting, my lord. Claims which are not part of the suit have been relegated to.
What remains? We'll let us decide the matter then.
Yes.
If you are ready in the matter, why not hear it out?
Lord, if it goes otherwise, my lord, I will be held up.
Mr. Kaur will rebuke you.
Oh, Mr. Kaur is there.
Too happy if he does the matter.
I'm sorry, my lord. I'm being led by
Mr. Kaur, you can move the matter. Yes.
Will it be convenient? Shoot it. Sir, I tell your lordship.
Open up,
frankly,
Mr. Kaur.
I, in fact, thought, Lord, I'll do the other matter, the Billa Lodha matter, which will
Yes.
take some time, but I got stuck.
That is below the matter, the previous one. In
the item number 2, 3. I thought I'll take
That matter
some
I'm
time in
against.
that. That if your lordship, Lord, permits me, Lord, to come back after the vacation on this, if it is not inconvenient. Otherwise,
to us, no, definitely nothing is inconvenient to us. So on the We will keep your prayer then. On
Yes,
the prayer of the appellant, the matter stands adjourned till after the upcoming annual vacation.
She will fix it or it will be.
No, it will remain in this.
First Wednesday. First Wednesday, my lord, will.
Yes, yes. Right.
Thank you. Grateful to you.
Thank you.
Item number 11.
Yes, Mr. Shen. In the previous matter? No, definitely record. No. He was in the court premises, yes. Or virtually if you are connected or something.
Vigorously opposes.
In one matter, he asked if unless she's in a hospital or in a police station, her name can record. Because our order would be bad.
One day, these grace marks are allowed.
Definitely. Absolutely. So this is item 11, Mr. Banerjee, you are there.
None of us are for the appellant.
Banerjee family is
Item 11 to recall.
yes.
Is also there. This is the problem.
Mr. Basu, you are with them.
Yes, all of us
That's
are together.
give
The appellant, nobody is
Polluted them.
Should be allowed.
Polluted them.
So none appears for the appellant.
ব্যাপারটা আমাদের অ্যাপিলটা তো লিস্টে নেই এখানে
এই দরকার আমাদের application item
You also have an appeal that is appearing today.
No, that is not there.
Just give the number, we'll direct that to appear along with this.
Assigned, specially assigned.
None appears for the appellant at the time of call. Learned.
Specially assigned.
So let us text.
We'll just adjourn it till after the week. None appears for the appellant at the time of, although the respondents are represented through counsel.
He is for the appellant.
Mr. Tapas Kumar Sinha appellant, my lord.
Is that Taposh?
Tapas Kumar Sinha, my lord. He's on leg, my lord. Kindly make it after vacation.
On the prayer of the appellant, let the matter stand adjourned till after the upcoming annual vacation. One of the shop naam record.
Matter কি বলে?
But this is regarding to the temple.
So
One appeal and 2 PILs.
so what? Well, you should release it.
No.
So there is one. কেন তুই এটার মধ্যে ঢুকছিস করছিস তুই বারবার না
ছুটির পরে
Maybe, but
after vacation.
No, just 2 PILs and 1 appeal. That's all.
ঠিক আছে পরে
All have been assigned together.
PIL has also been assigned to us.
Because that was the last order.
because the subsequent one is based on the PIL.
Because the learned judge said the other division bench getting said all these should be heard together. So that's
They want modalities regarding the functioning of.
they have made a lot of allegations, which I'm not going getting into.
That rest aside by an appointment of a special officer, your next chief justice of this held the election, everything completed.
Everything
Thereafter,
over.
my lord. ঠিক আছে তো ফাইন
Will come.
Item number 12.
My the interesting situation has risen. Well, I wish I could have also said after the vacation, but this can't wait. Can't wait.
But maintainability is an issue again.
No, well, we'll come to that. Well, may I tell you?
Wherever they go, we take the part maintainability. We've succeeded so far. Intend to succeed.
I'll tell you, Lordship, what is the
Sufficiently prejudicial to record.
well, interesting matter. Well, there was a mediation agreement between the parties. Mediation agreements led to a mediation. Well, that led to a memorandum of settlement, which is culmination of mediation. Well, a memorandum of settlement, when signed by the parties, assumed the character of an award.
Yes.
We therefore, Malad, sought enforcement of the award and execution proceeding.
Mr. Shah, the mediation and the provision of the 2023 Act has come.
Some of the provisions.
Can come in that has the force of a.
No, Malad, we are now relying on the Arbitration Conciliation Act because Malad, that is not.
Very good.
I'll just see the background.
Then it has to be a conciliation.
Yes, Malad.
There are.
Now, Malad, mediation, section 3 of the Mediation Act says mediation, conciliation, Malad, all the same. Well, I'll just tell you Lordship background. So, mediation agreement, admitted. Mediation proceeding, admitted. Memorandum of settlement signed by all the parties, admitted. That, Malad, brings the mediation to an end. This assumes the character of an award under the arbitration.
Yes.
We filed for enforcement of the award. My learned friend there, Malad, said that, Malad, the memorandum of settlement contains, Malad, clause 50, which is a provision for arbitration. The arbitration is, Malad, for disputes that arise out of this agreement, which is, Malad, the settled, Malad, agreement, the settlement of the parties. Malad, the single judge before whom, Malad, this application was moved, held that no, Ultimately, because of this clause, I don't say that it is a concrete
So
arbitral.
the enforcement will be subject to arbitration.
Yes, now let me know there's some more to it, my lord. Well, enforcement will not be said that the learned judge held that this therefore does not assume the character of a final award.
Yes.
Now, my lord, against that we prefer an appeal. The appellate court, my lord, has now held, my lord, of course, that was not mentioned in the my lord, previous judgment. Appellate court held that no, that is not maintainable because of the provisions of section 13 of the Commercial Court Act. Now, my lord, again, I must point out to your lordship that again, the order of the learned single judge dismissing my execution petition, against the order of the appellate court, my lord, 2 petitions have been filed. My lord, it has not yet received the diary number. In the meantime, what has happened is the settlement agreement. Well, if my learned friend says that it is an concrete award, I can execute. It is not an award, but it is an agreement and has an arbitration clause, then also I can approach your lordships under section 9 for interim protection.
Yes.
My lord, what happened is that, my lord, agreement contains, my lord, a provision, my lord, for transfer of 2 businesses to me. And, my lord, also a provision, in the meantime, the businesses will not be stopped in any manner whatsoever. My lord, however, during this, my lord, interregnum, while, my lord, on the one hand, preventing me from proceeding to execute the mediation settlement as an award, my learned friends are now, my lord, seeking to oust, my lord, the persons who are, my lord, carrying on business with me from that.
The previous appeal was rejected. Now what begins now?
Now, my lord, I file a fresh section 9 application saying that either it is an arbitral award.
Achha.
My lord, now section 9 applies before, during, and after. So,
Yes.
my lord, either it is an arbitral award, I can come up in section 9 for protection of my reliefs.
Yes.
Or, my lord, it is an arbitration agreement containing, my lord, provisions, my lord, which need to be enforced or protected. So I come under section 9. So, my lord, I file a section 9 application. That section 9 application was dismissed by the learned single judge only on the ground that no, but you have taken a stand before that this is an award. Now you're taking the stand that this is an agreement. I said that without prejudice to my contentions, well, this has to be considered because, my lord, once my rights are interfered with and, well, it becomes irretrievable, then, my lord, I cannot, my lord, get back the business once these parties with whom I'm carrying on business are ousted from the. Well, may I just show you, lordship?
You are selling on both boards, Mr. Shah.
I
Cannot
can.
at the same
I'll
time,
tell you,
then you'll
lordship,
be
why. I'll
forum
tell you,
shopping. There's a scope of you forum shopping.
No, my lord, I don't know. There's no scope of forum shopping.
Because you once in one breath you say that it's a
No,
you
my
have
lord,
to
it is
choose,
like
you have to elect doctrine
If
of election.
Well, let us understand one thing. If it is an award, it can still come under section 9. If it is not an award but an agreement, I can still come under section 9.
My lord, may I?
Well, may I just, my lord, complete my thought? Well, the question is, my lord, my rights will not be protected. I will be left without remedy. Well,
Right. So section 9 is applicable either way.
Yes.
Very well. There can be a section 9 along with a section 36 also.
That's right. That's right. Now, my lord, here, my lord, if your lordship, my lord, kindly sees, my lord, the memorandum of settlement once, because, my lord, that is where I come in. My lord, that your lordship will find, my lord, at page, my lord, 120.
What is your principal objection, by the way?
This is also not maintainable under section 13 of the Commercial Codes.
Commercial Codes Act. So we'll deal with that first, Mr.
Very well.
Shah. Just we'll look into Commercial Codes Act. Do you have a copy of the act?
Yes, it has to be an order. This is a self-contained code. It has to be an order under order.
Section 37.
Section 9 is not an
arbitration.
Arbitration. একটা Commercial Codes Act আছে।
No, but
This is section 37 of the Arbitration Conciliation Act.
yes, 37.
Yes,
there's a part of there's an avenue of appeal against section 9.
My lord, this is
Proviso says 13. Proviso is clear and section 37. It's very clear. Provided that an appeal shall lie from such orders passed by a commercial court that are specifically enumerated under order 43 as amended by this act and section 37. So this is 37. And we are acting as a commodity division upon assignment.
Section 37.
You take our book. Take your own book.
Thankfully, Mr. Acharya has just joined. My learned senior.
My lord, having a lot of trouble, electricity coming and going.
Oh,
inundated.
One of the submerged areas.
No, he should
Yes,
be.
my lord, I have a preliminary point that this is not maintainable. My lord, if your lordship kindly takes it up tomorrow, I can come physically, my lord.
No, not be in the
if your
country.
lordship kindly takes it up.
My lord, I will not be in the country tomorrow, my lord. I must confess.
He'll not be in the will not be in the determination. Tomorrow we don't take assignment. Mr. Bhattacharya, why so to 1A is very clear. 36.
No, my lord, there is Mr. Shaha is aware of it. My lord, I will ask my learned junior to hand over a copy that a refusal of an ad interim order is no longer appellable. That has been held where Mr. Shaha was leading me.
My lord, section 9.
My lord will kindly see it was an interlocutory order under
That
order
may be
43.
order 43. That may be on order 43.
Section 37.
No, it has been held what? That order 43 appeal is not maintainable against ad interim.
No, a refusal of an ad interim order is not maintainable.
Please see my lord 31B.
Actually, I'm having a lot of problems. And my lord, this matter has been going on since 2024.
This is not under order 43. This is under section 37.
This is under section 9. But the principles of order, but the principles
will point against you right now. 37 appeal is provided, and this judgment will say, without going into this judgment, will say that this judgment is in regard to order 43. Maintainability.
What I was saying was, so far as the merits of the case is concerned, this has been going on since September 2024. We are
First, let us decide the maintainability, then we'll consider whatever.
Yes, my lord will kindly consider this judgment, my lord.
Right now. At the outset, an objection to maintainability of the appeal has been taken on the ground that no appeal lies against an ad interim interlocutory order within the contemplation of order 43 of the Code of Civil Procedure. It is subject that by the impugned order, an ad interim prayer of injunction has been refused by the learned single judge, and as such, operation of the proposition laid down in such and such versus such and such reported at 2023 1 SCC 634, no appeal is maintainable. Full sub next para, senior counsel also relies on the proviso to section 13 within bracket 1-A of the Commercial Courts Act 2015 in support of his contention that the appeal is in the nature of one under order 43 of the code. So, senior counsel appearing for the appellant controverts such submissions and contents. The proviso to subsection 1A within bracket of section 13 contemplates appeals both under order 43 of the Code of Civil Procedure as well as section 7 of the Arbitration and Conciliation Act 1996. Who sub next para, the dispute arises out of an order passed in a mediation proceeding, from a final order passed in a mediation proceeding.
Pilot will kindly not record that. We are saying that it is not a final order. There is no finality to it.
No,
that is
Mr. Shah's submission we are recording. Final order, which mediation proceeding, which was disposed of in terms of a settlement arrived between the parties. For sub next paragraph, one of the clauses of the settlement incorporates an arbitration clause, there lending a character of arbitrability to the matter. Thus, it is submitted that the the provisions of Section 9 of the 1996 Act are applicable. Next para. As such, it is contended that an appeal lies under Section 37 of the 1996 Act. Next para. Although apparently the learned single judge refused the prayer of the appellant on the ground that previously the appellant had taken the stand that the award passed in mediation was a final award and execution lies, the said issue is a subject of the challenge in the appeal itself, and as such, we are not examining the same at length. Full stop. However, we find from the provisions of Section 13 in bracket 1 hyphen capital A, proviso that a challenge under Section 37 of the 1996 Act is also maintainable against an interlocutory order within the contemplation of Section 9 of the 1996 Act. Since it is arguable, at least arguable, as to whether the interim order, ad interim order refusal by the learned single judge was arbitrable, was under Section 9 of the 1996 Act or not, an appeal is maintainable against such an order. Next para. The proposition laid down in 2023 in sham cell supra is not applicable per se, since the said judgment was rendered in the context of Order 43 Rule 1 of the Code of Procedure and not Section 37 of the 1996 Act. Hence, we turn down the objection as to maintainability of the appeal and take up the appeal for admission.
Yes.
That is the only question in Mr. Shah.
Well, but I have to pray for that interim release. So, my lord, I have to now, my lord.
Then we'll hear you now.
This has been continuing. This has been continuing since September 2024. Kindly allow me to use an affidavit.
September 2024.
No, my lord.
So yes, my lord. This award, this so-called award, is of the 10th of September 2024.
My lord, please
just before the vacation, there cannot be any pressing urgency.
Yes.
Please see the memorandum of settlement with the outcome of the mediation. That is at page 120.
Yes.
My lord, may I request your lordship to, for example, my lord, have a look at, my lord, 123, clause, my lord, G.
Yes.
My lord, with the active involvement and assistance of the mediator, the parties have mutually, amicably, conclusively, and finally arrived at a full and final settlement of all their dispute, differences, claims to their full satisfaction. That is what is recorded here. Now, my lord, will kindly have a look at, my lord, paragraph clause, my lord, 51.
Which page, Mr. Shah?
My lord, clause 50 is at page, yes, my lord, page 142. Now, my lord, just before clause 50,
yes,
well, let's see clause 49.
Yes.
The purpose of this mediated settlement agreement is to bring an amicable settlement to the claims and disputes that have arisen between the parties. The parties have agreed not to institute any legal proceeding or complaint of any kind whatsoever against each other pertaining to the subject matter of the claims and disputes covered here. And then, my lord, skipping over 51, first come to, my lord, 51. Or, my lord, 52. 52.
Yes.
The mediated settlement agreement is final and binding upon the parties and fully and finally settles all claims, demands, entitlements, and disputes between the parties, including those contained in the agreement of such and such. Then 53. Parties have mutual interest in the mediated settlement, have entered into the same after taking legal advice. 54. The parties consider this settlement to be fair, reasonable, and in the best interest of the interests. 55. The parties confirm and declare that none of the parties are acting under any misrepresentation, threat, undue influence. And then, my lord, 56. the parties undertake to sign and execute all such papers, etc., as may be necessary to give complete and proper effect to the settlement. Now, in the context of these, now please have a look at clause 50 at page 142.
Yes.
In the event there are disputes or differences between the parties hereto regarding this agreement, including any question of regarding its existence, validity, or construction. Now, regarding this agreement means what is settled and contained in this agreement. So, our contention was that if there is a dispute which arises out of the settlement, then that can be referred to the arbitration. But you can't refer the disputes that have been settled to arbitration. That was our contention, rightly or wrongly. And ultimately, the learned single judge no, this clause will stand in the way. But the appeal court did not go into the merits of the matter. Of course, the appellate court was pleased to observe that had the appellate court been sitting in execution, it would have allowed the execution. But ultimately,
the appeal has been dismissed on the question of maintainability.
It is not maintainable. Now, if your lordship will please have a look at clause 20. This is where the shoe is pinching right now. At page 134.
Plus 20.
Yes.
Yes.
Now, this is one of the terms of the settlement. It has been mutually agreed that the business total and super spirit that has been carried on till now in the name of Hindustan. Just pausing for a moment. Hindustan was a company being run by our group, which we have handed over to the other side. But Hindustan runs the business of establishing tanks and allowing storage of oils, liquid components, fluids, and in the tanks. Now, two of the companies with which this business was carried, says it has been mutually agreed that the business of total and super spirit that has been now in the name of Hindustan shall belong to the ASA group, that is our group, with immediate effect, and the parties shall immediately inform this to total and super spirit and take all necessary steps and sign all papers and documents for transfer of such business to an entity of the ASA group to be specified by the ASA group. Till such transfer is formalized, the business with total and super spirit shall be continued without which, in the name of Hindustan, though the revenues shall belong to the ASA group and shall be paid by the EPI group to the ASA group after retaining a mutually agreed amount for use of the tanks for such period. The ASA group may either build new tanks on ASA group land or purchase tanks of Hindustan from EPI group at a mutually agreed amount and shift them to the ASA group land. The parties shall consider the possibility of the tanks presently being used for the business of total and super spirit remaining where they are at present, an allotment of the land on which the same located to the ASA group along with the. In such event, the area of the land so allotted shall be adjusted against the land area to be allotted in lieu of the RSF land mentioned in clause 27, and the mutually agreed price of the tanks and infrastructure shall be paid to the group by the ASA group. Now, pausing here for a moment. So therefore, the contemplation was that this business will come to me. I shall either buy the tanks of the other group, including the land which it is situated, or they will my lands which are to come to me in this memorandum of settlement, establish new tanks and take the business. Till then, the business of total and super spirits will continue unabated, and it will continue in the name of the Hindustan. But they will retain a charge for allowing the business to be continued through the tanks. Now, this understanding is there. We tried to enforce this as an award. We could not. We still maintain that it is an award. That is why we have gone to the Supreme Court. But in the meantime, my learned friends contend that no, there is an arbitration agreement. So let's say, even assuming for the sake of argument that this is an arbitration agreement, then the arbitration clause would allow me to approach your lordships under Section 9. And they have now been writing letters saying that after 31st August, we will not continue there. We will prevent access from using the chat. We will not renew the contract. Now, these documents are all on record. The letters start in this regard.
What sort of injunction are you asking, Mr. Shah?
He's saying that they should not disturb the business.
In respect of a third party. That party is not even a party to this proceedings.
Let me finish. Now, this is concerned. This is my understanding. This business is to come to me. If you have this party from the premises or stop business, in that case, the business cannot come to me. You are therefore preempting the whole dispute. You are therefore trying to irreparably.
Which is the party referred to by Mr. Bhatt?
Total and super spirit. Well, they are writing to total.
Not a party to the proceedings or to such agreement.
I'm conscious of that. Well, today the question is you're trying to impair my right. Because, my lord, upon the businesses being transferred to me, well, I would have done what? I would have, my lord, either, my lord, got the land from them and established tanks and carried on business, or, my lord, they would have said that very well, you take the tank and the land, give me a consideration. They have not allowed me to do so because, my lord, they're saying that you can't execute this as an award. Now, let us proceed on the presumption that's an agreement. Can you, my lord, try to terminate this agreement today? Well, that is exactly what I'm trying to do. Well, I had made the same prayer, well, in the appeal. Unfortunately, the prayer could not be looked at because, well, ultimately the appellate court held that the appeal is not maintainable. Well, please have a look at, the reliefs that I've sought here, well, in my application. Well, section 9, well, my prayers. That's at page 65.
Yes.
Well, it says order of injunction restraining respondents, well, from in any manner acting in derogation terms recorded or the obligations imposed in the memorandum to settlement, and injunction restraining them, well, from interfering with the business of total and super spirit. But, well, they are saying that we will not renew, we will terminate, you have to vacate, you have to give up the tanks.
No, total and super spirit is how are the parties related?
Well, they are only, my lord, persons to whom, my lord, tanks have been let out. They are, my lord, storing their oils and spirits in these tanks and they are paying a rent to, my lord, Hindustan.
What is the interrelation between you and the ASA group now at present? You are currently in business with total and super spirit. Regarding those tanks.
Yes.
So ASA has entered into this agreement with.
No, I am ASA.
Oh, sorry, they are Hindustan.
Respondent number 8, had entered into an agreement with Total and Super Spirit for letting out their tanks.
Oh, you are ASA, you are the third party to the.
No.
Yes. No. They are parties. The Total is a third party.
Mr. Bhattacharya, just allow me to conclude. Well, Total and Super Spirits had entered into, a business with Hindustan. Hindustan was owned by ASA. Now, Hindustan has been transferred by ASA Group to EPI Group. And that is what is recorded in the settlement agreement. And under this transfer, it is said that the business of Total and Super Spirits will get transferred to the ASA Group. And in the meantime, it will be continued. That is clause 20, which I showed you, Lordship.
So clause 20 says it has been mutually agreed that the business of Total and Super Spirit that has been carried on till now in the name of Hindustan.
I am a director of Hindustan.
Mr. Bhattacharya is for whom?
Is for the EPI Group.
I am for the EPI Group.
Acha. The EPI Group, how EPI Group, yes. Shall belong to the your ASA shall belong to the ASA Group with immediate effect. Acha. So you have that immediate right under this agreement.
That's right. And will not be stopped.
Yes.
It says it will not be stopped.
Yes.
Now, what my learned friends are trying to do is pending adjudication of the question as to whether pending decision in arbitration, if at all, because my learned friends have also issued a section 21 notice themselves. This right has to be protected. And that is all that I'm seeking. Now, my learned friends are trying to preempt the whole issue, trying to get rid of Total and Super Spirit once they leave. And even when the tanks come to me, I shall have no business there. That is why, I seek this injunction. Now, the question of usual questions of balance of convenience, prima facie case, and irreparable prejudice. The agreement says that it will not be stopped. The business will come to me. Today, stop it. The irreparable injury will be occasioned. I will suffer irreparable loss. And what is the inconvenience that my learned friend will suffer? That is the only thing. I only seek this limited protection because otherwise, pending adjudication of all these finer questions of law, my right will be irreparably impaired. Well, incidentally, I am a director shareholder in the Respondent. Even now, I have agreed to transfer my shares. And they have agreed to pay me money. 20 crores of rupees is lying in escrow with the Mediator. I am asking for release of that money. They will not give me my money. They will not give me my land. They will not give me my
Who are
tax.
the signatories to this agreement?
I'm sorry, Malad.
Who are the signatories to this agreement?
Yes, Malad. The EPI Group and
ASC is there.
Yes. Malad, please have a look at the settlement agreement. All of them have signed.
Acha, yes.
Now, my learned friends interestingly said that I have signed under a mistake.
EPI also signed.
Yes. And EPI said, wrote to the mediator after having signed the document, they are not children, they are not pardonishing women, they are not non-compos mentis. They said that I have signed under a mistake.
No, but why do they say they are third parties?
I do not know.
Bench of the High Court has actually
Mr. Banerjee, please let
Very
Mr. Shah complete. I will address.
Yes, Mr. Shah, so we have heard you.
I am now seeking enforcement of 20, pending adjudication of all disputes without prejudice to my right that this has in fact attained the character award, but saying that even if it has not, I am still entitled to approach your lordships under section 9. That is my case, nothing more.
Well,
yes.
Yes, Mr. Bhattacharya.
My lord will kindly first take Justice Sharka's order. That has still not been set aside. They preferred an appeal. The appeal has been dismissed.
Right. Where is that?
At page
My lord,
21.
that starts at page
21.
21.
Yes.
My lord kindly takes paragraph 40 at page 39. So they are relying on few clauses of that settlement, so-called settlement agreement, but Justice Sharka says it cannot be looked into. It was alleged by the EPI group. Has your lordship found it, Bharat?
Yes, para 40.
Paragraph 40. It was found by the EPI group that no consensus for settlement had been arrived at between the parties in course of mediation. There still existed irreconcilable disputes and differences.
Mr. Bhattacharya, please be precise. We don't have much time.
Yes. But I'll just take your lordship because this is not the...
Yes.
I'll just show the order and just few emails.
Do that.
Agreement has taken into account certain issues which were beyond the scope of reference. This is the finding. This is a finding. This is not the submission. The agreement recorded final settlement of disputes which were never agreed upon. The decisions were unilateral. The rights of the respondents has been prejudiced. No settlement as referred to in the purported agreement has ever been entered into between the parties. The same cannot be treated as a mediated settlement agreement. But this is a finding which has not been interfered.
No. These are not findings. Sorry. These are continuation of your arguments. It's alleged by the ESI group. Although there are full stops in between, it continues like that.
As there were miscommunications. The said
because that is seen from the fourth last sentence. Allegations were also made in the said letter. So it's a continuation of the allegations, Mr. Bhattacharya, not findings of the same.
Then the kindly comes to the next paragraph. The specific contention, page 41, of the respondents that they had signed the document and reduced the same with the impression the same would be forwarded to the mediator for further deliberation before the same can be authorized.
Page 40, where is page 40?
40
There is no
41.
Page, there is no page 40. One page is missing.
There is a missing page.
No, sir, this is actually wrong number 39 and
right.
Wrong. No, sir.
Anyway, Mr. Bhattacharya, let us hear you. Yes, continue.
Yes, one page before and after, my lord. 41. The next.
39 and 40, 39.
Now, my lord, kindly comes to 41. To resolve the dispute, the same would be deferred. The specific contention of the respondents were they had signed the document and reduced the same into writing with the impression the same would be forwarded to the mediator for further deliberation before the same can be authenticated. They were taken aback when the mediator sent a copy thereof by authenticating the same with a forwarding. Now, my lord, the clause has been referred to by Justice Sharka. Thus, paragraph 45. Thus, any dispute between the parties with regard to the agreement in question, including, my lord will kindly mark this, its existence, validity, construction. Mr. Shah is trying to rely on few clauses of the agreement in furtherance of his prayers in 9. But where the existence, validity, and construction is concerned, is this application under section 9 maintainable by relying on the other clauses of the terms and conditions contained therein were to be settled amicably at first? In case of failure of amicable settlement, the disputes were to be referred to blank, the mediator. The mediator was to make all reasonable endeavors, including engaging in discussions and negotiations, to settle the disputes and differences within 60 days from receipt of the request for mediation by any party, and thereafter, in the event the mediator could not easily resolve the disputes to the satisfaction of the parties within 60 days, the dispute would be referred to arbitration. So what are the disputes? He is referring to that mediated settlement, where the existence, validity of which we have challenged and which has been upheld by Justice Sarkar. In my view, the document annexed clearly
What has been
indicates
upheld by Justice Sarkar? What
there
has
was
been
an
upheld
appeal.
by?
That has been dismissed on the ground of maintainability.
Paragraph 46.
My lord, 46, the document annexed indicate that EPI group referred the dispute to the mediator by challenging the existence of the document. The said EPI group was of the firm opinion that signing of the documents which were handed over by blank, brother of the mediator, were not in full and final settlement of the disputes, were signed in furtherance of discussions and deliberations held in the proceedings. How can he rely on this document after these findings? There is nothing on record to show that the mediator had signed the document in presence of the parties or the respondent had knowledge of such signing. Clause 12 of the agreement of August 2 contemplated execution and signing of the agreement. The objections were referred to such and such as mediator had informed the parties that he was not in a position to settle the said disputes in view of the nature of allegations, and he refused to continue to act as the mediator and asked the parties to appoint another mediator or arbitrator. We have referred to them. But what are they saying? We had asked them, appoint an arbitrator, appoint an arbitrator. They sat over it. They never agreed to it. I will show those.
Softer, Mr. Bhattacharya, a bit softer, please. Yes.
I'm sorry. I have a
No, we know. Yes.
Under such circumstances, such stand of the mediator clearly indicates paragraph 47.
Yes,
cannot be treated as a settlement agreement. My lord, if it is not a settlement agreement, how can Mr. Shah rely on the terms of that agreement and say it had attained finality when the arbitration clause says even the existence and validity and construction under section 74, under 90, a final settlement can be treated as an award and enforced as an award. First of all, my lord, he has to take a stand whether he treats it still as an award or not. If he treats it as an award, the section 9 is not maintainable because the period of enforcement is over. He has to make a choice. Today, he has to make a choice whether he is treating it as an award or he is not treating it as an award. Because if he is treating it as an award, his 120 days is over for my challenge, and it cannot be, section 9 cannot be entertained. It has to be enforced as an award. So he has to first take that call. Because he said something that he is challenging before the Supreme Court or something like that. So he has to take the call today, whether he's still treating it as an award or not.
Even if it's not a award, Mr. Bhattacharya, it's you have not denied signing it. You say that
yes,
you have signed
but the validity, construction, validity.
It was an early stage of the discussions. You have said that. I mean,
Yes. But kindly looks at that paragraph again. Paragraph 47.
Yes. That it was one of the earliest steps of arriving at a settlement, but not the final.
Towards arriving at a settlement.
Even if that arbitration clause is there, why not section 9? Either section 36 or section.
No, my lord, Mr. Shah is trying to enforce those clauses which he says has attained finality. If it is attained finality,
no, but either way they are entitled to protection. Why not? Because the court
my lord, then he has to take a. My lord, kindly looks at section 9 because section 36. If he treats this document of 9th of September as an award, 120 days has elapsed for me to challenge the award. So he can only execute it. He cannot find a section 9. My lord, kindly looks at section 9 of the Arbitration Act.
Yes.
I will request my juniors to section 36 of the Arbitration and Conciliation Act.
36 or 9?
Mr. Banerjee, please.
You are relying on 36 or 9?
Yes, the copies are there.
My lord, section 9 is before, during, or after.
Yes.
But before it can be executed as an award.
Before it is enforced.
Before it is enforced. So he tried to enforce it as an award. He tried to enforce it as an award.
Right.
Yes. So does he still stick to the stand that it is an award? If he does, then the section 9 is not maintainable.
Why not? It has not yet been enforced.
They have tried to enforce it, and Justice
Tries to
Sarkar-
enforce it, not enforced.
not enforced. Justice Sarkar said that it is not an award. So he has to make a
Bhattacharya,
stand.
you're not answering your question. We are asking you, section 9 says, but before it is enforced, after the award is enforced, not tried to be enforced or levy of execution. But before it is enforced, section 9 will operate.
Yes,
So
so
section 9 still
enforcement,
continues to operate before it is enforced.
My lord, enforcement is, my lord, kindly looks at section 36. It is under order 21.
Right.
It is under order 21. So he filed an application under order 21 trying to enforce it.
No, enforcement is it has to be executed. Enforcement is execution. Before it is executed, that award is executed, section 9 operates.
My lord will kindly, my lord, my lord will
Before
kindly
it is
take the.
enforced. Enforcement is after the appeal period is over, then you can have it enforced.
Well, kindly gives me a moment, my lord.
And come to subsection 2 of section 36 also, where an application to set aside the that is different. Sorry, that's not important. So whether you treat it as 36(2) or 9, I mean, all the same. I mean, protection should be available to them. There is a dispute, no doubt on that. You have signed the agreement containing arbitration.
Yes. No, but can the terms of that agreement, and he is trying to espouse the cause of a third party. Now, my lord kindly takes the order of Justice Sarkar once more, page 43.
Yes.
Under,
Bhattacharya, please, as quick as possible, because we are considering only adding.
Yes, my lord. Under such circumstances, such stand of the mediator clearly indicates that the memorandum of settlement cannot be treated as a settlement agreement. He is trying to enforce the clauses of the agreement.
Yes, you've made that submission.
Yes, as contemplated the final set. Now, paragraph 48 is of importance. Under the 1996 agreement, a settlement agreement can be arrived at by the parties.
This order, it's only said that the arbitration clause is there. It's not a final settlement. That dispute
No,
has
this
been raised.
document is not a settlement at all.
Yes, that has been held. We'll proceed on that premise.
And a section 9 post award is for protecting the fruits which you have received under an award.
We'll consider that
Justice
argument.
Sarkar is saying that this is not an agreement at all.
No, Justice Sarkar does not say that. Justice Sarkar says this is not a final settlement.
And yes, so the entire document is not a final settlement. And my lord will kindly now
Mr.
take.
Bhattacharya will pass our orders because we don't have.
My lord, just few emails, 166 onwards.
No, we won't go.
So my lord will kindly look at it. My lord will kindly look at it. I have been asking them to go to arbitration, and my lord, these disputes are there since December 2024. My lord will kindly see.
Even if you say that, then also section 9 operates.
Yes, my lord will kindly look at the conduct. My lord, 166 onwards.
The dispute involved here, the dispute involved in the appeal is in connection with the purported memorandum of settlement arrived at between the parties in a mediation proceeding, dated September 10, 2024. Full stop, next para. Whereas the appellants contend that the same was in the nature of a final award by way of settlement in mediation, the respondents dispute that the said agreement was a final settlement in the mediation proceeding. Full stop. The contention of the respondents is that the said agreement was merely a preliminary step in attempts of the to arrive at a settlement, but not a conclusive award. Full stop. Next para. The appellants have admittedly sought to enforce the said settlement agreement by deeming the same to be a final award passed in the mediation. Full stop. Next para. However, a learned single judge of this court, while dismissing the said enforcement application bearing EC Com 9 of 2025, by a judgment dated May 20, 2025, observed that that agreement did not tantamount to a final settlement within the contemplation of the Arbitration and Conciliation Act 1996, read with Order 21 of the Code of Civil Procedure. Full stop. Next para. The appellants in the meantime, have challenged the, you have preferred a challenge against this. Preferred a challenge against the order dated May 2025 before the Honorable Supreme Court. Full stop. The
Supreme Court, my lord, I thought it was before the division bench. Before Justice Boschak, which has been dismissed.
We challenged it before
the division
and
bench.
division being dismissed it, now we have filed an SLP.
Which challenge was dismissed by the division bench, upon which a special petition has been preferred by the appellants before the Supreme Court, which is now pending. For sub next para, learned senior counsel appearing for the appellants argues that even if it is construed, even if the agreement is not construed as a final award, the provisions of Section 9 of the 1996 Act are applicable, operates till award is finally enforced. Full stop. Next para, even otherwise, Section 36 of the 1996 Act would entitle the appellants to execute the award. Full stop. Next para, by the impugned order, an application by the appellants was actually in terms of clause 20 of the was turned down on the ground that the appellants themselves, having treated the agreement to be a final award, cannot now resile from such position and treat same to be an arbitration agreement, leaving it open for the parties to take recourse to arbitration and seek a relief under Section 9 of the 1996 Act. Upon a careful consideration of the arguments, we find that the respondents are justified in arguing that the appellants cannot take the benefit of the best of both worlds, simultaneously treating the agreement between parties to be a final award past mediation, and on the other hand, treating the same to be merely an agreement between the parties containing an arbitration clause, which would give rise to a genesis of a dispute in arbitration. Full stop. Next para. However, even if we accept such submission of the respondents, the court, when approached for protection in aid of a particular clause of an agreement which contains an arbitration clause, cannot shut its eyes due to the mandate of Section 9 of the 1996 Act. Full stop. Next para. The scope of Section 9 is wide enough to encompass disputes between the parties where there is an arbitration agreement between them, before, during, before or during the arbitration proceedings, or double inverted at any time after the making of the arbitral award, but before it is enforced in accordance with Section 36, double inverted close, full stop. Next para. In the present case, if we deem the agreement between the parties to be a final mediation award, having the effect of a decree, still then, the award has not yet been double inverted enforced. Full stop. Next para. The initiation of an enforcement proceeding under Section 36 of the 1996 Act cannot be equated to an arbitral award having been enforced. Full stop. The term enforced used in Section 9 within bracket 1 contemplates, undoubtedly, a situation where the award has already been enforced thereby giving a termination to the arbitral proceeding, and not a situation where the award is yet to be enforced and only an initiative has been taken for such enforcement. Full stop. Next para. Even otherwise, comma, if we proceed on the premise that the agreement between the parties is not a final settlement and stroke a final award passed in mediation, comma, the respondents themselves have referred the dispute to arbitration by issuing a request under
No,
section.
my lord, that was pursuant to what had fallen from Justice Boshak, that are you willing to go for arbitration? We sent him a letter saying, yes, we are. They refused. They refused to go in for arbitration.
Let us complete our judgment, please. কোথায় ছাড়লাম? A request under Section 21 of the 1996 Act, comma, apparently pursuant to an observation made by the division bench in the challenge against the order May 20, 2025, full stop. Even if the appellants have refused to accede to such request, comma, fact remains that the existence of the arbitration clause and or the agreement containing the same is not disputed by either of the parties. Full stop. The dispute is as to whether the said agreement tantamounts to a final settlement in mediation and has the effect of an award. Full stop. Next para. Thus, comma, even if the agreement is not deemed to be a final settlement between the parties in mediation, comma, the arbitral, comma, including the arbitration clause contained therein, comma, thus justifying protection being given by the court under 9 of the 1996 Act. Next para. As such, comma, either way, comma, whether the agreement between the parties is ultimately found to be a final award in mediation or not, comma, the existence of the arbitration clause remains and the disputes under the said agreement are referable to arbitration. Full stop. Next para. Thus, comma, at least a sufficiently strong prima facie and arguable case has been made out to give rise to a triable issue between the parties. Full stop. Thus, comma, we are of the prima facie opinion that the judge, comma, in the impugned order, comma, erred in law in refusing to consider grant of interim protection to the parties. Full stop. Next para. Mr. Bhattacharya will grant him order. Should he dispose of the appeal and direct the request the learned single judge to do that, or keep it open here for?
I will just beseech your lordship to look at one document, page 328.
No, we gave you
page
that option.
328. This is of May.
No. We're in the midst of an order. We gave you an option. If you don't take that option,
My lord, then my lord passes an order and let the learned judge dispose of the application.
Full stop. In view of the fact that the existence of the arbitration agreement and existence of the agreement comprised in the purported settlement between the parties has not been disputed by any of the parties, and in view of the said agreement containing an arbitration clause in clause 50 thereof, comma, we are of the opinion, comma, that till the issue is resolved as to whether the agreement tantamounts to a final settlement or not, comma, the dispute between the parties under such agreement remains alive, comma, entitling the appellants to an order, a protective order as prayed for in terms of on the strength of clause 20 of the said agreement between the parties. Full stop. Accordingly, we grant injunction restraining the respondents from respondents and or the agents from interfering with the business carried on by the appellants with total and super spirit, comma, either by seeking to terminate.
I'm sorry to interfere. My lord, will kindly see prayer C. It does not say with the appellant. Kindly see prayer C, my lord.
Comma, including by refusing to renew contracts or by requiring them to stop using the tanks referred to in the said agreement between the parties, or by seeking to recover the said tanks from them, or by preventing their access to or use of the tanks and related infrastructure for the purpose of storing and handling petroleum products, or in any other manner whatsoever, till November 30, 2025, or until further order, comma, whichever is earlier.
My lord, subject to them making payment for that, my lord. Otherwise, they will refuse to make payment.
The above injunctions shall operate subject to the payments contemplated under the agreement in question being made by the appellants, full stop. In the event of default of such payments, comma, the interim order shall stand automatically vacated without reference to the court. Full stop. The respondent shall file their affidavit in opposition to GA Com 1 of 2025 within November 14 would be a good time. Number 7. You're getting the entire vacation. November 7, 2025. Full stop. Reply, if any, shall be filed by November 21, 2025. November 7, by November 14, 2025. Full stop. The application shall be listed. This is not an this is an assignment to us.
Assignment. Yes, yes.
Shall be listed next on November 19, 2025. Very great. Thanks.
Before your lordship start with this matter, by some protection, my lord, I am the erstwhile mediator.
This matter?
This matter, my lord. I am the erstwhile mediator. I am holding 20 crores, which was given by the respondent, and some documents. Now, my lord, the mediation agreement, if your lordship sees, puts an...
You're appearing for the mediator, or you are the mediator?
I am appearing for the mediator, my lord. He's also a legal professional, my lord.
Right.
Kindly see only clauses 7, 8, 9 of this agreement. This provides that if the mediation fails or is terminated for any reason whatsoever, I will hand over all the securities given to me by both sides to an officer appointed by the court. Kindly appoint somebody, because I am now facing notices, my lord, threatening me with legal action, which, my lord, is very difficult for me, my lord, as a lawyer.
Let me see the name once.
Kindly see, my lord.
The name of the mediator?
My lord, name is...
Pass me the signature.
Mr. Rajiv Ginodia.
He is Mr. Rajiv Ginodia, my lord. He has put in some years in this profession.
No. He's a very respected man, my lord. He's a very respected.
My lord, kindly, my lord. Divested, my lord. Allegations have been made against bias, my lord, by the respondents, my lord.
No, whichever party.
Well, I'm not naming the parties, but
We'll
allegations...
give you a cloak of protection by making an order.
Kindly divest.
We'll make you the special officer. No. Choice is yours. Either you or your client.
I cannot. They reposed faith in him initially, your lordship.
Either you or your...
Let him continue then. Let him. I cannot take that responsibility. They repose faith in me.
No, they have not said that you are biased.
No, my...
As yet.
I am not aware of this letter.
Yes, therefore, you as Mr. Tucker.
No.
Mr. Tucker, if you can hand over copies.
Something involved, I can't even think of holding 20 crores.
If you can't yourself hold it, then why are you asking to appoint some other person as
well? Either Mr. Ginodia continues or your lordship.
Mr. Ginodia. Next para, at this juncture, comma, learned senior counsel appearing for the mediator.
Erstwhile mediator.
For the erstwhile mediator, submits that the mediator is holding a sum of money deposited with him during mediation, and
also certain documents.
As certain documents of importance. Next para, learned senior counsel submits that the said amount and the documents may be directed to be handed over to any special officer appointed by this court in order to obviate any future allegations against the erstwhile mediator. Next para, we do not see any particular reason as to why aspersions should be cast at this juncture by the court on the erstwhile mediator on any count. Next para, accordingly we appoint the erstwhile mediator, Mr. Rajiv Ginodia. Mr. Rajiv Ginodia, comma, as special officer for the purpose of holding the amounts and documents deposited with him in the capacity of erstwhile mediator until further orders by the court.
May I
But
file the certified
that will
copy
be
of the
without
impugned-
revolution, sir.
No, no, without revelation. Of course. not.
certified copy of the impugned order, that
আচ্ছা,
will
বেশ। সবকিছুর আগে প্রথমে একটা লিখে নাও। Certified copy of the impugned order is passed today, is filed today in court and be kept on record.
Very grateful for the protection.
Thank you. Sorry, Mr. Bhattacharya.
No, 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 no.
We don't have, simply don't have the time.
Grateful.
Yes.
Grateful, my lord.
না, ওই মিডিয়েট এই বাঁচিয়ে দিলাম আমরা স্পেশাল অফিসার টেক পেমেন্ট। Yes.
Any mentioning, please?
Lordship, in this matter,
From that set.
interim order, interim order passed on 4th September 2025. Respect to item number 43 today will expire on 26th. That is the Friday.
Today it will appear for extension of it tomorrow.
Lordship may be permitted to mention a matter pertaining to testimonial appeal. The matter, Lordship, the dispute
What do you want?
amicably settled, and I am deciding to withdraw the matter.
It is appearing in the list.
No.
Hand over the slip has to be mentioned.
Two applications in connection with two appeals in mining matter.
Mention after the vacation. Mention after the vacation. We have only 1 day left.
Might happen.
We have only 1 day left in the division bench.
Maybe encumbered by giving another.
We don't have time. You should have mentioned earlier. We are regularly taking up. Mention after.
One application matter. The order of shifting was under challenge matter.
Mention after the vacation. Yes, Mr.
Lordship, on Monday, Lordship, your Lordship has granted leave to move this matter today itself, but it is not in the list.
Not in the list. List নেই কেন? লিভ দিয়েছিলাম আজকে অ্যাপিয়ার করতে। কালকে যেন পজিটিভলি থাকে লিস্ট। Yes.
On the month of January, Malad had passed an order regarding visitation, Malad. Something has happened, Malad. We have filed an application, Malad. Let it happen tomorrow, Malad. Because
Before vacation, impossible.
Malad, if the file comes, Malad, because Malad, during vacation, Malad, the visitation is affected, Malad. That's it.
Continue during the vacation. After that, we'll consider.
Fine.
Not before vacation.
My lord, may I have a lordship's leave, urgent leave to file a matter, my lord. Now, what happened is that, my lord, Group 8 matter. Now, my lord, vacancy notification, I am also an eligible candidate, my lord. The subdivision controller admits me as an eligible
Group 8, we have determination?
Yes, my lord.
Yes.
The subdivision.
What are you seeking now? Leave to?
Interim order, my lord. I am filing an appeal, my lord. The learned judge has not considered my interim order. My lord, and has posted the matter.
Hand over the slip. If the file comes, we'll give it tomorrow.
Slip, no, my lord. I am seeking for leave to file the matter, my lord.
Why are you seeking leave? Why is leave
Because,
required?
my lord, the learned judge has not. So, my lord, the 15 September, the order has been passed. 19 September, the order has been uploaded, my lord. On 27 September, I have filed with the.
Without certified copy. That
Without
is
certified copy.
Yes, yes, leave is.
To appear tomorrow, my lord. Seeking, my lord.
Leave is granted. কালকে যেটা দিয়ে
কপি কেন? একটা কপি আছে। কপি দিতে হবে না। ঠিক আছে আমি আরেকটা নিয়ে নিই। আর লিভ তো একটাতেই গ্রান্ট।
Yes, call on the list. এটা লিভ দিয়ে দিন আর কালকে লিস্টে লাগবে না এটা।
Item number 1 for judgment.
Accordingly, FMA number 12/25 is allowed on contest, thereby setting aside the impugned judgment dated May 6, 2025, passed in WPA 26226 of 2023, as well as setting aside number 5 dated September 19, 2023, passed by the DL and LRO, rejecting the application for renewal made by the writ petitioner. The DL and LRO Purva Bardhaman is hereby directed to entertain the application for renewal of leave made by the writ petitioner in the light of above observations and grant such renewal, subject, of course, to the restriction imposed under Rule 12 of the rules 2002 rules, as well as Clause 3 of the original mining lease dated such executed by the state government to the government in favor of the writ petitioner not being applicable. You can reject subject to not being applicable. Such exercise shall be concluded as expeditiously as possible, preferably within 30/2025. Can is also consequently disposed of, no orders to cost, urgent certified copies. We have granted you time till November 30th because you will get the time to prefer an appeal.
Well, in the meantime, vacation, my lord, some time be extended, my lord, if it is possible by your lord.
No, in the meantime, vacation, that's why we have given you to not till October 31st, November 30. We reopen on 24th October. We have given you more than 1 month after that.
Grateful.
That is the reason we have given you so much time.
Diploma.
ভুল ডেট দিয়েছিল সার্ভারটি পুরো Yes.
Item number 2.
My lord, item number 2, my lord, identical matter was, my lord, passed by your lordship earlier. My lord, same matter, my lord, same judgment. It is, my lord, the case is this, the revenue officer who has, my lord, preferred appeal against the owner. This is the question. And, my lord, two petitions was my lord moved. One petition disposed of and another petition is there.
Notice
No, with notice. Yeah.
with notice.
We have corrected the copy.
You were copied to my learned brother of our judgment.
Yes, yes.
No, no, previous.
Yes.
Yes, what do you say we are passing similar order?
My lord, before your lordship passes this order, my lord, I'm led by Mr. Jonathan Shamanto. As
Nothing
per
doing.
Mr. Shamanto, my learned senior colleague's contention is that the state cannot prefer an appeal.
No, no, not
No,
that.
no.
That the BLLRO himself could not prefer the appeal on behalf of the state. State can definitely prefer an appeal. State can definitely prefer an appeal, and in the previous order, we made that clear that nothing order shall preclude the state from preferring a fresh appeal. BLLRO cannot act as the agent. We are passing a similar order. The matter is mentioned on the ground that a similar writ petition had been previously disposed of by us on September 24, 2025, being WPLRT number 335 of 2007. For the next para, the motion before us is whether single judge, whether the tribunal, whether the West Bengal Land Reforms and Tenancy Tribunal was justified in passing an order in entertaining an appeal against an order passed by the BL and LRO within bracket revenue officer under the West Bengal Estates Acquisition Act 1953 within bracket the 1953 Act bracket closed at the behest of the BL and LRO himself. For the next para, although the appeal was preferred before the tribunal on behalf of the state, the question arises as to whether the state appeal could be preferred by the state through the BL and LRO acting as an agent of the state, in view of the BL and LRO himself being authority which passed the impugned order. Full stop. Having heard learned counsel for the parties, we find that there is substance in the contention of the writ petitioner. Full stop. Next para. The state has attempted to defend the filing of the appeal on the ground that the revenue officer within bracket BL and LRO bracket was the authorized person designated to prefer the appeal on behalf of the state and did not prefer the appeal in his individual capacity. Full stop. Section 4 of the 1953 Act is cited by the state, which provides that the state government may from time to time by notification make declaration with regard to vesting of an estate. Full stop. We are also apprised by the state of the fact that for the lands in question, an appropriate notification was issued by the state. Full stop. Next para. However, there is palpable absurdity in the argument of the state. Full stop. As held in our earlier judgment in the unreported case of Sri Vishwajit Das versus State of West Bengal and others within bracket WPLRT. Oh, that is 334 of 2007. এই প্রথমে যেটা বললাম না একটা জাজমেন্ট হ্যান্ডওভার করেছে সেপ্টেম্বর 24, 2025 যেখানে লিখেছি ওখানে ওখানে করে দাও একদম ওটা সেপ্টেম্বর 24 না সেপ্টেম্বর 11, 2025 আর নাম্বারটা হবে WPLRT 334 of 2007 কি হ্যাঁ হ্যাঁ Vishwajit Das versus State of West Bengal and others within bracket WP LRT 334 of 2007, comma, the office of a particular authority under a statute does not change its character merely by a new individual assuming office in place of the earlier incumbent. Full stop. Thus, comma, the BL and LRO, while preferring the appeal in question, comma, acted in his capacity of BL and LRO, comma, even if the officer manning, MANNING, the post had changed. Full stop. Next para. Under the 1953 Act, comma, section 57, capital B within bracket 2 within bracket small b provides that it is the revenue officer who has to make an adjudication within the contemplation of the said provision. Full stop. Next para. Hence, comma, the current revenue officer who preferred the appeal, comma, despite him being a different individual than the one who passed the original vesting order, comma, retains the character of a revenue officer within the contemplation of statute. Full stop. Next para. It would cause judicial anarchy and hierarchical chaos if an adjudicating officer, comma, under AEGIS of a statute, comma, makes an adjudication and simultaneously feels himself by such order and prefers a challenge against the same. Full stop. By way of such challenge, comma, a power of review is, comma, in effect, comma, being incorporated into the statute, which is otherwise not permissible. Full stop. Next para. Although, comma, in the present case, comma, the appeal was preferred in the name of the state of West Bengal, comma, the state is relegated merely to a name lender in view of the practical reality that the affidavit in support of the appeal was affirmed by the BL and LRO, comma, who adjudicated the order impugned in the appeal itself. Full stop. Such change of avatar, AVATAR, by the revenue officer, comma, by conveniently representing himself as the representative of the state, comma, vitiates the very premise of the adjudicatory process contemplated under the 1953 Act and imparts an element of palpable bias to such adjudication. Since the officer passing the order is himself preferring the appeal. So next para. The confidence reposed on the revenue officer by the legislature in entrusting him to make an adjudication incorporates an element of neutrality of the said officer. Full stop. Thus, comma, the revenue officer who himself passes the impugned order cannot come within the ambit of a double inverted person aggrieved double inverted clause with such order within contemplation of section 57 capital B within bracket 4 of the 1953 Act. Full stop. It is unfortunate that the state resorted to such practice by taking an affidavit from the current revenue officer while preferring a challenge on its behalf against an order passed by the revenue officer himself. Full stop. Hence, comma, the effort before the tribunal, comma, in its present form is ex facie not maintainable. Full stop. Next para. Accordingly, comma, the learned tribunal acted without jurisdiction in turning down the challenge to the locus standi of the BL and LRO in affirming the affidavit on behalf of the state appellate in connection with the appeal. Full stop. Next para. According to WPLRT 335 of 2007 is allowed on contest, comma, thereby setting aside the impugned order dated April 17, 2007, passed by the second bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 1083 of 108307 within bracket LRTT and dismissing the appeal preferred by the state with the revenue officer bracket BL and LRO bracket close as the person affirming the appeal, comma, bearing appeal number 77 within bracket T bracket closed stroke 2006, comma, on behalf of the state. For sub next para, in view of the long pendency of the present writ petition, comma, The principles of Section 14 of the Limitation Act would be applicable if a fresh appeal is preferred by the state against the order impugned in the appeal. That is, appeal number 77 within bracket T closed stroke 2006 through a different officer. Full stop, next para. It is made clear that nothing in this order shall preclude the state from preferring a fresh appeal within a reasonable period of reasonable from this date, comma, without involving BL and LRO in any manner whatsoever in the filing or conduct of such appeal. Full stop, next para. If so preferred, comma, such appeal will be decided independently of the present order and in accordance with law, comma, upon giving opportunity to all concerned. Stop. There will be no less to cost, urgent certificate costs.
If appeal fails, consequential benefit will be given persons. The
Consequence
benefit. That is LR will be stopped.
No, we are not directing anything. If they prefer an appeal, then it will be subject to appeal. You can always ask for enforcement of that. Next.
Item number 3.
My lord, my matter, I am for the appellant, my lord. They come at my instance, my lord.
Yes.
Well, the only thing is, my lord, can you look at the order passed by? I mean, এই যে order. দেখো পড়ুন। এটা হয়ে যাবে।
Yes, it has been settled.
Well, we are, my lord. In midst of, my lord, we want some more time, my lord. Kindly have a look at the order. Appearing
So it was directed to appear 3 weeks after the puja vacation.
Yes, 24th.
So why did you mention it?
24th, my lord. Kindly is 24th.
Oh, 24.
My lord, only thing is,
Year, my lord.
I'm the unfortunate.
If you have still not been able to arrive at a settlement, why should
Only
you?
thing, my lord. Only thing, my lord. I am appearing on behalf of the unfortunate. My lord, normally, my lord, I never appear on behalf of the husband. My sympathy is always with the wife, my lord.
Even if the wife has done? This is gender bias.
My lord,
Reverse gender
my
bias.
lord, kindly during, my lord, when, my lord, I was in the conference in the chamber of lamented, my lord, Shankutas Banerjee, a young man of bookseller, he came up with, sir, here is a book for divorce. Then, Mr. Banerjee, as you lordship know, in his inimically studied in Bengali, I'm rendering it for my lord.
No, my learned brother knows me.
আমি তো জোড়া লাগাই, আমি তো ভাঙি না, ফলে আমার ডিভোর্স বই লাগবে না।
Then you should make a divorce appeal.
No, my lord, only thing is, well, my theory, my lord,
What do you want now? I mean, why have you?
My lord, we puja vacation, impending puja vacation, my lord, God is not coming, my lord. I have been inducted here. I will do my best to get an amicable settlement. But there is no alternative to amicable settlement. See the Palestine.
There isn't.
What is going on in Palestine? What is going on? Amicable settlement. Everybody, super fast they come. Well, I for amicable settlement.
We don't have jurisdiction over Palestine, but this matter we definitely.
Only, my lord, I stand for.
So you want us to? What should we do? Why is it mentioned?
For some time to make kindly during the puja, try to come to an amicable settlement. Let this appear under puja vacation. After puja vacation, it is appearing for hearing, my lord. So kindly direct us both the parties to
appearing in the list for hearing.
Yes, well, 50 when I mentioned that. Yes,
it was appearing. No, it will go back to the list. If
yes, my lord. Only thing kindly direct both the parties here, my lord. You try to settlement. If the settlement fails, the matter will be taken up.
Can we force it upon them?
No. It might kindly have a look at the wording of the very nicely. It has been worded, my lord, by Justice Mothuresh Prasad.
Learned counsel for the respondent that.
Yes,
they have pondered over the issue.
Yes, now we are pondering. We both of us are pondering.
He's not pondering. He's saying that it is not a.
What my learned senior friend has submitted, that's true. But my lord, one thing, my lord. Previously, on two occasions, they said
we shall send it to mediation. Then in the meantime, mediate.
Lord, mediation, my lord. I think
there are trained mediators. They will try to make both ends meet.
Lord, as your lordship, please.
We'll do that. We'll do that, and we'll give you liberty to come back.
It will come before.
My lord, kindly one humble prayer, my lord.
There's a timeline in mediation, 60 days or something like that.
Lordship.
If it fails within that, then it comes.
Yes, my lord. Third party intervention is required sometime, my lord.
No,
Third
they are trained mediators. We have actually taken a training in mediation, and we have seen my views have changed somewhat. Yes, mediation is very effective.
Very well. No, my lord, and moreover, my lord, it will be helpful for us, my lord. I am appearing on behalf of the, so I may be biased. And maybe biased. My
No
lord,
counsel is ever.
my lord, unfortunately, I have got the other views, my lord. Here we come. Our is we have to come here. Our commitment is to
Learned
look-
counsel for the appellant submits that there is still a chance of settlement between the parties. Full stop. An order dated the copy of an order dated September 26, 2024, passed in the appeal is handed over to us, where whereby a coordinate bench had adjourned the matter, exploring the opportunities of settlement. Full stop. However, we are apprised by the respondent that there has not yet been any settlement between the parties. Full stop. Next para, be that as it may, keeping in view the nature of the dispute, which is a matrimonial one, we are of the opinion that there may be a possibility of settlement by way of mediation. Full stop. Accordingly, we send matter to the High Court Mediation Committee for the purpose of having mediation between the parties. Full stop. The file be sent immediately to the said committee for such purpose. Full stop. Next para, liberty is given to the parties to mention the matter for inclusion in the list for hearing. If in the event the attempts at mediation fails. Full stop. Next para, we request the Calcutta High Court Mediation Committee to engage a psychologist as one of the mediators in order to facilitate an early settlement between the parties.
Well, and a doctor, my lord, because you see there is some medical problems at there. Psychologist.
No.
My lord,
Psychologists are more trained to mediate between parties because they know your psychology, they'll know their psychology.
Well, I beseech your lordship to make it part of my lord.
How can we, after sending to mediation? Can we?
My lord, mediation fail. My lord, only thing is then my lord, your lordship knows it is easier to get the matter heard than to list.
We cannot make it part heard. We refer it to mediation.
Then my lord, mediation, I have to come back.
Yes, you have to come back.
Come back before your lordship.
If we are there in this bench,
Then I make it part heard. My lord, that's why my
we cannot make it part heard. If you make it part heard, that is contradictory to sending to mediation.
If mediation fails, then we have to again do.
Next matter, please.
Item number 4.
My lord, item number 4. May I have your lordship's kind leave to appear virtually, my lord?
Yes,
My lord, it has come up at our instance. Your lordship was kind enough to pass an order, my lord, elaborate order, my lord, thereafter sending it back to the appellate authority. My lord, the only reason for having this matter mentioned, my lord, I was not minded to appear in this matter before this honorable court today. The only reason that, my lord, the matter has been dismissed by your lordships, my lord, I was praying before your lordships, may this matter dismissal be recorded as disposal, my lord. Just this, because your lordship has elaborately dealt with the entire issue that the matter was initially referred back. This is a second round of litigation. We were, my lord, kindly takes up page paragraph 32 of the order, my lord. My lord, it was the private respondent's fault that has led, my lord, made your lordships to impose cost on them for the inordinate delay that they are being continued with.
The dismissal is absolutely. Why should we?
My lord,
we dismissed it because a challenge was preferred to order of the tribunal remanding the matter. So
yes.
Unless we dismiss the appeal, how can we say that the
my lord, I was just praying before your lordships this because
no. The matter has been mentioned on behalf of the appellant for the purpose of altering our judgment dated September 16, 2025 to the effect that the dismissal of PLRT 144 of 25 be converted to a double inverted with the disposal. Next para. However, upon elaborate hearing and on assigning reasons, we had categorically dismissed the appeal and affirmed the order of the learned tribunal remanding the matter. We had also imposed costs on the private respondents 5 and 6 why we should alter the portion of the order whereby we had dismissed the appeal, we dismissed the writ petition. Full stop. Accordingly, no further order need to be passed since the matter has already been disposed of. Next.
So very grateful.
Yes.
Item number 5.
Item number 5, I am for the petition. My very inadequate.
What is the inadequate?
My fault, my lord. My lord, kindly see order, my lord. Order was passed, my lord, to consider my representation. Consider my representation within 6 weeks from the 6 months from the date of communication. But order was passed on 9 December 2024. I am later part I communicate, but they have not considered it.
So why your fault?
Later part I consider. I have communicate, but there is some delay, my lord. So they have not considered it, my lord. And today is my lord, long day past, my lord, they have not communicated.
No, you want setting aside of this order, though.
Yes, my lord. They have
Within 1 month from the date of receiving.
They have started.
When did you communicate? After 6 months?
Yes.
Then you are not entitled to any relief.
Yes.
Why should you interfere with this order?
Not.
You should have approached the tribunal itself for extending the time. We give you that liberty. We are not doing anything.
PLLR with his milk of human kindness, he has already initiated a proceeding.
So he has started considering.
Yes.
He has started considering.
Then there is no scope of interference.
Yes. Should notice.
We'll record an expression that the BLR will dispose it as a early.
This would be retained with the record.
Yes,
This
absolutely.
gentleman has sent me.
Why not?
So here,
Learned counsel, the petitioner submits that by the impugned order, the Land Reforms and Tenancy Tribunal had directed the BL and LRO, Salani, District Paschim Medinipur to dispose of the representation of the petitioner in accordance with law after giving opportunity of hearing to all interested parties within a period of 6 months from the date of communication of the order. Which of next para, learned counsel, the petitioner submits that due to unavoidable circumstances, the communication was made beyond such period, as directed by tribunal. In the latter part of the impugned order dated December 9, 2024, the petitioner was directed to serve a copy of the original application with its annexures and a copy of the order of the tribunal upon the concerned authority within 1 month from the date of the certified copy of this order. Next, learned senior government advocate appearing for the state hands over a report filed by the concerned BLLRO, from where it is apparent that a proceeding has already been initiated by the BL and LRO. Next para.
Last 4 lines from the bottom.
Yes, you're saying that is thus, we do not find any reason to interfere with the order of the learned tribunal, which was perfectly justified in the context. Accordingly, WPL 152 of 2025 is dismissed on contest without any order as to cost, thereby affirming the order of the affirming the impugned order dated 9/2024 passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in O3774 of 2023 bracket A TT bracket closed. Next para. However, it is made clear that the mere fact that the petitioner communicated the order along with the annexures and copy of the original application to the BL and LRO late would not come in the way of the BL and LRO complying with the order of the tribunal and making endeavor to dispose of the matter within 6 months from this date. There will be no orders to cost unnecessary. Next.
Service kept in record.
Item number 6.
6 and 7, my lord. I beg to represent the petitioner, my lord.
What about service, Mr. Gali?
My lord, service out of 7. Out of 7, 4 have been hand service My lord, they could not be raised. We have because, my lord, there is as per the instruction I find, my lord, we tried to effect service of the learned advocate representing the applicants before the learned tribunal. He refused service. Instead, he said he served the petitioner directly.
Was there a direction for service on the advocate? He was just, he's not
Yes.
no longer,
Since lordship,
he does not have power. You should have served directly. They served directly.
we have served directly. We have sent, 4 received. No, 4 have received in the mode of hand delivery, and rest, my lord, 5.
All have received?
No. 5 are yet.
There are 18 in total.
18.
4 and 5 makes 9.
9 are yet to lordship.
You serve on all and come back.
Lordship, my lord,
file your affidavit of service will say that complete service has not been effected.
Made on 27th, lordship.
There is some urgency in the matter.
Urgency, my lord, there is.
We'll keep it on 27. No difficulty.
No, 27. Now 27 means reopening. 27.
24th we are reopening. Friday, that's not a single bench.
27th kindly, my lord,
Yes.
because we are facing a contempt.
File your affidavit of service.
Lordship.
Oh, affidavit of service you have filed?
Oh, it's not.
Since the prior service was not completed.
The
Complete
learned
service
counsel,
not there, sir.
we find that the affidavit of service is not yet ready. Push up, it is submitted by learned appearing for the state stroke appellant that service has not yet been completed on all the respondents. Push up, accordingly, the appellant is directed to serve copies of the application on all the respondents and file an affidavit of service to that effect on the returnable date. Push up, let the matter be listed next on October 27, 2025.
Grateful to Lord.
Both matters? 6 and 7. তাহলে plural করে দিও matters, applications. Thanks.
Item number 8.
Yes, Mr. Bhattacharya, what is the matter?
Only email I have served the copy upon the state.
Why?
Full state. Yes, ma'am. But only your
Private respondents are there.
Yeah, but only it is extremely urgent. Why? I am instructed to appear on
For the private.
My lord.
Yes.
It has not been served still today, but instructed to appear. Already served.
So you are ready to contest the matter today? We'll take up.
I'm ready.
Very good. Yes. What is the matter, Mr.
This application, my lord, against the decision of the my lord Respondent and Tribunal, why the tribunal is to my lord set aside the order of the subdivision land and issue the appellate also for annulment of patta. We are the lands. We have been possessing the land and file suit for declaration, and that suit, my lord, was degree. An appeal was preferred against the my lord state of West Bengal. Appeal was allowed and set aside the order, the judgment and degree of the land.
Set aside. So your faculty was set aside.
Set aside. Thereafter, I preferred an appeal, second appeal before the High Court.
Then?
And that second appeal is still pending for consideration.
It has been admitted.
Admitted. It was admitted initially, thereafter it was dismissed for default. Default, thereafter, consequently, it was restored. Old.
Is there any subsisting interim order there?
No interim. However, my lord, I prefer thereafter, my lord, the this order, my lord, there is no whisper in the second appeal, as well as the order of patta. Here, my lord, petitioner has land excess limit. Even, my lord, 1976, my lord, patta was issued. And that order, my lord, I prefer an.
So your patta has been annulled.
Ultimately annulled.
No, ultimately, what do you say? Ultimately, it is the annulment before the first authority, DLL.
Subdivision.
Oh, SDU.
49-2.
This is.
And on the patta was annulled. That day, my lord, private is an appeal before the appellate authority. Appellate was also affirmed the order of the.
No, whose patta was annulled? Private respondent's patta was annulled on your application.
Yes.
So you won the first forum. Then
second part also. Second part, they preferred an appeal before the appellate authority.
Yes, that was a.
That was also dismissed. They had against that order of
tribunal.
Read application.
Tribunal application.
Before the tribunal.
So what was the ground on which the tribunal reversed the findings?
We are the owner mind the record of rights. So my record does not care, but it is my the recording that we are in till today. Position there is no dispute. Even the order would show.
A land reforms act didn't.
And my lord, apart from that, the title suit, there is no whisper in the title suit as well as the second appeal. Even
Title suit, how can they explain the title suit about the second?
because we are challenged the order of vesting also on this appeal, in this title suit. We also challenged the did
No. The tribunal held that you have lost the suit. That is one of the reasons.
no, I have suit was decreed in my favor. They preferred an appeal.
That was allowed.
That was allow and set is the judgment degree of the trial court.
So the tribunal proceeded on the premise that their appeal was allowed and it was set aside.
Yes,
on that ground.
Yes, ma'am.
Therefore, it was held that you have no title.
Yes, ultimately. But
What is your ground in the score?
I prefer the second appeal. We put the.
May I place the facts? If your lordship allow.
Facts on what ground is challenging? We have to understand that.
The decision of the land tribunal.
Ground.
Two grounds, Your lordship has this. Ground number 2 and 4.
You don't know the grounds 2 and
Yes,
4.
Only patta holders had lands, excess limit of 1 acre at that time.
Why should you interfere with concurrent findings of both forums?
But
there has to be a reason.
But the appellate authority.
Oh no, this is not a concurrent finding. The tribunal interfere. Let us see the grounds given by the tribunal. Let us see.
Ground lordship will get from 180.
Okay.
No.
Internal affairs 6.
2 and
187. Thank you. 187.
Now, internal affairs 6, where he quotes 20A. There are
nine
187.
8 থেকে 84 that's 8
Start with 186.
184
No.
187, page 187, and thereafter 180.
Only one. Accepted হয়নি
না গ্র্যাজুয়েশন কি দাঁড়াও না
अब किच्छु नहीं
হ্যাঁ
होगा सेटिंग
to only one point. On one point that at the time of grant of patta, they were within ceiling limits. So what is
But my lord, at the time of
right
the
decision?
but your lordship can also consider the my lord order of the computer appellate authority.
No. Do you deny that they at that point of time they had acquired land subsequent? At that point of time, when the pattas were granted, they were within the ceiling limit. Do you deny that?
Yes, my lord.
Have you the sale deed must have been produced?
Here,
sorry, pattas must have been produced, and the sale deeds by which they acquired the land, those were produced.
And my lord,
You produced.
no, he is appealing for the state, my lord.
No. I am for the.
He
private
cannot be
response.
appealing. Thakur doesn't have
Second
locus
question,
sanitary.
my lord.
Is appeals required.
I filed the title suit. The suit was decreed.
What is your challenge?
But only by 2 counts. The excess land.
Excess.
Yeah,
Tribunal has held that they did not have excess land.
But
why should you interfere?
But the competent appellate authority also can see the order.
They held wrongly.
Number 2, my lord, my submission will be another that my lord title suit as second appeal.
Title suit is not a factor here, even without title suit.
Second appeal also pending, my lord, for
Second
consideration.
appeal may be pending. You have lost.
When the second appeal is still
Your
pending,
title, first of all, your title that is on your locus standi. Your title, it has been held. You had no title.
For the better interest, my logically, my lord, after vacation, then my lord,
after vacation we will become wiser.
My lord,
why better for better what?
Deed of
better
sale.
change of determination.
No.
What will be better? What will become better?
Deed of sale and others, my lord, information with the land of the state under the estate acquisition act.
Let us see. Place the order of the lower two forums. The SDO and the DLLR. Either will do. DLLR show us.
DLLR.
Where is that? Give us the page number. Must have the page number written in your margin.
DLLR is at page 169.
169.
PLR.
DLLR.
PLR order start.
PLR. No. PLR. It will be decided by the SDO and appellate authority, my lord.
Appellate authority 169.
On
So section 49(4).
Second, yes, third. 23rd September, my lord.
Nothing. The dates have not been looked into at all.
Page 169. Page 100.
We have read 169, 167, 170. This point was the dates of the were not considered at all.
Neither by him nor by the bailiff.
Obviously, yes. And that was considered for the first time by the tribunal. The tribunal records specifically.
Internal page 9, last paragraph.
And my lord, SDO order, my lord. 157, my lord.
The deed numbers have been given by the tribunal, Mr. Bhattacharya, page 9. Last. Deeds are of 2012.
Well, we are directed.
Part was granted in 76, 77.
We are directed by the tribunal to
produce those deeds. Rightly.
And there is no embargo in the statute.
Subsequently, nothing.
The subsequent purchase cannot.
No embargo. No embargo. Absolutely.
That is why tribunal. It is not a bar. It is.
We are trying to understand the grounds of Mr. Bhattacharya till now.
My lord.
Grounds of challenge. One is your second step pending. How does that have a bearing in this?
But my lord, when suit was filed in the 1976. When the patta was issued.
Dismissing. The present challenge has been preferred against an order of the West Bengal Land Reforms and Tenancy Tribunal. Why the learned tribunal set aside the orders passed by the subdivisional officer and the appellate authority, the district land and reforms officer, annulling annulling the pattas, PATTAS, granted in favor of the private respondents. Push up next para, the learned tribunal, while reversing such annulment of pattas, observed that private respondents acquired property above the ceiling limit much after the grant of patta in their favor. Push up was further observed that the subsequent acquisition of property beyond ceiling limits has no manner of bearing on the earlier grant of patta, comma, at which juncture the land held by the patta holders were within the ceiling limits as prescribed in the statute. Full stop. Next para. Upon hearing learned counsel for parties, comma, including the state, comma, we find that there is no illegality in the order of the learned tribunal, comma, inasmuch as the tribunal rightly proceeded on the premise that at the point of time when the parties in question were granted in favor of the private respondents, comma, that is in the year 1976-77, comma, the private respondents held land well within the ceiling limits. Full stop. The subsequent acquisition of further property beyond the ceiling limits by the private respondent does not have any retrospective effect, comma, nullifying the pattas already granted in their favor, comma, whereby vested right had accrued in favor of the private respondent. Full stop. Next para. The appellant also seeks to argue that a suit for declaration of title filed by the appellant was initially decreed, but subsequently such decree was set aside by the first appellate court on an appeal being preferred by the state. Full stop. It is submitted that a second appeal is at present pending against the said judgment of the first appellate court. Full stop. Next para. Be that as it may, comma, as of date, comma, the title of the appellants, title of appellants যেখানে যেখানে বলেছি না সেখানে petitioners হয়ে যাবে. Title of the petitioners has not been established, while, comma, on the other hand, comma, the tribunal was justified in reversing the findings of both the authorities, that is the SDO, the TL and LRO, on the premise that the said authorities did not take into consideration that the dates of acquisition of property above ceiling limit by the private was much after patta was, comma, thereby having no material effect on the grant of patta. Full stop. In such view of the matter, comma, we do not find any reason to interfere with the impugned judgment of the tribunal. Accordingly, WPLRT 168 of 2025 is dismissed on contest, thereby affirming the judgment dated June 13, 2025, passed by the second bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA number 405/2022 within bracket LRTT. Full stop. There will be no extra cost. Next. Urgent certificate.
Item number 9.
Item number 9.
I'm
My lord,
late.
may I appear, my lord, online, my lord?
Yes,
I'm
absolutely.
seeking leave.
You're for the petitioner.
Petitioner, I'm led by Mr.
My lord, I am for the petitioner. My lord. Yes. My lord, in this matter, my lord, what has happened?
I have
My lord,
the-
we have, my lord, I have.
Petroleum Corporation. My lord, this is a very old brief, my lord. I could not trace it, my lord. Who is the Mr. Pushpendra Chakraborty is here. Advocate on record.
The advocate on record is also not being traced and the file is also not being traced. Or either or both.
Both. 2 days time I require.
Who is the advocate on record? Do you know who is the advocate on record?
I do not have any track, my lord, because 24.
Then we'll pass interim orders.
No, my lord, 1 day time, my lord, kindly.
1 day, we don't have 1 day time.
Well, because copy has also not been served upon.
My lord, I have some urgency, my lord. This is
long back must be. Yes, Mr. Dhar, what say? Mr. Basu has instruction.
My lord, we have served, my lord. My lord, this is on a petrol pump, 3 cafeterias being run. My lord, they are not authorized to run those.
Mr. Nilanjan Pal, Mr. Basu appeared, Mr. Malay Kumar Ghosh was there, Mr. Nilanjan Pal.
Yes.
So it's your chamber brief.
Yes.
I will showing Mr. Chakraborty.
Mr. Chakraborty has
instructed by HPCL to assist him, my lord, at this juncture, my lord. Since
Then he goes out of the picture, Mr. Chakraborty.
Yes,
he is not to blame.
only 1 day time, my lord.
Why? When was notice served? No notice was served.
I have not received this application, my lord. Original petition.
Twice
Dhar,
we
give,
have.
give a copy to Mr. Dhar, Mr. Bose, and we'll take it tomorrow. Let us come back. Let us have a comprehensive discussion. Mr. Basu, learned advocate, having instruction to appear on behalf of the respondent number 1, seeks a day's accommodation. Full stop. Next. It is also said that since the matter is quite old, Mr. Basu being able to trace out the copy of the application if served on him, his client. For the next para, learned counsel, the learned advocate and record for the petitioner is requested to serve a copy of the relevant paper to Mr. Basu during the course of the day. Push up, let the matter stand over till tomorrow. Please have all copies, and Mr. Basu will pay double the amount of photocopy charges. Just double. Yes. And the proceeds will be distributed among Mr. Chakraborty and you. Yes. Next.
Item number 10.
Just now, Mr. Chatterjee has served the affidavit few minutes ago.
Because yesterday there was
Every matter simply, Mr. Basu. He has not served, so it's your problem.
No, not problem.
Absolutely your problem. You are the common factor. Everybody last minute, last night.
I'm the victim of the circumstances. Incidental.
What circumstances? It's in mentality, Mr. Basu. And you love that.
Tomorrow
Enjoy your
Monday, I said that I'll affirm it on Tuesday.
You have served a copy?
Yes, because of it. To yesterday's presentation, I can get it affirmed.
Tomorrow we'll take it.
My lord.
Since a copy of the
but may I file?
Applications have been served on the respondent only today, let the matter stand adjourned till tomorrow to enable the respondent to
reply. Mine is by reply.
Since a copy of the application, since a copy of the reply has been served only today on the learned advocate for the respondent, to enable learned counsel for the respondent to actively contest the matter, let them stand adjourned till tomorrow. The affidavit reply filed today be kept on record. This is that matter suppressed all documents.
I found some more perjurious statements.
More perjury?
Because he has disclosed 10,000 in the affidavit. Now, after
but then this will flow in perjury only. We will never reach the main matter.
I'm not insisting that, but because documents have been disclosed, so I had liberty to find out more.
You have found further documents being suppressed?
50 lakhs was the balance in the disclosed documents, and it was 10,000 in the affidavit.
Rest has gone to his counsel. What can the poor do? Yes. Next.
Item number 11.
Yes.
11, I appear for the respondent, my lord.
Yes.
But suit for divorce has been dismissed, my lord. Yes, the petitioner has
dismissed.
Paid for stay of.
Stay of what? The will direct you to. He's appearing. So.
My lord can send it. My lord.
There is a scope.
Why? This
Stay of what? Divorce suit has been dismissed. Stay means the divorce suit would revive.
No, my lord.
Affidavit of service filed to be kept on record. Full stop. Since by the impugned judgment, the divorce suit of the husband was dismissed, there is no scope for grant of stay. Full stop. Accordingly, Can 2 of 2025 is dismissed on contest without orders to cost. Full stop. Next para. Since the arises out of a matrimonial, the same be sent to the High Court, Calcutta High Mediation Committee for the purpose of resolution of the disputes between the parties by way of mediation. Full stop. Liberty to the parties to mention the matter for inclusion in the list in the event mediation fails. Full stop. Next para. In the meantime, the appellant shall deposit special messenger costs for bringing the trial court records, and the trial court records shall be brought as a special messenger.
No, paper book has been made ready.
Paper book you have made?
Made it. Yes. Yes.
You have already filed paper book?
Yes.
Oh, in the meantime, let it go to mediation. If fails, you come back and we'll hear out.
Can there be a time limit for mediation?
There is a time limit, statutorily probably 60 days or something. So within that, if it fails, you come back. We have single bench.
My lord, may I be permitted to mention this review application that recalling I have.
My order.
My lord, recalling has been withdrawn. I am filing this review application.
Here.
Seeking lordship's leave to file it without certified copy. I have applied a certified
Leave is
copy.
gone. Leave is gone.
Grateful.
190. We'll keep it tomorrow as extension under the extension heading. এটা কালকে extension heading এ দিয়ে দেবেন তো 190 190 yes ঠিক আগে হবে
Item number.
What was the nature of the contempt alleged? File din. They're appearing.
This is basically my learned
My lord.
mentioned it yesterday for correction.
Yes, my lord.
Oh, correction.
My lord, if my lord comes to paragraph number
So
50.
this is the matter where the alleged contempts were appearing online on last Friday when I was not there. This is
My
not
lord,
that matter.
No, my lord. My lord, this matter was taken up last Thursday.
এটা কোন matter?
Those DBC matters,
My lord, yes.
Anandita. বলে না লাস্ট ফ্রাইডে যে হয়েছিল সেই যে
If my lord, if my lord comes to paragraph 17, my lord.
17 years.
My lord will find the respect of WPA numbers. My lord has mentioned several WPA numbers. My lord, in the third line, will find WPA 15590. My lord, this is my client, my lord. My lord has the same consumer from paragraph 20 onwards, my lord, where my lord has held that the injunction or the restriction of migration will not be pertaining to him because his dues already, his security deposit has well covered the dues of DVC.
They intend to, my lord, get their supply disconnected. So my lord had already observed. My lord will kindly delete this particular WP number, my lord, from paragraph 17.
My lord,
Paragraph
that
60, right.
and my lord, one more correction. My
Oh,
lord.
they're not required to be. They cannot be restricted.
Yes.
And my lord, if paragraph number 25.
25.
My lord, I am reading from the beginning. Keeping in view such facts at this juncture, no interim direction for payment is being passed on the writ petitioner number such and such. Since the writ petitioner has already applied for disconnection, the DVC would be at liberty, my lord. I have applied for migration. I have not applied for disconnection, my lord.
My lord, it has to be disconnected, my lord. Then only they can migrate.
My lord, my client's only apprehension is, my lord, based on this. My lord, by an email, my client had tentatively said that by end of
Unless
this
you're
month,
disconnected, how can you migrate? They have to. So far as they are concerned, you have to disconnect. You cannot apply for migration.
My lord, the difficulty is, my lord, the email I had given them that the tentative date for disconnection would be the 30th of this month, which I am not shifting. My lord, DVC had in turn written that you give me 2 days prior notice, I will do the needful.
Yes.
My lord, I am shifting by the end of October now. My apprehension is based on that email. If they disconnect line,
you have applied for disconnection, they may.
Why will they disconnect, my lord? If they are paying the, my lord, why will they disconnect, my lord?
My lord, then my lord will kindly remove
No,
that.
Not the same. It is rightly pointed out by learned counsel for the writ petitioner in WPA 15590 of 2022 that the said writ petitioner ought not to have appeared 17 of the judgment of this court.
My lord, of 18th September.
Thank you. Dated September 18, 2020. Full stop next para. Accordingly, let PA 15590 of paragraph 17 of the said order dated September 18, 2025, full sub next para, counsel for the said writ petitioner further submits that the writ petitioner apprehends that as the court has observed paragraph 25 of the said order that the writ petitioner has already applied for disconnection and DVC would be at liberty to disconnect the electricity supply of the petitioners subject to adjustment of total outstanding dues, and as the petitioner substantially wants to migrate to some other distribution company and prior to such migration, if the disconnection is effected, the writ petitioner will be in jeopardy, comma, the said observation in the order be altered. Learned counsel for the DVC submits that in the event the writ petitioner in WPA 15590 of 2022 goes on paying electricity charges regularly, comma, there is no question of such disconnection being effected unless the writ petitioner wants so. Push up in any event, comma, for any in any event, comma, the unless there is a disconnection of electricity of power supply by the DG, there would not be occasion for the writ petitioner to migrate stroke shift to some other distribution company. Push up hence, comma, the application had to be for disconnection in order for the writ petitioner to migrate to some other distribution company. Therefore, comma, I do not find any reason to alter the observations made in paragraph 25 of the said order. This order be deemed to be a part of the order dated September 18, 2025. Affidavit of service filed to be given.
The difficulty is, as per the supply code regulation, if there word is disconnection at the fault of the consumer, then 6 months I have to go on paying the demand charges.
You have applied for disconnection.
No, surrender. I have applied for surrender. If the language, I want to surrender my license.
There is no provision for surrender. You can ask for disconnection.
Disconnection can be the default of the
No, that is what was submitted and we recorded also.
But at the instance of the disconnection, the instance of the consumer, if my lord puts that word.
No, whatever it is.
Because if it is if they will disconnect, I have to go on paying the.
No, we have clearly recorded you have applied for protection and on that application they are entitled to. It's very clear from the.
Well, one line for my appearance.
Next.
Item number 3.
Yes.
This matter is appearing in my instance. This is extension of interim order.
You have applied for vacating.
I have applied for vacating. It's appearing today, my lord, in the list.
What is the nature? What is the nature of the challenge?
Should I place my case in?
Take up the vacating application. Constitute to be an objection to the. You have applied separately for extension or on the main application you have asked?
Main application because it is still
the main
subsisting.
stay application is still pending.
Yes, my lord.
What is that CAN number?
My lord. The CAN is filed by.
Oh, this is a civil division.
Yes, my lord.
Achha. Learned counsel appearing for the opposite party submits that the opposite party has filed a vacating application to the filed an application for vacating the interim order of stay granted on August 13, 2025. Who sub next on the other hand, comma, the revisionist petitioner seeks an extension of the interim order granted. Who sub next para. Since the issues involved in the vacating application will in the vacating application are identical with those involved in the revisional application itself, comma, let the revisional application be listed along with the vacating application immediately upon reopening of court after the upcoming annual vacation. Push up.
The only
order is till the end of September.
By way
the
of
interim order granted earlier is extended till November 30, 2025 or until further order, whichever is earlier.
only thing, by the interim order, execution proceedings has been stalled.
Yes, if the execution, then nothing remains.
The only thing, what
we'll
has
take
been
up on the reopening whenever the court reopens.
My lord, I'm
The
led
24th October. Yes.
Mr. Oyan Banerjee's name
Oyan Banerjee is in court.
is in court, my lord.
Give his name.
My lord, deeply obliged.
the only thing, if it can be given some precedence, because I have obtained an order, my lord.
No, but that will appear before the regular bench. Then these are assigned only for a limited.
But
no, yes, it's the assignment.
So only
before the regular bench.
My lord.
After reopening before the regular bench and limited interim order, so they have to pray for extension.
My lord, deeply obliged.
The only thing, my
execution cannot happen.
Probably a false statement has been made on the affidavit, my lord. That is the and it has been stated that a settlement.
Yes. Who is appearing in court?
I am appearing on behalf of the petitioner. The plaintiff opposite party.
You asked for repairing. Oh, inspection.
Yes, I am asking for inspection and local inspection on 151 Code of Civil Procedure for repairing of my medical.
Oh.
Well, what is happening?
Who is the suit for?
Suit for.
Who is appealing for the other side?
Well, I have served.
Good service?
Yes, yes.
File the affidavit of service?
Well,
is a suit for eviction?
Suit for eviction of licensing and position. The plaintiff opposite party instituted a suit against the petitioner.
For eviction of, in that you filed a repair application supporting application?
We have preferred an appeal. We have thereafter the
a degree was
granted in favor of the
in the appeal you took out a repair application.
Yes.
In support of that 39.7.
Order 39.7 and 151 application both we have filed, but court taken up the one order 39.7 first.
That was allowed.
That was allowed, but the 151
understood. That has
at
been
the time of appeal. Well, therefore, we will suffer irreparable loss and injury. At the time of appeal,
the report has come of the adjudicator. No, 39.7 was allowed.
We have challenged the said order. We have challenged the said order.
39.7 you have challenged.
Total order we have challenged.
Why 39.7?
And during the
you had applied for 39.7.
Well, I have applied for 39.7, but my purpose is if 151 application will not be hard, we will suffer irreparable loss injury, my lord.
Oh.
151 for repairing of my medical
Let me make my statement first, then you will say.
Fine.
They filed an eviction suit against you, eviction of licensee that was decreed, you preferred an appeal against that. In the appeal, you took out an application for repair of the premises.
Yes.
In support of that, you took out an Order 39 Rule 7 application.
Yes.
Order 39 Rule 7 was allowed,
yes.
thereby appointing an advocate commissioner for inspection.
Yes.
But repair was relegated to the hearing of the appeal, which you say is to your detriment. I am asking you whether, because your local inspection was allowed, my question was whether the commission has been completed and the report has been filed.
No, because we have already challenged the said order, that's why.
You are challenging yourself. You yourself got an order of local inspection. That also you are challenging.
Well, kindly.
Your application was allowed. How can you challenge that?
If 151 Code of Civil Procedure for repairing work was not done, my purpose is not served because the mediation shop I totally.
How can I penetrate an object which is as thick as a stone wall?
Well,
you are entitled to have the repair application.
Yes.
But why are you challenging the order portion of the order whereby your local inspection was allowed? You are also challenging that.
My lord, I am not.
It's a frivolous revision then.
I am not pressing this said. I'm not pressing.
This is absurd, sir. Absurd, ridiculous.
Well,
you preferred an application under Order 39 Rule 7. That portion also you are challenging.
Well, I'm not pressing that.
And you are advising your clients to do this.
Well, I'm only concerned with the repairing work. Kindly allow me.
Peculiar.
During the
I've never heard such an absurd proposition. Your application allowed, you are challenging that component also. Despite affidavit of service filed to the advocate commissioner filed a report. Has the inspection held?
Judgment has been already fixed by 25th September 2025. The learned trial court has fixed for judgment, my lord. That's why 25th September.
Why to answer a question straight, sir? Inspection was allowed. Has the inspection been held and a report filed?
No, my lord.
Yes or no? Despite service, none appears for opposite party at the time of call. Full stop. Next para. The plaintiff stroke opposite party filed an eviction suit on the ground that the appellant, that the revisionist petitioner stroke defendant is a licensee. Full stop. Such suit being decreed, an appeal was preferred against the same. Full stop. Next para. At this juncture, comma, the petitioner filed an application for repair of the suit premises under section 151 of the Code of Civil Procedure, comma, simultaneously with an application under Order 39 Rule 7 of the Code of Civil Procedure for holding a local inspection to ascertain condition of the premises. Full stop. Whereas, comma, by the impugned order, comma, the application for local inspection was allowed, comma, the repair application was directed to be heard along with the appeal. Full stop. Next para. The grievance of the revisionist petitioner is that unless the repair application is immediately decided, comma, the appeal, the revisionist petitioner would be in jeopardy due to the condition of the property. Push up next para. On hearing learned counsel for the petitioner, comma, it is evident that the petitioner cannot have a grievance with regard to the portion of the impugned order whereby the petitioner's own application for local inspection was allowed. Full stop. However, comma, it is well settled that unless all interlocutory applications are disposed of, comma, an appeal cannot be finally heard. Full stop. The only exception is application in the nature of production of additional evidence and or amendment of the pleadings, which might be required to be heard along with the main appeal. Full stop. Next para. Keeping in view such position of the law, comma, this court is of the opinion that the appellate judge ought to have decided the repair application first before going on to dispose of the appeal. Full stop. Next para. Accordingly, comma, 2076 of 2025 is disposed of by modifying the impugned order bearing order number dated May 21, 2025 to the limited extent that the learned additional district judge, comma, first Roman 2, comma, Bardwan, comma, District Purbo Bardhaman will take up for hearing and dispose of the repair application of the revisionist petitioner within 3 weeks from the date of communication of this order to the said court. Push up. Next para. Only upon disposal of the said repair application shall the learned additional district judge proceed to dispose of the appeal. Push up. No rest to cause certain certificates.
One indulgence with the execution case has already been proceeded.
Rightly. You cannot stall the execution proceeding. Your repair application will be heard within 3 weeks, but then the judgment will be passed.
Item number 5.
Yeah.
My lord, I would like to appear on behalf of the petitioner.
Copy served.
My lord, I have served. My lord, may I file my affidavit?
Good service.
My lord, pages
Yes.
6, 8, and 10
Only
of the affidavit. My lord, I have served.
Oh, yes.
Yes.
Yeah, what is your
I'm appearing for the respondent number.
consumer forum? Is it maintainable?
Yes.
Oh, against national?
Yes, yes.
Right.
My lord, impugned order is at page 399, my lord, at the end of volume 2. My lord, the impugned order, my lord, refused to condone a delay of 55 days, my lord, in filing the appeal.
Why?
My lord, the application for condonation of delay was not very well drafted. My lord, they did not mention the day, the number of days of delay, but my lord, there is no malafide or laches on the part of the petitioner, my lord. My lord, the case,
yes, what do you say?
We do not have any objection, my lord. I was the plot wherein this construction has.
Set aside this and direct the tribunal to give them an opportunity to file supplementary affidavit to that condonation application, and we'll frame a time limit for that.
Grateful.
Lordship, kindly record my submission that we have unnecessarily dragged into this litigation.
Very.
Well, they are the complainant.
No, I'm the owner of the land.
The owner. He is dragged by both sides. Affidavit of service will be kept on record. Full stop. Who is not appearing? Which party is not appearing?
My lord, the complainant is not appearing. That is 1 and 2, my lord.
Achha, despite service, comma, opposite party numbers 1 and 2, comma, that is the complainants before the Consumer Disputes Judicial Forum choose not to appear. Full stop. Next para, learned counsel appearing for the owner stroke opposite parties that the owners are unnecessarily dragged into litigation for a prolonged period. Full stop. Next para, by the impugned judgment, comma, the National Consumer Disputes Judicial Commission dismissed an application present petitioners for condonation of delay in preferring an appeal before the said commission. First of although the delay was merely of about 55 days, the tribunal, comma, upon quoting several judgments, comma, came to the conclusion that there was no reason to condone the delay which was not satisfactorily explained. Full stop. Next para. Apart from the quotation of judgments throughout the order, comma, we find that the reasoning is. It was observed by the tribunal that the application for condonation of delay was drafted in a casual manner, and even the number of days of delay was not mentioned. Full stop. Next para. Keeping in view the fact that the delay was only of 55 days, comma, the punishment meted out to the petitioner by dismissing the application disproportionate. Next para. In the event was of the opinion, the Congress was of the opinion that the delay was not satisfactorily explained, comma, the tribunal ought to have granted a further opportunity to the petitioners to file a supplementary affidavit, comma, thereby sufficiently explaining the reason for the delay. Instead of dismissing the condonation application outright, comma, taking a strict view of the matter, comma, contrary to the well-settled legal position that unless patent malafidis can be attributed to the petitioners, comma, a lenient view is taken in condonation of delay, comma, particularly when the number of days of delay is not much. Next para. Moreover, comma, the mentioning of the exact number of days of delay in the condonation application is not mandatory or a statutory requirement. What is needed is a satisfactory explanation for the period of delay. Next para. In such view of the matter, comma, the CO number 46 of 2024 is allowed, comma, thereby setting aside impugned order dated November 1, 2023, passed by the National Consumer Disputes Redressal Commission, comma, New Delhi, and and directing the commission to dispose of the condonation application of the petitioners afresh upon giving an opportunity to the petitioners to file a supplementary affidavit to the application for condonation of delay, comma, thereby furnishing further particulars as to the explanation of the delay in preferring the challenge. Next para. The National Commission will be at liberty to give a reasonable time-bound frame for filing of such supplementary affidavit and directing opposition, comma, if any, to be filed thereto by the respondents in the appeal. Next para. It is expected that upon granting such opportunity, comma, National Commission shall dispose of the condonation application as expeditiously as the business of the commission permits, comma, in accordance with law, comma, without being prejudiced in any manner by the observations made either by the court or by the commission in the order issued here. No address to cause or next.
Item number 6.
6 minute. I have
Yes.
6 minute. There is a caveat. I have served, but unfortunately,
No difficulty.
I shall make the affidavit of service. and come.
Great. Since the affidavit of service has not yet been prepared, comma, on the prayer of the learned advocate for the petitioner, the matter is adjourned for the day. Come back to.
Grateful.
Give your appearance, Mr. Whoever is appearing with you.
Item number 7.
My lord, may I be permitted, my lord, to appear virtually
Yes,
today?
yes, Mr. Das. What is the matter?
My lord, the point involved in this divisional application is that whether, my lord, a subdivisional magistrate under the Maintenance and Welfare of Parents and Senior Citizens Act has the right, my lord, to order and to pass an order of eviction. Now, my lord, kindly comes to the order impugned.
Supplementary affidavit reply, all of these have been filed. That was the last.
My lord, I do not require it. My lord, what they have done is they have merely annexed the medical documents, my lord, of the parents. Now, my lord, so far as, my lord, medical documents of the parents are concerned, my lord, perhaps, my lord, they won't be necessary. But kindly seize the order impugned for once. But I am only agreed with that portion of the order, my lord, in which the subdivisional magistrate has directed.
Or the other
My lord,
side.
we are the sons and the daughter-in-law. My lord, the parents.
Where is the impugned order? Which
My lord, kindly comes to the my lord, revisional application, my lord, the last page of the revisional application.
yes, right. Foolish question. It should be in the my question was foolish.
Lordship.
No, don't agree to that. Yes, let us see.
My lord, kindly sees the order. Both the parties are directed to keep peace and tranquility at their home, and I abide by that. Considering the medical ground, the opposite parties are directed to leave the house after delivery of the baby. In the meantime, they will not involve in any kind of quarrel. The case is disposed of. And my
Baby
lord,
has been delivered, quote
yes,
unquote.
my lord, it has been delivered.
So leave the house.
But kind of but I'm questioning the jurisdiction of the SDF, my lord, to pass this order. But my learned junior sister is there, my lord. She has a copy of an order, my lord, passed by your lordships, in which, my lord, your lordships have held that, my lord, perhaps the SDM does not have any authority.
Even without any order, it does not.
My lord, kindly sees their prayer in the petition. My lord, they did not claim for any maintenance. Only, my lord, relief sought was for eviction of the son. My lord, the order, my lord, if your lordship, my lord, kindly sees the hearing portion. During hearing, it was known to that the petitioner
No,
and the opposite party.
the parents, Mr. Das, are also residing in the same premises.
Yes. My lord, we reside in different floors.
At the time of call, none appears for the opposite parties. Full stop next para. Although a previous leave was granted to the petitioner to file supplementary affidavit, no such learned counsel for the petitioner submits that supplementary affidavit is not required and the petitioners want to proceed with the revisional application as it is. Full stop next para. The limited context of challenge in the present matter is to an order dated June 2, 2022 passed by the subdivisional magistrate, that is subdivisional officer, under the provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, 2007. Full stop. Learned counsel for the petitioners point out that the petitioners that the opposite parties stroke parents, in their application before the tribunal. What is the page number of the prayer, Mr. Das?
My lord, kindly comes to
page.
My lord, kindly comes to
Yes, I've got it.
yes, page 39.
39. A suit is also pending. Suit is also pending.
Yes, there are suits pending by and between the parties, my lord. It's a suit for declaration and injunction over a sweetmeat shop, my lord, in which the father and the son are joint owners. The wife is enjoying
You have
an
filed the
order, my
suit.
lord.
You filed the suit.
Yes, my lord, I have filed the suit.
You have an injunction there? No.
No, my lord, there is no order of injunction there.
Page 39.
My lord, kindly comes to the petition, my lord, which has been filed. My lord, kindly comes to
What is the prayer of their petition?
The lordship gives me a minute, my lord, I shall take out the pen.
কি বললাম মেঘনাথ কোন কন্ডিশন একটু বলুন asked for manifold reliefs. Full stop. The learned tribunal, by the order, without assigning any reasons at all, directed the parties not only directed the parties to keep peace and tranquility at their home, but also directed the present petition to leave the disputed house delivery of a baby, double inverted মধ্যে delivery of a baby, double inverted.
But it is page 34. My lord, the application made by the my lord, petition.
Yes, I got it. Delivery of the baby of the parties. Full stop next para. A perusal of the prayers made in the application for the tribunal shows that inter alia, injunction was sought against the present petitioners from repeating certain alleged acts against applicants of opposite parties, or eviction of the present petitioners or exclusion of the present petitioners from the shared household or any part of it, as well as injunction restraining the present petitioners from dispossessing the applicant opposite parties from the shared household. To subpara, the impugned order suffers from several discrepancies. First, the same is absolutely devoid of reason. Full stop. Next para, the learned tribunal merely recorded the submissions of the parties in the cryptic impugned order of half a page and without assigning any reason whatsoever, directed the present petitioners to leave house without any finding as to the veracity of the case of the opposite parties and stroke or adverting to the pleadings of the parties and of the materials, if any, produced before the tribunal. Moreover, the tribunal, under the 2007 Act, in particular under section 20, does not have the authority to pass an eviction decree outright. Next para, seen in the limited context of the jurisdiction of the tribunal, the impugned order cannot be sustained. Next para, the tribunal also took into consideration the pendency of a civil suit filed by the present petitioners for declaration of title and consequential reliefs against the opposite parties. Next para, in such view of the matter, the impugned order cannot be sustained. Accordingly, CO number 116 of 2024 is allowed in part, thereby setting aside the impugned order dated June 2, 2022, passed by the subdivisional officer within bracket subdivisional magistrate, Kollani, Nodia, closed, in the capacity of the tribunal under the 2007 Act, and directing the tribunal to re-hear the application before it by the present opposite parties afresh upon giving adequate opportunity hearing to both the parties and dispose of the same with a proper reasoned order, upon adverting to all the materials on records and the pleadings of the parties. It is expected that such exercise shall be concluded as expeditiously as the business of the tribunal permits, preferably within February 28, 2026. No rest to cause.
Grateful.
If any, stand vacated.
Grateful, my lord.
Thank you.
Item number 8.
For the petitioner, my lord. Only,
Yes, please. What is the matter?
Only 1 day accommodation.
What is the matter about? What have you challenged?
Lord, the brief, my lord. Only give me a short.
Bring the brief. I'm passing it over.
My lord.
Pass over. Come quickly. Will not wait indefinitely. এটা কোথা থেকে এলো? এটা না আগেরটা? এটা আগেরটাই দিয়েছিল, এর আগেরটা। Yes, করুন।
Item number 9.
For the petitioner, my lord.
Yes, Mr. Das.
Even as the petitioner before lordship, suit for licensee.
Is appearing for the first time?
Yes, my lord.
No caveat.
No caveat.
Yes, what?
Earlier occasion, my lord, these plaintiffs, that is the opposite parties, purchase the plot of land or accommodation.
Take the microphone a bit closer. Purchase the plot of land, yes.
With some structures thereon. Now, before their purchase, their owners filed a similar suit of eviction against these present petitioners in the year 1993. That is
Sorry, please repeat that. Opposite parties purchased the property
from the vendors, and
Yes.
their vendors filed a similar suit against the petitioners, saying them their licensee. That has been rejected.
That was dismissed.
And these subsequent purchasers
No appeal preferred.
no appeal paper.
The previous degree
Yes, my lord.
dismissed.
Now, these present vendors, opposite parties, that is subsequent purchasers,
Again filed on the ground that you were a licensee.
Yes, my lord.
That was dismissed for default or on merits? The previous
On merit.
holding that you are not a licensee, or what was the finding?
Yes, I'm not a licensee.
What are you then?
I'm a co-sharer. Therefore, I filed a suit for co-share.
Held by the previous court.
No, previous court dismissed their first suit, saying that I am not a licensee. On the point.
Have you got a copy of the judgment? What happened then?
The point. I have a copy of the judgment.
Don't have a copy of the judgment?
No, my lord.
That is very crucial, Mr. Das, you know.
That I'm saying, my lord.
The findings there will govern you here. So what?
Therefore, my second suit has filed his objection on the point of res judicata. That when the first suit has been dismissed on the same point, I am not a court.
There cannot be any application under section 11. Either it has to be taken as a preliminary issue.
My lord.
Will directly dispose of the writ petition and what has been done?
Rejected, my lord. When the first parties and in the first suit, parties in the first suit and parties in the second suit are not same. And second one, my lord, I have not submitted the copy of the said disorder in the first suit.
How can the parties be same?
Yes. Parties may not be same.
But without hearing them, we cannot.
Lordship. But at the same time, my lord.
We'll do this, Mr. I'll not interfere with this.
Lordship.
I'll not interfere with this. But I'll say that these observations are this will not affect and direct the trial court to frame a preliminary issue and decide this issue first. The present revisional application has been filed by the defendant in a suit for eviction of licensee against an order whereby the petitioner's application, purportedly under section 11 of the Code of Civil Procedure, was dismissed. Learned counsel for the defendant's petitioners argues that the vendor of the present opposite parties had previously filed a suit for eviction against the petitioners on the allegation that the petitioners are licensees. Such suit having been dismissed, was such suit was dismissed, which was never challenged before any forum. Thus, the said dismissal attained finality. Next para. Subsequently, the opposite parties, upon purchasing the property from the said vendors, again instituted the present suit for eviction of the petitioners, also on the ground that the petitioners are licensees. It is argued that the barred by the principle of res judicata in view of the opposite parties having stepped into the shoes of their vendors, who had filed the previous suit, which was dismissed, and thus are barred by res judicata from instituting a fresh suit on the self-same cause of action. Next para. It is undoubtedly true that in the event the defendants or petitioners are able to show to the court that the vendors of the opposite parties had filed a similar suit and where it had been adjudicated that the petitioners are not licensees, the said decision will be binding on the present opposite parties as well. However, the court is of the opinion that an application in the nature of one under section 11 of the Code of Civil Procedure is not maintainable as such. Next para. Thus, although this court does not agree fully with the of the learned trial judge, the conclusion was justified. Next para. The appropriate procedure to be adopted by the learned trial judge is to frame an issue on the question of judicature. You have raised that issue in your written statement. comma, if taken in the written statement filed or to be filed by the present petitioners, full stop. Next para. Accordingly, CO number 142 of 2024 is disposed of without interfering with the impugned order, but directing the learned trial judge to frame a preliminary issue as to whether the present suit is barred by the res judicata in view of a previous suit filed by the opposite party having been dismissed with the finding that the present petitioners are not licensees in respect of the suit. Such issue shall be decided first by the learned trial judge before proceeding to decide the other issues. However, comma, the framing of the preliminary issue as directed above shall be subject to the issue of res judicata and stroke or maintainability, comma, in whatever form, comma, having been raised by the defendant's petitioners in their written statement in the suit. Next para. In the event such issue is framed and decided, comma, none of the observations made in the impugned order shall be considered to be binding on the learned trial judge at such stage or any further stage of the suit. Full stop. It will be deemed that the observations made in the impugned order were only tentative in nature and not conclusive in any manner, conclusive or binding on the parties in any manner whatsoever. Full stop. No rest to cost. Unless keeping it pending would not help the other side also.
Item number 10.
10. Yes, Mr. Ventus, you are for the petition. Who is for the petitioner? You. Yes.
I'm for the petitioner. One thing, 2nd of June. 2nd of July, sir.
Again, no notice was given.
No, my lord. The appearance, if my lord will have any, the.
Oh,
that's
the matter is released on my personal ground in view of one of my relatives having appeared for one of the parties in the matter. Thank you. Yes. That's why Mr. Manto is very confident. Next. Release on person. After line add kudin, let the matter be listed before the. In any event, this is not the regular.
Item number 11.
Lordship, item number 11, Mrs. Snigdha Shah is appearing.
Mr.
Item number 11, Mrs. Snigdha Shah is appearing on behalf of the petitioner.
You are also of her chamber?
My lord. She is in hospital because of her mother's operation. That is why, my lord, kindly make it after vacation, if possible.
On the prayer of the petitioner, let the matter stand adjourned till after the vacation.
Deeply obliged, your lordship.
Item number 12.
Give your appearance. Yes. 12, who is appearing? You are there?
I am for the petitioner.
Yes. No caveat.
It was already filed and an order was passed by His Lordship, Honorable Justice Biswajit.
Achha.
Thereafter, here is the affidavit of service, my lord.
By Justice Biswajit Basu?
Yes, my
lord. Only one order is there in the record. Justice Raja Basu Chaudhuri. This is CO 342?
Yes. 342, my lord.
CO 342?
Yes.
Oh. What is your CO number?
342, my lord. 2024, it was passed. Justice Biswajit Basu.
এরকম ভাবে ঢুকে আছে, এরকম ভাবে বিচ্ছিরি ভাবে বাঁধা রয়েছে। আগে থেকে অর্ডার সবসময় একসঙ্গে থাকবে, এগুলো তো আপনারা তো দেখতে সবে ফাইল।
Yes, madam. For a limited period till the end.
Served on the other side. Where is your service? Good service.
Yes.
They have received.
Yes.
What is the matter? Tell us.
Matter relates to the.
Take the microphone. Yes.
The plaintiff sued in the trial court or declaration and injunction. The property is a walk-up property as per section.
Why is this can filed?
Can probably they have filed and vacating interim order.
We are taking out the main matter. Yes. Yes. Sorry. Please repeat. What is the matter about?
The suit for declaration and injunction. Thereafter, The matter was
They filed a suit for declaration injunction.
Yes, my
Right.
and
They filed 26 Rule 9.
26 Rule 9.
Allowed, against that you have come up saying that it is fishing out.
Yes, my lord.
What is the pair in the suit and what is the pair in the local investigation? Show us these two things and it will be over.
Lordship, kindly see page 19.
Page 20 is the prayer portion.
Page 20. Page 20.
They seek a declaration of the title. Yes. সম্পূর্ণ মসজিদ
আর্জি বর্ণিত হেতু বাদে নালিশি সম্পত্তিতে বাদীগণের সত্য সাব্যস্ত মতে তাহাতে বিবাদী পক্ষের কোনরূপ রাইট টাইটেল ইন্টারেস্ট না থাকা অধিকারণে নালিশি সম্পত্তি
মসজিদ. Yes. Now let us see the. We have seen it. I have seen it.
This is a work of property, mother. Section 85.
Show us the points of local investigation now. Their application for local investigation.
Page 35. Page 31.
Mr. Mukherjee, you are also appearing.
Mr. Mukherjee,
No, whatever.
Points of local.
Challenge the order allowing that application.
35, my lord.
35.
Page 35.
Allowing. Despite service none appears for the opposite party, the affidavit is filed today be kept on record. Full stop. Next para. The matter arises out of a suit for declaration of title of the plaintiff stroke opposite parties and for declaration that the defendant stroke do not have any title, right title or interest in the suit property, as well as that the suit property comprises of a mosque and under the control of a mosque committee, and that the Muslim public, the Mohammedan public in the area have the right to use the said property, comma, and for consequential relief of injunction and other reliefs and other ancillary reliefs. Full stop. In such a suit, comma, an application was filed by the plaintiffs opposite parties under Order 26, Rule 9 of the Code of Civil Procedure, seeking for a local investigation inter alia for comparing the suit property with CS map, comma, for survey and relay of the property and preparation of a case map, as well as for identification of the property claimed by the plaintiffs within the suit property. Full stop. Next para. By the impugned order, comma, the learned allowed the same mechanically, comma, on the alleged ground that the same was required for proper adjudication and to decide the suit. Full stop. Next para. However, comma, in the absence of any specific, did you take any objection as to identity of the property?
Identity of the property.
Oh, then why is it not necessary?
Lordship, kindly, the section 85 of the suit for declaration in work of property is not maintainable, my lord.
That is a different proposition, but local investigation, what does it have to do with it? Where is your written statement? Have you filed a written statement?
File করেছে?
No, no,
Written statement was not filed, man.
then you have not yet challenged.
File করেনি তো?
No, no, not filed.
Is not filed, my lord.
কি কোনখানটা ছাড়লাম? However, no, no. Challenge to the identity of the suit property, comma, since the defendant's petitioners submit that they have not yet filed any written statement in the suit and challenge the maintainability of the same before the civil court, there could not have been any option for the court to direct local investigation in a suit in the nature of a declaratory, in a suit for declaratory reliefs. Full stop, next para. Thus, comma, the learned trial judge acted without jurisdiction, granting local investigation substantially for the purpose of fishing out evidence, comma, which is not permissible in law. Full stop, next para. Accordingly, number 342 of 2024 is allowed, comma, thereby setting aside the impugned order bearing order number 22 dated December 5, 2023, passed by the learned civil judge, junior division, second court at Rampurhat, district Birbhum, in title suit number, title case.
Title suit number 130 of 20.
30 of 1920.
No, in the order sheet it is written case.
1022.
Yes, in the order sheet it is title case. That is why you are. Anyway, title suit number 130/22. Full stop, next para. It is made clear that the question of maintainability of the suit is kept open for being decided by the learned trial judge if such objection is raised by the defendant stroke petitioner before the trial court. No arrest to cause certain certificate.
I'm grateful to you, Lord.
Thank you very much. Acha, can 124 is stands disposed of consequentially. Next.
Item number 13.
Lordship, in this matter, I am for the petitioner.
Yes, Mr. Banerjee, use the microphone.
Lordship, this is the first time appearing here.
First time. The challenge?
I am challenging the order of the consumer dispute, consumer. Now, no, Lordship, kindly see.
National Forum.
Lordship, I am coming to that. Your Lordship, I am the decree holder.
You're challenging an order of the National Forum.
No, Your Lordship, I'm coming to that. Your Lordship, you kindly take up number
Yes.
37. That's why I am coming, Your Lordship.
37, yes, I have come.
Lordship. Your Lordship, this is the order of
The
the
total order. This is the total order.
No, Your Lordship, this is the order wherein the National Forum has directed me to approach the appropriate forum.
No, this is the total order which you are challenging.
No, I am challenging the last order, Your Lordship, that is the last annexure of Your Lordships, that is on 28th March 2023.
You had challenged what order before the National
28th
Commission?
National Commission, I have challenged the 28th March 2023.
Which you are challenging?
Yes, Your Lordship.
28.
2023. What's happening in this matter, Your Lordship? I have made an agreement with the promoter, Your Lordship.
State Forum is the appropriate forum.
State Forum has already rejected, Your Lordship. Kindly see.
This is District Forum.
Lordship, kindly see page number 34.
28th March is not State Forum, it is
No.
District Forum.
Page number 34. After State Forum, I went to the National Forum. State Forum says, no, this is not an applicable one, so we will not interfere it. Challenging that, I went to the National Forum. National Forum said that you should approach the appropriate forum. Lordship, only thing is that while passing the decree,
give us half a minute.
Lordship.
got a copy of the Act, Consumer Forum?
No, sorry, I do not have.
This is not a regular quote on this Act. So
Lordship, I do not have this right now.
we will serve copies and come back.
Lordship.
What is the main order of the district forum?
Main order of the district forum is that which I am challenging, Your Lordship.
Yes.
While passing the original decree,
Execution proceeding was levied. We have seen that the respondents preferred an appeal.
Loss Protection Act is there.
Thank you. Thank you.
And
Thank you. Yes.
Thank you. While passing the order final decree,
Yes.
the premises number has been wrongly recorded. Instead of 9 by B by 1, it has been written as 9 by D by 1.
So who sought a correction? You?
I sought a correction, and while the in the execution, that has been rejected.
And what was the other thing? Check something?
Check
Demand draft?
The order was that I have to deposit the balance amount I have to pay the balance amount to the developer. The developer will sign. So I have deposited the amount with the court, with the forum.
Yes.
That has been, I have paid for revalidate.
The present revisional application has been preferred against an order passed by the District Consumer Disputes Redressal Commission, Howrah. The petitioner, the petitioners obtained an award from the district forum, which was challenged by the opposite parties in an appeal, unsuccessfully. Thereafter, the petitioners levied execution of the said award, in connection with which, the petitioners sought for a rectification in the particulars of the subject property, subject premises. Another application was filed by the petitioners in connection with the execution proceeding for revalidating the demand draft which had been deposited by them in terms of the orders of the tribunal. Both applications were rejected by the tribunal apparently by unnecessarily citing irrelevant proverbs and beating about the bush. Next para. Thus, prima facie case for hearing of the revisional application has been made out, inasmuch as the District Consumer Forum, in the impugned order did not advert to the and the context of the applications of the petitioners while rejecting the same. Next para, it may be recorded here. Previously, a challenge had been preferred against the self-same impugned order before the station, which was dismissed on the ground that an appeal under Section 27 capital A of the Consumer Protection Act 1986 is maintainable, which was further challenged before the National Commission, which also dismissed the appeal by granting leave to the petitioners to approach the appropriate forum, prompting the present revisional application to be filed. Thus, the revisional application is written and shall be heard on the above questions. The petitioner shall serve copies of the copies CO 360 of 2024 on the opposite, indicating that the matter shall be listed in the monthly list of November 2025 before the regular bench having determination. There is an interim order. Your application rejected.
Absolutely.
No, thank you. Yes.
Item number 14.
Thank you.
My application.
Yes. What is the matter?
This is arising out of an order 7.
No caveat for the first time.
Actually, for the first time, caveat is there. We have served it on the other side. Affidavit of service.
Caveat.
Praying for short passover.
You do the matter. Yes. What is the matter?
This is an application under.
You are led by whom?
Mr. Animesh Pal.
Mr. Animesh?
Paul.
He's coming.
Yes, my lord.
So let him come. In the meantime, yes.
This is an arising out of a rejection of an application under Order 7, Rule 11. The property is hit under Section 4 of the Benami Property Act. Lordship, the suit is for a declaration that one brother is the owner of the suit when the deed is in the name of another brother.
Why was it? But there is a protection regarding
Yes,
within
it's not.
family,
Yes, it's not within the exceptions.
not within this.
It's not
So
within the
how
exceptions.
did the trial court proceed?
Chip will kindly come to the order.
Let us senior. You have a apparently you have a good case. So let us senior come. I'll pass it. Yes. একটা ম্যাটার পাস হয়েছিল না আগে পাস করে সেটা বলটা
Item number 8.
Yes, move your matter. Studied. What is the matter about?
I am
This is কি করছেন? Yes.
I'm the defendant wife petitioner, my lord. My husband, as plaintiff, my lord, filed a title suit for nullity of marriage. My lord, I filed written objection.
Written statement.
Sorry, my lord, written statement.
You take the microphone. You are Mr.
Samrat Chakraborty.
Samrat Chakraborty. Yes, Mr. Chakraborty. Continue. So you filed a written statement there.
My lord, I filed written statement. My lord, then, my lord, the petitioner, the plaintiff filed an application under section 63, 65A, 65B, 66 of Indian Evidence Act. My lord,
You filed those.
no, my lord,
They
filed.
they wanted to produce any electronic evidence.
Yes, my lord.
What sort of electronic evidence? Emails.
Emails, my lord.
WhatsApp must be.
Emails, my lord,
Emails, very
sent by Canadian High Commission, my lord. That email was sent to my email ID, my lord, but
Other side, not your side.
my lord, that email was sent to my lord my email ID. I admit that, my lord.
You admitted.
I admitted, my lord.
Right.
By to my email ID, but my lord, the option I filed, my lord, I stated there that my email ID was handled by my husband for that purpose, my lord. For that was regarding my for issuance of my visa, so that I can go to Canada with him. And my lord, the impugned.
What was the significance of those? Those emails will show what?
So will show, according to them, those email will show that the marriage was not solemnized properly. Something was there. my
Your
lord.
admission, sort of.
Kind of, my lord. They have.
You say they had control over your email ID. So therefore, it was their mechanism. They are doing.
Yes, my lord.
That you have to independently prove in the suit. How can that be a defense to their seeking to those electronic evidence? Let them prove this proof is on a different footing. You admit that those emails were sent from your ID, but
to my ID.
Sorry, to your email ID, but you say it's in control of your email ID.
Yes, my
At that point of time.
Yes, my lord.
You prove that you have to prove that independently who was in control. But that evidence they are entitled to being on record.
I admit, my lord, but kindly, my lord, come to page number. It is not page.
Yes.
Examination was not, my lord, properly.
You have denied
In
the
impugned-
integrity.
My lord.
You have denied the integrity.
Yes, my lord.
Or something like that. Now let us see the impugned order.
My lord, in the impugned order, my lord.
In the humble view of this court, let's start from there. Second last page. That is the opinion of the court.
Yes, my lord. My lord, kindly, my lord, before that also.
Acha, very well. Yes.
That page, my lord, second paragraph, last portion.
Right.
My lord, moreover, the counsel for the defendant pointed out that, my lord, got it?
Got it, yes.
My lord. Moreover, the counsel for the defendant pointed out that the plaintiff, while deposing PW1, has stated on doc and admitted that since he works at Canada, he applied for various authority for issuance of visa for taking defendant over there. My lord, that procedures was doing by him only.
Then you have a good case in the suit as
My
regards
lord.
the evidentiary value of those evidences. There are two aspects of evidence. One is evidentiary value. You know that.
Yes.
So this is on admissibility, 65B and all these things.
Yes.
So let it be admitted, but the evidentiary value will be kept open to be read in the context of other evidence which may be adduced.
As my lord.
Yes, Mr. Shamal, will not
Actually,
interfere.
that because that is the purport of section 65B, upon compliance of
Precisely.
all the formalities.
You are only trying
Initially,
to
my
comply with the
application-
formality.
My application was rejected because letter of interrogation to produce those
Yeah,
documents.
that is also cited by them
Yes,
that
my lord.
previously it was rejected,
It
but
was
that was on a
rejected.
technical ground.
Because initially, prior to filing this application, we have to ask for those documents. That was not done. After rejection, we have.
Mr. Partha Pratim Rai, two things. One, first, that no, before first, Mr. Chakraborty argued very well, actually. That will be evident from my understanding of the matter, subject to what you say. 65B filed, allowed, you have challenged that. Your defense PW1 himself admitted he was told of your email ID and doing all the communications with Canadian High Commission.
Canada High Commission for the purpose of.
So you know the next sentence which is coming from you. You must be knowing that pertains to admissibility. Let it be admitted in evidence. 65B has nothing to do with your defense. You take that on basis of independent evidence, and he has his admission, your independent evidence that he was in control. Prove that evidentiary value I'll kept open to be read in the context of other evidence. 65B allowing, I mean, we cannot interfere with that. And I'll make it open, keep it open in my order that evidentiary value of that evidence will be dealt with by the trial court at the time of trial. The present challenge has been filed by the defendant stroke wife in a suit for divorce suit.
No, my lord, declaration that the marriage is
nullity.
In a suit for declaration that the marriage between the parties, two opposite parties,
No, my lord.
and others.
No, yes, Narayan State, wife Nimachandra State is the Narayan State, wife. Narayan State is the wife, mother, and the plaint, my lord. I can consider the plaint itself.
Between the parties. Next para.
Page 14, my lord, can you consider? It is, I cannot
parties.
say.
Next para. By the impugned order, comma, the learned trial judge allowed an application under section 60 capital B of the Indian Evidence Act filed by the plaintiff stroke opposite party number 1. Counsel for the petitioner contends that the plaintiff stroke opposite party number 1 himself in his evidence as 1, admitted that he was at Canada and applied before various authorities for issue of visa for taking the defendant stroke petitioner over there. Full stop. As such, it is argued that the plaintiff stroke opposite number 1 was in control over the email ID of the petitioner at the relevant point of time, and hence the electronic evidence sought to be produced by the opposite party number 1 has no evidentiary value. Full stop. Next para, learned counsel for the opposite party number 1 submits a previous application for similar was rejected on a technical ground due to non-production of certain prior paraphernalia, non-compliance of certain prior paraphernalia. Full stop. However, it is submitted that the learned trial judge was justified in permitting electronic evidence to be led upon production of appropriate certificate under capital B of the Indian Evidence Act. Full stop. Next para. Upon counsel for the parties, it is evident that by the impugned order, the learned trial judge allowed an application filed by the petitioner under sections 63, 65 capital A and 65 capital B of the Evidence Act, thereby permitting the plaintiff stroke opposite party number 1 to adduce electronic evidence with appropriate certificate in consonance with law. Full stop. By the same order, no substantive right of the petitioner has been infringed. Full stop. In any event, the previous dismissal of a similar application was on technical ground and could not stand in the way of the application being allowed by the impugned order. Full stop. Next para. Insofar as the production of a certificate under section 65 capital B is concerned, the same pertains to the admissibility of electronic evidence and does not touch upon the evidentiary value of such evidence, once brought on record. Full stop. Next para. Accordingly, there is no scope for interference. Hence, CO 126 of 2024 is allowed, is dismissed contest, thereby affirming the impugned order bearing order number 60 dated October 9, 2023, passed by the learned civil judge, bracketed junior division, first court at Krishnanagar, district Nadia, in title suit number 8 of, now it is pending where?
No, which is
Before the
Additional court. Acha na, but learned civil judge, junior division, additional court at Krishnanagar, district Nadia, in title suit number 8 of 2014. First of next para, however, it is made clear that it will be open to the parties to challenge the evidentiary of the open to the petitioner to challenge the evidentiary value of the electronic evidence sought to be brought on record by the plaintiff stroke opposite party number 1 at the time of hearing of the suit, and if so raised, such issue will be decided in accordance with law by the learned trial judge at the time of hearing of the suit by taking into account a conjoint reading of the entire evidence on record without being influenced in any manner by any of the observations made herein or in the impugned order.
one thing subject to this.
Certificate.
Now he has to tender those only for the marking of because I cannot raise
Yes.
But it is automatic and it is directed next for preemptory hearing. That is the one of the dispute, my lord. Unless those are tender, I cannot raise my objection.
So he must have proved the documents.
Yeah.
But only for the sections.
My lord, these issues totally subject to question. Under the guidance of court, in which the mark of a document does not prove the same matter, the said address to the defendant must be marked as an exhibit. So this document already marked. So
the document is tender. Witness.
It is marked as identification.
Because of the 65B.
Yes, that is why once
at juncture this application was made.
That is why
we will be getting a chance to cross-examine.
No, not only that. Mr. Rai, the document was to the witness. Only due to 65B it was. What else has to be again tendered and again?
No, it is formally marked exhibit as objection. That is the only thing while subject to question because it is recorded next date is for preemptory hearing.
Yes.
Because
it has to be marked as an exhibit.
Yes, then I have to cross-examine the witness on that score, my lord. It is
Examination is not completed yet.
That is what it is recorded as preemptory hearing. That is why.
That is the stage. Some documents are marked as exhibit. Some
Marked
documents are
exhibit
marked for identification.
Food for preemptory hearing, my lord, there is no scope for any.
It has been fixed for
cross-examination. That is what. If your lordship.
That includes cross-examination also. PH board, yes.
PH board,
not SDP, PH. PH is a stage where the cross-examination.
Examination will start. But great.
Next.
Only one thing that I can put on the basis of the documents.
It is needless to say, whenever you say needless to say, we say it's all the same. Needless to say, adequate opportunity will be given to the petitioner to cross-examine the witness of the opposite party number 1.
Yes. Yes.
Item number 15 with 6.
Yes.
For the petitioner, it's a very simple matter, my lord. All that I'm playing for, my lord, is an expeditious disposal, my lord.
Of the suit itself?
Yeah, no, my lord. Oh, I'll indicate to your lordship, my lord. I am the plaintiff. The defendant has come.
Eviction suit?
Yes, my lord.
What is pending?
7172.
The present application has been filed with an innocuous prayer for early disposal of the applications filed by the defendants opposite parties under section 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenants Act 1997 in the eviction suit initiated by the plaintiffs. Next para, in view of the innocuous nature of the prayer, service of notice on the opposite parties is dispensed with. CO 407 of 2024 is disposed of by requesting the learned civil judge, junior division.
With CO 409, if your lordship could pass a similar order,
you are in 409.
Both the matters.
I'll repeat it. Sure. 407 of 2024 by requesting the learned civil judge, junior division, 7th court. Yes, 7th court at Howrah, district Howrah, to dispose of the pending applications under section 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenants Act 1997 filed by the defendants parties in title suit number 397 of 2022 as expeditiously as possible, upon giving adequate opportunity to the plaintiffs stroke petitioners to file written objection, and upon hearing the party on the said action, comma, preferably within November 30, 2025. Full stop, next para, there will be no arrest to cost. Suit is different in the next one.
Yes, my lord. Two different suits, my lord, for eviction.
আচ্ছা, পরেরটা একই হবে, শুধু সিও নাম্বারটা হবে 409 of 2024 আর টাইটেল সুট নাম্বার 457 of 2022.
My lord, I've been told if my lord, this could be direct on the charge code as well, my lord. The court in charge.
In the event the regular presiding officer of the said court is not available, comma, it will be open to the petitioners to move the concerned learned district judge for allocation of the matter to a different, in which case the aforesaid request shall apply to the court in charge of the suits as well.
I'm grateful, my lord.
What is your name?
Shahadat Ali.
Yes. Next.
Needless to say, this is my first appearance, and today is the day I got my enrollment.
Congratulations.
Thank you so much, my lord.
Pass over item number 14.
Yes.
My application.
They're still not.
My lord, my senior is still on legs, my lord, kindly.
Affidavit of service filed today be kept on record. On the prayer of the opposite party, the matter is adjourned for the day. Please come back tomorrow. If tomorrow you pray for him, you have to come prepared. And if you're not there, we'll take up expertise. Or you. Yes.
Item number 17.
Give your appearance. 17, yes. Who is there?
17, I am for the opposite party, my lord. Can I be
Parthopratim
taken up
Rai's name is.
tomorrow, my lord?
Yes.
Tomorrow, because I missed the brief.
On the prayer of the opposite party, let them attest. Parties, let them attest and adjourn for the day. Mr. Chakraborty, you have a copy of the brief? Of this.
Yes, I have copy, but I believe, missed the brief now.
Yes. Next.
Item number 18.
None appears at the time of call. Let us then adjourn for the day.
Item number 19.
Thank you, Lordship. I beg to appear for the
Yes.
petitioner.
What is the matter?
Lordship, the only thing is that, your Lordship, I'm led by Mr. Shuddhasatya Banerjee.
Who you led by Mr.
Shuddhasatya Banerjee, my lord. He has some personal inconvenience today. Your Lordship, kindly takes it after vacation.
After vacation means.
So one.
I appeal for the opposite parties, my lords. I am led by learned senior counsel Mr. Honorable Chatterjee. My lords, in this matter, my lords, I don't want to stand in their way, but they have been delaying this matter, my lords, for the past 1 year, my lords. They don't have any.
I am also appearing, my lord, in this matter, my lord, for the petitioner.
You are also of the same opinion.
No, my lord. I'll indicate to your lordship. It's a very short matter, but one of the annexures are missing, my lord. I'll tell your lordship what the matter is about. The impugned order, my lord.
Stop wasting time if it is not taken up today. We'll take it up tomorrow.
No, your Lordship, one indulgence, because one of the annexure, which is the impugned application under section.
No, I'll explain it to your lordship, my lord.
You are for the. Oh, you are.
Yeah,
Yes.
My
Sorry.
lord,
Yes.
The application under section 34 was filed. It was dismissed for default. Thereafter, I preferred an application for restoration, which was dismissed by an order. Now that order
was under section 34.
For the Arbitration Act, my lord, was filed.
Yes.
That application was dismissed for default, and thereafter, my lord, I filed an application for restoration, which was dismissed. Now that is the impugned order before your lordship. Now the only annexure that is missing is with the section 34 application. If your lordship deems it relevant.
No. What was the reason for dismissing?
The reason for dismissing was latches of the petitioner. I'm sorry, my lord.
What was the delay?
Yes, my lords.
There was delay, but I'll explain that if your lordship is pleased to take up the matter, my lord, I'll just indicate.
Let us take it up. Take it up.
I'll just indicate, my lord.
Yes.
Today, your lordship will find the dismissal order, the dismissal order of the section 34 at page 100. My lord, only kindly notes the dates in these orders.
Yes.
Lord, the first dismissal order of the 34 was 2nd March 2021 during the COVID period.
Right.
My Lord, the application for restoration was filed along with the Section 5 on 3rd April 2023.
Right.
My Lord, which appears at page 94 and 106, the Section 5 and the main application.
All right. All right. All right.
So, my Lord, if your Lordship, I have also annexed the suo motu order of the Supreme Court appearing at page 101. If your Lordship will.
That order helps you till when? What is the last cut of date?
20th February 2022 and thereafter 3 months. I'll just indicate. Kindly, my Lord, takes page 101.
20th May 2022.
2022
Before
and
going
thereafter
into
3
the
months.
merits, my lords, perhaps my learned friend, my lords, would answer, my lords, how this civil revision is maintainable, my lords, against
No, I'll
34,
indicate.
my lords.
I'll indicate. If that is the point they want to take, my Lord, I'll try my best to satisfy your Lordship on that.
Yes, my lords.
But as I'm, my Lord.
No, answer that point also. Whether this is an application under section, this is an order under section 34.
This is not an order under section 34, my Lord. This is, there's a coordinate bench, my Lord. From the same court, an impugned order was filed at 227. It was impugned.
Provision, separate provision for restoration under the 96 Act. We don't think so.
No.
It has to be
913, my Lord. Order 9 rule, in the nature of Order 9 rule 13.
Yes, order 9 rule 13, right.
Yes. My Lord, so, my Lord, I'll place that relevant judgment for your Lordship when I'll just indicate the facts prior to that.
No. Indicate the facts.
Yes. Now, kindly takes the suo motu order, my Lord, appearing at page 101. Now, if your Lordship is pleased to take that order at page 101, kindly takes page 103.
Yes. Why are you placing the Supreme Court's order?
Just to show, my Lord, to what extent, what period of time.
No, it's all till approximately 20th of May 2022.
Yes, 28th of May 2022, my Lord. And the application I filed was in April 2023.
What was the delay for this reason for this 1 year delay?
My Lord, the person, this was the dispute was regarding a leave and license agreement to run a restaurant in a mall. Now, the main person, that is the brother of the person, the deponent, he had expired. He was the person looking after all the affairs. And he had expired due to COVID, and I had kept on insisting and asking my
what of the petitioner? What was the relationship?
The deponents, well, the petitioner is a company. Well, the main person looking after the business was the brother of the deponent, well, who has affirmed this affidavit. Well, he had died. He was
vis-a-vis the company. What was his designation?
I'm not too sure, but I'll indicate, my Lord, that is not the primary challenge. The order is expressly bad on the face of it. My Lord, your Lordship will kindly take the impugned order once.
Yes.
So, my Lord, the only thing, my Lord, I'm exempt till 28th May 2022, and the application was filed 3rd April 2023. If your Lordship is pleased to take the internal page 5 of the impugned order. That is the findings of the court. Kindly, my Lord, takes the 4th paragraph starting.
You have made allegations against the advocate also, several allegations.
No, just general allegations that it was not followed diligently.
Not that. It's recorded in page 2 that you are in constant touch with the advocate who at all times kept on assuring that the matter is.
Yes, but that was true.
No, not only that, the petitioner was at all material times kept under a false impression that the matter is being pursued diligently.
And subsequently, there was a change of advocates.
False pretext that effective steps are being taken to pursue the application. Anyway, let us come to page 5. Yes.
Yes, ma'am. Kindly takes page 5 of the order. The instant application, kindly takes paragraph number 4. The instant application along with section 5 was filed on 5th April 2023 with a delay of 763 days. Even assuming deducting the delay would come to 399 days post effect of the order.
Yes.
So, my Lord, this, first of all, my primary submission is, my Lord, this effect itself is less than a year. The delay that needs to be explained is less than a year.
Number of days is not material.
And, my Lord, there is this if your lordship takes the application itself, which appears at page 94 and page 106, I have.
Let us first complete the imping order. Yes.
Yes. It is submitted the entire, my lord, delay is attributed to the conduct of the learned counsel for which it got dismissed. On the other hand, the respondent submitted initially that the petitioner got an order of stay without the presence of the decree holder, but later Honorable High Court vacated the stay order as it failed the mandatory imposition of costs akin to 41(5) and directed to dispose the petition under 36 of the Arbitration Act within 15 days. But the petitioner never showed any interest, my lord, to complete the hearing under 36 as per imposed condition akin to 41(5). The petition under section
You had section 36. In that an order was passed.
The 36, my lord, was filed not in the commercial court, but it was filed in a court not having jurisdiction, which was at the Barasat Civil Court.
Yes, but you had filed that, and you had obtained an order of section 36 by them. Okay.
By them, yes.
No, section 36(2) stay was obtained by you from that court.
And section 36(2) was obtained by that court. Yes.
By you. There was a conditional
I
order.
have challenged.
But you did not comply with the condition.
No, there is no stay. There is no stay. The main contention, my lord, on the primary objection in section 34 is
this 36(2) was undertaken during the period when no section 5 was filed in the interregnum.
No, I'm not too sure about that, my lord. Whether the 36(2.
Apparent.
I'm not too sure about that. My lord, the only thing, my lord, if your lordship takes the rest of it, now that's the objection in 36, which I have filed also, and it got there's a separate 227 pending from the rejection of that objection. Is that the arbitrator appointed wasn't unilateral appointment. In the 34 also, my lord, that is.
We cannot go into the merits of that. Sorry, no.
Yes. Yes.
You explored your opportunity before the 36 court, and thereafter you came with this section 5.
No, my lord. The 34 was filed prior to the 36.
No. Filed prior to dismiss for default, and after dismissal for default, Mr. Chatterjee will lead you for the other side. No. You have a good case. Take it.
For a change.
Yes. For a change. No, but section 34 was dismissed for default. You kept mum over the matter, and throughout your what was your plea that your brother, the brother of the deponent, was?
I'll indicate, my lord. Can I indicate? May I be?
Just tell me, brother was sick or ill or something.
No, but brother had passed away. The main person. I'll indicate, my lord. It's from the petition itself. I have filed his death certificate also.
113. Volume 333. It is at page number 113, probably.
Thank you.
Yes.
Second of August 2021.
2021. Yes.
So how does
this, my lord, this is relevant because the person who was, my lord, at the hem of
No, right order. We are dismissing the division.
No, my lord, kindly gives me one more opportunity, my lord.
No opportunity. Sorry.
Gives me one more opportunity, my lord. I'll come back tomorrow.
No, don't come back.
Kindly gives me
Don't
one
come
more
back.
opportunity.
Come back tomorrow for a different matter. Sorry.
No, my lord, then kindly, my lord, allows me to exhaust my submissions, my lord, with regards to the merits of the application for restoration. Whether those.
No. Section 5 has been rejected. Why should I permit you to do?
Well, section 5, then I'll, my lord, only refer to the section 5 I had filed over there.
What are you addressing?
I'm sorry, my lord.
You've been addressing till now. You have been addressing that only.
No, but I have not taken your lordship to that application. I have not taken your lordship to that application. May I just place that application? Lord, it appears at page 94, my lord. Your lordship will only take page 94 once.
Yes. Yes. These have been narrated at length by the learned judge.
May I only place the relevant paragraphs?
Approach of the advocate.
No, my lord, may I only place a relevant paragraph as well as, my lord, one judgment of a coordinate bench, my lord.
Quickly cite the judgment. Judgment on what? Maintainability?
No, not on maintainability, my lord.
Cite it. Cite it.
It's Decon India Limited, my lord. May I just place the paragraphs first?
No, I've seen the paragraph. You are left aghast with the situation and all these things.
No, my lord. Paragraph 5, 6.
Paragraph 5 to 10 are the relevant paragraphs.
5 to 10 are the relevant paragraphs. And thereafter
Read
also, my
paragraph
lord,
5 to 10.
yes, thereafter also, my
During your
lord.
arguments.
And my lord, in my 227, my lord, I have explained it even
No,
further.
227 explanation is not acceptable. Post facto.
My lord, the judgment which I wanted to cite, my lord, was
1 minute for the judgment.
Kindly passes.
Yes, my lord.
Not
It's
carry.
Proposition of law.
no, on the proposition that the party, the litigant, should not be made to suffer, my lord. Also on 227, whether it's maintainable or not, the party should not be made to suffer, my lord, due to the latches of the learned counsel. That is, my lord. It was from the same court a 227 was filed. Now, this particular judgment, my lord, refers to a lot of Supreme Court judgments, and it has been
Judgment.
I'm sorry.
That's a coordinate bench judgment.
Coordinate bench judgment.
We'll accept that proposition and proceed on that basis. But dismiss your
Kindly keeps it tomorrow, my lord. Gives me one more opportunity.
Parties whose next the present challenge has been preferred against an order whereby the court, the learned judge, the learned trial dismissed an application for restoration of an application. Dismissed an application for condonation of delay in filing an application for restoration of a petition under section 34 of the Arbitration and Conciliation Act 1996, whose next para. The brief facts are that the section 34 application was rejected by the concerned court on March 2, 2021. Thereafter, an application for restoration was filed only on April 3, 2023, along with an application for condonation of delay in filing the same. Next para, learned counsel, petitioner seeks to place lines on the judgments passed, the different judgments passed by the different orders passed by the Supreme Court during the pandemic period, extending the time for extending the limitation period for filing all applications during the said it is subject that during the said period, the brother of the deponent in application for condonation of delay also met his demise. Next para, that apart, the petitioner had relied on the advocate of the petitioner in the court taking up the section 34 application. Despite being assured by such advocate that the matter was taken care of, the petitioner was left aghast, AGHAST, when it was discovered that the same had been dismissed for default much after. Next para, the learned judge, while dismissing the said application, disbelieved the ground taken in the application. It has also been recorded that the judgment debtor / petitioner has been deliberately keeping himself abstained from satisfying to comply with particular terms of the award. Next para, it was also recorded by the learned trial judge that in another case, being an execution case pending before the first court of civil judge senior division at Barasat, the petitioner had filed a put-up petition on February 10, 2022 and prayed for time to file written objection, and on March 25, 2022, filed another petition seeking time to file written objection. As such, it transpires, next para, it is argued with the petitioner that the petitioner relied on his advocate, and as such, it was beyond the control of the petitioner that delay was occasioned in taking out this restoration application. Next para, learned senior counsel appearing for the opposite parties preliminary objection as to maintainability of the application, since no appeal or application under Article 226/227 of the Constitution lie in respect of a proceeding under the 1996 Act. Full stop. Learned senior counsel also disputes the contentions of the revisionist petitioner on merits. Full stop. Next para. Insofar as the maintainability, insofar as the objection as to maintainability is concerned, comma, such point cannot be accepted. Full stop. On a conjoint reading of Section 5 of the Arbitration and Conciliation Act 1996 and Section 37 of the said Act, comma, it is evident that the legislative intent is to curb judicial intervention apart from the provisions as made in the 1996 Act. Full stop. Section 37 of the 1997 Act is the only appellate provision therein which does not provide for an appeal in connection with a rejection of a restoration application or a connected application for condonation of delay. Full stop. Next para. However, comma, since there is no specific provision within the four corners of the 1996 Act as to restoration of a dismissed restoration of an application under Section 34 of the said Act and or an application and or adjudicating on an application for condonation of delay in filing the same, comma, strictly speaking, comma, the impugned order does not come within the legislative regime envisaged under the 1996 Act, and the court, comma, a civil court within the contemplation of the 1996 Act, comma, taking up an application under Section 34, comma, has inherent power to consider an application for restoration and or an application for condonation of delay there. Thus, comma, there is no bar in the 1996 Act for judicial intervention on an application, rejecting an application for on an order rejecting an application for condonation of delay filing a restoration application. Full stop. Thus, comma, the revisional application is maintainable. Full stop. Next para. However, comma, a bare perusal of the ground taken by the revisionist petition in the restoration application and the connected application for condonation of delay indicates that the total blame of the delay has been cast on the learned advocate conducting the litigation at the relevant point of time on behalf of the petitioner. Full stop. Next, choicest adjectives have been used for such that there was including that there were latches on the part of the learned advocate and the petitioner was aghast upon coming to know of the negligence of the advocate. Full stop. The application for condonation of delay also states that the petitioner was shocked after finding that because of lackadaisical approach on the part of the advocate, comma, the dismissal for default of the Section 34 application took place. Full stop. Next para. However, comma, the petitioner has failed abjectly to substantiate such allegations by cogent material or evidence. Full stop. Next para. That apart, comma, there is nothing in the application for condonation of delay to indicate, to substantiate that the petitioner itself, comma, through its agents, comma, was diligent throughout the period in conducting its litigation. Full stop. Next para. The demise of the brother of the deponent in the application for condonation of delay took place on August 2, 2021, comma, during the thick of the pandemic period, and as such has no material bearing, comma, in view of the Supreme Court orders prolonging the time for filing applications coming to the aid of the petitioner in any event. Full stop. However, comma, such relaxation granted by the Supreme Court ended on May 20, 2022, and the prolonged delay of almost a year between the said date 2023, comma, when the restoration application was filed, comma, has not been satisfactorily explained at all. Next para, in such view of the learned counsel for the petitioner seeks to rely on the proposition of law that the litigant cannot be made to suffer for the laches of the advocate. Although such proposition, although there cannot be any quarrel with such proposition, comma, the said proposition does not come to the aid of the petitioner in view of the negligent conduct of the petitioner, which is evident from the explanations sought to be given in the condonation application itself, as in the present case. Full stop. Next para. Thus, comma, I do not find any illegality or jurisdictional error in the order in the impugned order, whereby the application for condonation of delay and consequentially the restoration application filed by the petition was dismissed. Full stop. Hence, comma, CO number 81 of 2024 is dismissed on contest, comma, thereby affirming order number 7 dated February 2, 2024, passed by the learned judge, comma, Commerce at Rajarat, District North 24, in miscellaneous case number 3/2023 within brackets C. Full stop. There will be no arrest to cause urgency.
On Indran's lordship, may I permitted to keep the judgment?
I've accepted that proposition.
Your lordship, your
He
lordship,
was imposed cost 5 lakhs by your lordship. This very point in the division bench with
Against advocate.
Same thing.
We will not get that back in this one. Yes.
excuse me.
Yes, quickly.
Your lordship, I would like to mention that there has been a CO pending. Is item number 217. My lord, there's a order of the lower court. If it's not heard today, all the matters here will
It's back end of the day.
My lord, no, my lord.
Sorry,
if
you should have mentioned in the morning.
my lord,
At 2 p.m.
If only my lord keeps it tomorrow.
No,
early.
mention tomorrow. This is not. Mention at 2 when I sit singly. 2.
Much
Give a notice to the other side that you will mention.
It's already served.
Mention tomorrow for being taken out of turn. Today you have not mentioned.
Absolutely.